Here we go. Now we got the microphones all warmed up. We're ready to go. IT, are we online and ready to roll? All right. Excellent. Well, welcome everybody. Thank you all for taking the time to be here today to discuss this important topic. We got a very full agenda, as many of you guys can see, and welcome everybody that's in the audience as well. Many of you will be presenting a little bit later. First, a couple things I wanted to point out is this is a paperless committee. As you all know, there aren't stacks of paper everywhere. You will be able to find all of today's testimony and presentations on the ks.legislature.org. Go to our special committee on civil asset forfeiture, and it is under agenda and minutes for today's date. So that's where you'll be able to find all the documents. They've been uploaded and ready to go. Also, as part of what was emailed out, our legislative research team updated a memo that they did a few years ago on civil asset forfeiture, which speaks to how the process works and a lot of very good information. We're grateful for them and the work that they've done to get that prepared for us. And so we're also going to have our revisers spend some time with us going over that and answering questions, because I really think as a committee it's incredibly important that we understand how the process works and that we're all comfortable and get our questions answered to make sure before we dig in a little bit further on potential changes. So with that in mind, am I missing anything already? Did I get everything covered? All right. Because without these people at the front table, I would not be able to keep it together. So I'm grateful for all of you guys being here, guys and gals being here as well. So we'll go ahead then and we'll get started with Natalie, our reviser, who's going to give us an overview on the civil asset forfeiture laws in Kansas and also the House Bill 2380 that was introduced and heard last year. Natalie.
Thank you, Mr. Chairman. In your packet of information that's on the website, you should have two memos from me. The first in the subject line says a review of the Kansas Standard Asset Seizure and Forfeiture Act. That's what we're going to go over first. And then the second one is a bill brief on House Bill 2380, which was a bill that was introduced last year related to civil asset forfeiture. And the bill is attached there. You might notice that neither one of these memos is particularly short, and I have a pretty short time to go over them. So I'm going to be fairly brief, but I can, of course, answer any specific questions you guys have. So we're going to start with the review of the Kansas Standard Asset Seizure and Forfeiture Act. The act can be found at KSA 60 4101 through 4127. That first statute just names the act, and the second statute provides useful definitions that are used throughout the act. KSA 60 4103 establishes jurisdiction and venue. The district court essentially has jurisdiction over all interest and property if that property is within the state at the time of filing. And a forfeiture proceeding can be brought in any county where any part of the property is found, or in the county where civil or criminal actions for the conduct giving rise to forfeiture would be able to be brought in court against that owner or interest holder. KSA 60 4104 provides the conduct and the offenses giving rise to forfeiture. You'll see there's a pretty long list there. I won't read that to you, but the key here, I think, is that that conduct can lead to forfeiture regardless of whether or not there's a prosecution related to that conduct or a conviction related to that conduct. So most of the things listed in that list are crimes, but there doesn't necessarily have to be a prosecution or a conviction in order for forfeiture proceedings to go forward. KSA 60 4105 describes the property that's subject to forfeiture. Again, there's a list there, but essentially it's most property. Real property can be subject to forfeiture under certain circumstances, and of course personal property can be subject to forfeiture. The one thing I would note there is that contraband is technically subject to forfeiture, but that's not required to go through all the forfeiture proceedings. Essentially, law enforcement officers can just seize that and not return it since it is contraband. KSA 604106 provides a list of circumstances under which property is exempt from forfeiture. Real property or conveyances can't be forfeited unless the conduct giving rise to forfeiture constitutes a felony. So if they are wanting to forfeit some type of real property, that list of conduct giving rise to forfeiture, it would have to be a felony violation of one of those offenses. Property is not subject to forfeiture if the owner did not know and could not have reasonably known of the act or omission that was giving rise to forfeiture. And they didn't act reasonably to prevent the conduct giving rise to forfeiture. Also, if an owner acquires property in good faith for value and was not knowingly taking part in an illegal transaction, then that property wouldn't be subject to forfeiture. Those are two of kind of the bigger exemptions. In making this determination of whether property is exempt from forfeiture, there's a list in the statute for things that the court is to consider. KSA 604107 outlines the process for seizing property. The court can issue a seizure warrant on an affidavit demonstrating probable cause exists for the forfeiture of the property. Property can also be seized without that process on probable cause if the law enforcement officer believes the property is subject to forfeiture. The seizing agency is required to make reasonable efforts to provide notice when they seize property. And once property is seized, the seizing agency is required to forward a written request for forfeiture to the county or district attorney, who can then accept or deny that request. If it's denied, the seizing agency has a few more options to try to get that forfeiture pursued. KSA 604108 governs management and preservation of seized property. Essentially, the seizing agency is required to kind of maintain that property during the course of the forfeiture proceeding. They're also required to conduct a written inventory and estimate the value of the property. Under certain circumstances, the court can order certain things to happen with that property during the course of the forfeiture proceeding. KSA 604109 outlines the procedure for commencing forfeiture proceedings. They're commenced by filing a notice of pending forfeiture or a judicial forfeiture action. If proceedings aren't initiated within 90 days, then the property is required to be released on request of the owner or interest holder. And then this is where a claimant can file for recognition of one of those exemptions that we talked about earlier, saying that the property is not subject to forfeiture. KSA 604110 provides the framework for recognizing exemptions. An owner or interest holder can file a claim within 60 days after that notice of a pending forfeiture. And those petitions for those claims cannot be filed after the actual forfeiture proceedings are commenced. So they have to be filed within that notice timeframe. KSA 604111 outlines the process for filing a claim. Only an owner or interest holder of property can file a claim, and that claim has to include the case information, a return address, the nature and the extent of the claimant's interest in the property, and a detailed description of when and how the claimant obtained that interest in the property. Those claims can also assert the right against self-incrimination in that claim. KSA 604112 covers the general process for judicial proceedings. The burden of proving an exemption is on the claimant, and the rules of civil procedure apply to all civil asset forfeiture proceedings. KSA 604113 addresses in rem proceedings. These are proceedings that are brought against property. So a lot of times in forfeiture, we'll see state versus $100,000 or state versus 2005 Chevy Corvette, something like that. Those are in rem proceedings. And so an answer to one of those filings has to be filed within 21 days after service of that in rem complaint. And then the plaintiff's attorney has the burden of proving the interest in the property is subject to forfeiture. That has to be done by a preponderance of the evidence. If the state proves that claim, then a claimant who's trying to file an exemption has the burden of showing that the claimant has an interest in the property that's not subject to forfeiture. They also have to prove that by a preponderance of the evidence. If the plaintiff's attorney fails to meet their burden, or if the claimant is successful in showing that the property is not subject to forfeiture, then the court must order the interest in the property returned. KSA 604114 governs in personam proceedings. These are proceedings over people, so the court has a jurisdiction over that person. In these cases, the court can issue a temporary restraining order if the plaintiff's attorney demonstrates that there's probable cause to believe that the property involved would be subject to forfeiture and that providing notice to the person might jeopardize the availability of the property. The court shall enter judgment of forfeiture on a determination of liability of a person for that conduct giving rise to forfeiture. So in this case, the court's actually making a determination about the person involved here, not just the property involved. An owner or interest holder can file a claim if not otherwise precluded. If that seizing agency doesn't recognize the exemption, then the plaintiff's attorney shall file a complaint in court, and the court would hold a hearing to determine that claim. The court can amend the order of forfeiture based on that determination at that time. KSA 604115 relates to substituted assets. Under certain circumstances, the court can order the forfeiture of other property up to the value of that original property that's subject to forfeiture. And this is only the case in personam proceedings, not in rem proceedings. KSA 604116 provides for the judicial disposition of property after resolution of all claims and exemptions, and after a determination that the property is subject to forfeiture. The court can enter an order that the seizing agency has clear title to that property now going forward. KSA 604117 describes how the law enforcement agency can use forfeited property or the proceeds from the sale. There's a list there. Again, I won't read that to you, but then the statute goes on to provide how the proceeds of that sale should be distributed. KSA 604118 details the powers of the personnel enforcing the act. A county attorney, district attorney, the attorney general, or one of their designees can conduct an investigation of alleged conduct that would be in violation of the act. KSA 604119 authorizes immunity orders. KSA 604120 is the statute of limitations. All actions under the act have to be brought within 5 years of that last conduct giving rise to forfeiture. KSA 4121 provides that controlled substances are contraband and can be summarily forfeited. KSA 604122 prohibits a person claiming interest in the property subject to forfeiture from commencing or maintaining an action against the seizing agency. KSA 604123 provides that the provisions of the act shall be liberally construed. KSA 604124 provides for uniform application of the act. KSA 604125 provides for severability if one portion of the act is held invalid. And KSA 604126 requires the act to be codified in the Code of Civil Procedure, and it also applies the rules of evidence to the act. The newest statute in the act, KSA 604127, creates the Kansas Asset Seizure for Forfeiture Repository. It requires reporting by certain law enforcement agencies. So now the KBI is required to set up that repository and gather information from each of the seizing agencies on each forfeiture made. The repository is on the Bureau's website. Each agency is required to report certain information concerning each seizure to the repository, and then the prosecuting attorney shall submit information from there into the seizing agency, who then is required to report that back to the repository as well. Each law enforcement agency is also required to submit a forfeiture fund report each year. And then the Bureau is required to determine whether that agency's financial report matches the substantive forfeiture report. So all that information is available online. So that's kind of a general overview of the act. I'll stop there and see if there's questions.
Thank you, Natalie. I have a couple of questions here, and then we'll go to the members. Back at 604107, which I believe is on page 3 of the memo, you talk specifically about the county attorney. It goes to the county attorney first, or the district attorney, who shall accept or deny. If denied, the agency makes a request to the state law enforcement agency, including the AG, to adopt it. May also request federal seizure. Isn't there another step in there where a private attorney can be involved in this process and take over those forfeiture proceedings?
Yes, so the county or district attorney can engage a private attorney as well to go through those. And we actually had a bill, a few years ago related to that process that I think passed. So let me find that for you and I can send that out to the committee.
Is that at the request of the district attorney, or is it at the request of law enforcement? And if you don't know, could you find that answer?
Yes, yeah, sorry, I should have brought my statute book up here at the same time, but yeah, I can double check that.
No problem. Thank you. Does the standard, the appeal process for civil asset forfeiture follow a standard civil appeal process? Or what is that mechanism for appeal?
To my knowledge, it would just follow the normal civil process. I know that you're hearing later today from a lot of people who actually handle these in court, so they may be able to kind of answer some of those questions a little bit better. But there's nothing in the act that specifically outlines that. So I think they just follow the normal appeals process.
Makes sense. And then my final question, 4127. This is the latest one that has the reporting requirement. Mm-hmm. Is there any mechanism in there, because as I reviewed, and we will review this report a little bit later, we have a couple of agencies and or counties that are just choosing not to report. Is there any mechanism within that statute to encourage, force, penalize, anything like that to ensure we have accurate reporting?
Yeah, so the KBI, in that requirement where they review the financial report against the seizure report, there are some kind of enforcement, I would call them light enforcement mechanisms, though. I mean, really, they just notify agencies that they're not in compliance. They kind of keep reminding the agencies that they're not in compliance. I would have to look to get the specific details, but there's not too much enforcement there for being in violation.
All right. Thank you, Natalie. Committee questions for Natalie. Senator Warren.
Thank you, Mr. Chair, and thank you, Ms. Scott, for your presentation today. A couple questions. First, the Kansas Standard Asset Seizure and Forfeiture Act was created in 1994, right?
That sounds about right.
I'm just looking at the statute.
Yeah.
I have the advantage I get to pull it up.
Yeah.
Okay, so almost 30 years then. And if you could explain for those following along online or in the committee meeting room, you said that the burden of proof on the state or the taking entity is a preponderance of the evidence. Could you explain that versus beyond a reasonable doubt, kind of the difference in standards there?
Sure. So a preponderance of the evidence essentially just means that it's more likely than not. So you have, there's a 51% chance that the property involved here is subject to forfeiture. Whereas beyond a reasonable doubt has to be, that's a very high bar. It's the highest bar. And that's what's used in criminal proceedings if there's a criminal conviction. So there is a standard in between called clear and convincing that's kind of partway between a preponderance of the evidence and beyond a reasonable doubt. And I think actually House Bill 2380 proposed to change that to a clear and convincing standard. So we'll get into that in a little bit.
Thank you. And a couple more, if I may, Mr. Chair. Thank you. Ms. Scott, you talked about the statute, the process talks about plaintiff's attorney. Plaintiff's attorney in civil asset forfeiture is the state?
Yes.
So the plaintiff in civil asset forfeiture is the state, correct?
Yes.
Okay. And then is there a situation in this process that a person could be found guilty of a criminal charge related to the conduct giving rise to the civil forfeiture, but then be found not liable, excuse me, be found not guilty on the criminal charge, but civilly be found to have, with the preponderance of the evidence, the state would be able to keep your private property. Do I have that right?
Yeah, absolutely. The two proceedings are kind of distinct. So the criminal proceeding is going on against that person. It's my understanding actually that most asset forfeiture proceedings are in rem. So they're going to be state versus this piece of property, not necessarily against a person. And I think oftentimes the criminal defendant may not even engage in that civil proceeding. That's not necessarily required.
And so if you do engage in the civil asset process, civil asset forfeiture process, you as the defendant in the civil procedure, you're defending a piece of property and showing that the piece of property wasn't engaged in the conduct giving rise to the seizure. Is that how the process kind of works?
Yes, if it's an in rem proceeding. So you would file a claim saying, kind of setting forth why that property is not subject to forfeiture. So you would try to be saying that it's not involved in the conduct giving rise to forfeiture. It wasn't purchased with proceeds related to the conduct giving rise to forfeiture. That's kind of the argument that you'd be making.
So you'd be defending a vehicle or a
Yes.
lump sum of cash. And regarding the proceeds from the seizure, is it correct that in the civil process that we have the statute you just talked about, that there's no, it's not property that's then turned over to the governing body of the police department or the county sheriff, or if we have KHP seizing it, to then reappropriate the money back, or any kind of, I guess, checks and balances I'm looking for?
So essentially, those proceeds go back to the law enforcement agency. If you look at that statute, which is KSA 604117, when you're talking about the proceeds of the sale, they first go to satisfying any security interest or lien against the property. Then they go to expenses for the forfeiture proceeding, reasonable attorney fees, and then repayment of law enforcement funds if any purchasing of like controlled substances or contraband happened during the investigation. And then the remaining proceeds are credited to that law enforcement agency's forfeiture fund. And that's what they're required to report to the KBI about.
Right, but report it, but not turn it over to a elected body or anything,
No,
right?
it stays in their forfeiture fund.
And if I may, one last question, Mr. Chair, thank you. Finally, when we heard about the statutes of limitation, or the statute of limitations to conduct a civil asset seizure and forfeiture, it was 5 years. Is that sometimes a longer statute of limitation than some of the underlying crime statutes?
It could
For some.
be. Yes, it's possible that it could be. Yeah.
So the statute might have run on prosecuting for the crime, but not on the civil asset seizure
Yes.
aspect of it. Okay. Well, thank you. That clears up a lot of questions I have about the process. Thank you. Thank you, Mr. Chair.
Certainly, committee additional questions. I think Senator Haley would like you to repeat everything that you, no, I'm just kidding. Welcome, Senator Haley.
Thank you, Mr.
Absolutely. Final question then on this topic. How was this handled prior to 94 then, when the civil asset forfeiture hearing, granted, I know that's a minute back. Do you know anything about that mechanism beforehand?
I have no idea. I would have to do some research about that.
Okay, very good. All right, Senator Wilbur.
Thank you, Mr. Chair, and thank you, Natalie, for your presentation. I may have missed it, but a few years ago, we passed some legislation requiring a reporting of what's occurred over time. Did you mention that? If you did, I missed it.
Yeah, that is the very last statute that we talked about, KSA 604127. That's the statute that requires the KBI to set up a repository online that the law enforcement agencies then report information about each seizure for forfeiture that happens, the outcome of that case, and then they're also required to report how much money that they're getting from forfeiture proceedings.
Thank you. To follow up on that, would it be advantageous to this body here if they all had a copy of that, or at least, I guess we could access it online?
You can. I think you're actually getting a report about that repository maybe right after me, actually. I don't know.
Okay.
At 10 o'clock, we have Jessica Crowder will be sharing that repository data with us.
Thank you.
Certainly. Additional questions, committee? All right, seeing none, Natalie, let's go ahead and move on to 2380, which are the bill that was introduced last year that had some proposed changes.
Yes, so House Bill 2380 was introduced last year. It went through the House Judiciary Committee. It stayed in House Judiciary Committee, and then the chair at the time, Chairman Patton, referred that bill to the Judicial Council, and so that's the report that you're going to hear about today. That bill would have required a criminal conviction for civil asset forfeiture to take place. It would remit proceeds from civil asset forfeiture to the state general fund instead of staying with law enforcement agencies, increase the burden of proof required to forfeit property, make certain property ineligible for forfeiture, provide persons involved in forfeiture proceedings representation by counsel and the ability to demand a jury trial, and it would allow a person to request a hearing on whether forfeiture is excessive or not. So I'll go through kind of each of those changes. Section 1 would amend KSA 604104. That's the statute that provides that list of conduct giving rise to forfeiture. And that section is amended to provide that that conduct only gives rise to forfeiture after a conviction of that related offense. A criminal conviction would not be required when property is forfeited pursuant to a plea agreement or an agreement for a grant of immunity. Section 2 amends KSA 604105. That's the statute that provides what property is subject to forfeiture. So that section provides that cash or negotiable instruments less than $1,000 would be exempt from forfeiture. Property other than cash or negotiable instruments with a market value of less than $2,500, and property owned by a person who's not convicted of that offense that was giving rise to forfeiture. Section 3 amends KSA 604106, the statute providing for exemptions, and that is essentially just amended to comply with the conviction requirement that's changed up above. Section 4 amends KSA 604107. That's the statute that provides the seizure requirements. So the section is amended to require a seizing law enforcement agency to forward a request for forfeiture to the county or district attorney within 14 days instead of the current law requirement, which is 45 days. If that county or district attorney declines that request and the seizing agency doesn't request adoption or engage an attorney to represent the agency, then that property has to be returned to the person within 30 days, which I guess that answers actually Representative Owen's question. Is the law enforcement agency can be the one to engage an attorney. The thing I can't remember is whether the county or district attorney can also engage private counsel to handle those for them. So I'll look at that for you. This section is also amended to provide that no law enforcement agency can request federal adoption under the Act, and to add a new subsection providing that when property is seized for forfeiture, the seizing agency shall not request or induce any person who asserts ownership to waive their interest in the property until the forfeiture proceedings are commenced. Section 5 amends KSA 604109. That's the statute that governs commencement of the proceedings, again, just to conform with the new conviction requirement. Section 6 amends KSA 604112. That's the judicial proceedings statute. A new subsection H would be added there to provide that following the seizure, the person from whom the property was seized can petition the court to determine whether the forfeiture was unconstitutionally excessive. The plaintiff's attorney has the burden of establishing that the forfeiture is proportional to the seriousness of the offense, and that would have to be done beyond a reasonable doubt. The bill provides a list of factors that the court would consider when making that determination. It also provides that an owner interest holder shall be entitled to the assistance of counsel, and if they can't afford to retain counsel, then the court would be required to appoint an attorney for them. In a proceeding where an owner interest holder prevails by recovering at least half of their property, then the court would be required to order the seizing agency to pay reasonable costs and attorney fees with interest in that case. An owner interest holder would also have the right to appeal an order under the Act. Section 7 amends KSA 604113, which governs in rem proceedings. This section is amended to allow claimants to demand a jury trial and provide claimants with the assistance of counsel. Again, if the person can't retain counsel, one would be appointed for them. This section also requires the plaintiff's attorney to prove that interest is subject to forfeiture beyond a reasonable doubt instead of a preponderance of the evidence. Finally, the claimant shall be assessed a fee for storage or any other fee related to the property. Section 8 amends KSA 604114, which governs in personam proceedings. That section is amended to provide that persons with a known interest would again get that assistance of counsel, could be appointed if they can't afford one. If no determination of liability is made under that section, then the property that was seized has to be returned to the person within 7 days. An interest holder can demand a jury trial in those in personam proceedings as well. Section 9 amends KSA 604117. That's the disposition statute. Current law allows transfer of that property to a federal agency. This bill would allow transfer of the property to a federal agency when the property was seized under federal law only. It also provides that all seized cash and negotiable instruments and any proceeds would be remitted to the state general fund. And then finally, Section 10 amends KSA 604127. That's the repository statute. It's amended to conform with the conviction requirement again. And then current law also requires reporting of how law enforcement agencies spend those proceeds. But now that the money would be going to the state general fund, those reporting requirements would be removed. And I can take any questions.
Thank you, Natalie. Questions, committee? Oh, seeing no questions on that one. Thank you very much, Natalie. Mm-hmm. All right, committee. Now we have Tim Anderson, who's the Director of Communications from the Council of State Governments online, who is going to present to us some of the recent changes to forfeiture laws in other states. So, Tim, thanks for joining us and welcome to the committee.
Representative Owens, thank you so much. Thanks to everyone. Can everyone hear me okay?
We sure can.
Oh, wonderful. So thanks again on behalf of the Council of State Governments. Thank you for inviting me to take part in this hearing, and thanks to all of you too for your public service. I'm sure there are some familiar faces to me in the room, and many of you also undoubtedly know some of my colleagues at CSG. And that includes Laura Cleaver, who visits Topeka every year as our CSG Midwest staff liaison to the state of Kansas. Laura also conducted some of our initial CSG research for you on recent laws and legislative activity, which is going to focus on the Midwest and some of the changes to the laws in the Midwest on civil asset forfeiture. That includes a table that Laura put together and that I believe has been distributed to you in advance of the meeting. Unfortunately, Laura could not join us, but this presentation builds off on a lot of the work she did. So what I plan to do today is just try to take you on a tour of the Midwest, to look at the laws enacted in other Midwestern state legislatures over the past 5 or 10 years. Come together, these laws have changed civil asset forfeiture in many ways, and they also really reflect recent trends in state legislatures across the country. Two, in listening to Natalie's presentation, a lot of these proposals that have become law in other states are part of the the bill that you considered this past year in Kansas. But before I dive into the state-by-state overview on civil asset forfeiture, I just want to briefly remind you about CSG and what we do. Noah, if you could advance the slide, that'd be great. CSG is a region-based, nonpartisan organization serving all three branches of state government and the elected and appointed officials in it. Our mission is to promote excellence in state government, and you see a list there of some of the things we try to do in promoting that excellence. Noah, you can go to the next slide. This is the map of the 4 CSG regions. We are, again, a region-based organization. I'm from the CSG Midwest office, which includes Kansas. And my presentation will focus on legislative actions taken in your fellow states of the CSG Midwest region. Noah, you can go to the next slide. CSG provides staff support for several regional groups of state legislators, including the Midwestern Legislative Conference. Every legislator in Kansas and in every state of the CSG Midwest region is a member of the Midwestern Legislative Conference. Next slide, Noah. And as you can see here, those are the states of the CSG's Midwestern Legislative Conference. It also includes participation by neighboring Canadian provinces. Next slide, Noah. So before I move ahead with this tour of the Midwest and some detail on these recently enacted laws, I thought it might help to provide a little context and go through a few terms. If anything, this has helped me better understand some of the recent state actions, and also the previous presentation by Natalie really helped define some of these terms as well. But first to note, every state in the Midwest has indeed changed its laws on civil asset forfeiture within the last decade, often in fairly significant ways. In my research of these recent legislative actions, here are some of the central questions that some of the lawmakers in your other states of the Midwest have been asking and trying to address. 1, should our state allow for civil asset forfeiture by the government? To a large extent, the answer to this point has been yes, with one exception being Nebraska, and we'll talk about Nebraska in just a little bit. 2, should our state change the standard or burden of proof for assets to be forfeited? Many of the recent changes in our state, in the Midwestern states, have indeed raised the bar in terms of the standard of proof in civil asset forfeiture proceedings. 3, does the civil asset forfeiture process need to be changed in order to ensure due process rights? That has been kind of a common theme in some of the new laws being passed in the Midwest. Should the process be changed for innocent property owners in forfeiture proceedings? And when we talk about innocent property owners, we're essentially talking in cases where there's maybe a third party that owns the property that was not involved in the underlying criminal, but has had his or her property seized. And what is the process for those innocent property owners to make sure that that property is not forfeited and that that property is returned to the innocent property owner? And on this question, one trend of note has been some states shifting the burden of proof in proceedings from the property owner to the government. And so in other words, the government is given the burden of proof to show that the property owner knew of the criminal offense, criminal activity, or should have known. Another question, should more reporting and public disclosure be required of law enforcement? You did this in Kansas, as we just heard about, and this has been a very common theme across all these new laws in the Midwestern states: more reporting, more public disclosure. And then should the state define or change how proceeds from civil asset forfeiture actions can be used? Sounds like that's one of the proposals in this legislation introduced in Kansas, and that has certainly been up for debate. And we'll talk a little bit about Wisconsin and how it dramatically changed how proceeds from civil asset forfeiture can be used. So let's just go over just a few common terms, I think, that we've seen in these recent legislative debates. I think it helps to just frame some of these state actions that we're seeing. So first, regarding civil asset forfeiture, it's a process that is independent of criminal prosecution. It involves the government filing a civil action against the property, not the individual. So the property is on trial. Property because it's related or suspected of being related to criminal activity. So under civil asset forfeiture, property may be seized and ultimately forfeited, minus a criminal charge or conviction of a person. Forfeiture laws do vary quite a bit by state, but each law generally allows the government to keep seized cash and property and ultimately to sell or keep the proceeds from those sales. And because civil asset forfeiture is independent of criminal prosecution, the standard of proof is different and can vary from state to state. So on the slide here, we show the kind of 4 standards of proof. You have the probable cause, which is the lowest standard, the 4 standards listed on the slide. Next, we heard a little bit earlier about preponderance of evidence, and that the standard here is satisfied if there is a greater than 50% chance that the proposition is true. One of the more common changes by states has been to raise the standard in civil asset forfeiture from preponderance of evidence to a standard of clear and convincing, a higher standard. This generally means that the evidence must be highly and substantially more probably to be true than not. That's clear and convincing. And again, a big trend we're seeing in some of our states is a move to clear and convincing instead of preponderance of evidence. And then the highest standard of proof is, of course, beyond reasonable doubt, which we required of criminal convictions. Lastly, I just want to make note of this term innocent owner defense with regard to civil asset forfeiture proceedings and state laws. An innocent owner is generally a person who owned the property but had no knowledge that the property was being used or connected to illegal activity. States have varying processes in place for these innocent or third-party owners to get their property back after it has been seized by the government. Under a few of the new laws that we're going to see in the Midwest, legislatures have switched the burden of proof for the innocent owner away from the innocent owner and to the government. So in other words, the government has to show that the owner of the property does not have a claim to being an innocent owner. So let's go to this now review of recent laws and legislative trends in the Midwest with that context in place. I'm going to take on this tour of recent legislative actions in other states of the Midwest region. And for each state, I'll list the bill number, the year that the legislation passed, and give a little context on the legislative vote. You'll see in this state-by-state overview that many of the final measures passed by wide margins in the legislatures, often with unanimous or with near unanimous votes. For each state, too, I'll provide an overview of some of the major provisions. And so we'll go from Illinois to Wisconsin, and we'll start with Illinois and what it did. Illinois House Bill 303 was passed in 2017, and I have broken it down into its major provisions into 3 main sections. First, that law from 2017 raised the standard regarding the government's burden of proof to show property can be subject to forfeiture. The standard is now preponderance of evidence. It had been only probable cause in Illinois. Under that law, too, the standard is set higher at that clear and convincing standard for a forfeiture when the related criminal case results in acquittal or a non-indictment. Second major part of the law, there were several changes made to the forfeiture process in Illinois, and I list some of those out on the slide here, but I would point out a few particular things. First, under the new law, forfeiture is not allowed in criminal offenses involving small amounts of drug possession. In addition, small sums of cash are now exempt from forfeiture. Second, changes in Illinois statutory language now place the burden of proof on the government in forfeiture proceedings. It must show that the property owner is, quote, legally accountable or should have, quote, reasonably known about criminal conduct. And then in separate innocent owner hearings, the property owner must demonstrate his or her innocence by a preponderance of the evidence. The third change in Illinois is something we'll see repeatedly in almost all the states of the Midwest in the new laws, to require more reporting by law enforcement agencies. And just going back to something Representative Owens asked earlier about kind of how you enforce these new reporting requirements, I will point out in Illinois that there is a provision that says the state may withhold money from agencies that do not comply with the reporting requirements. Okay, no, we can go to Indiana now. So Indiana's most recent change in the law came in 2018 with the passage of Senate Bill 99. Part of the goal of legislators in this new law was to more clearly define the civil asset forfeiture process, set clearer guidelines and deadlines in statute, and expedite proceedings. For example, the legislature established a procedure for the owner of real property to obtain at least provisional custody of any seized property pending a final forfeiture determination. Also, prosecutors must file a forfeiture action within 21 days of receiving a demand for return from the owner, or within 90 days if no demand is made. Additionally, Indiana does now have new reporting requirements. Prosecutors must report the information to a statewide council of prosecutors And then that statewide council passes on the findings to the legislature. Lastly, Senate Bill 99 in Indiana outlines how funds from seized assets can be used by the government. First, those funds must be used to pay any outside counsel, which can be employed by Indiana prosecutors in forfeiture cases. Then most of the remaining funds go to a state general fund, the general fund of the law enforcement unit that conducted the asset seizure, or a county law enforcement drug task force fund. Any remaining funds, a small amount, will go into the Indiana's Common School Fund. No, we can go to Iowa now. Iowa's Senate 446 was passed in 2017 and was a fairly comprehensive change in that state's civil asset forfeiture process. You'll see all those changes broken down into 3 different categories, but I want to point out a few of the more noteworthy changes in Iowa. First, in some cases, a criminal conviction is now required before any property related to the alleged offense can be subject to forfeiture. This criminal conviction requirement applies to property valued at under $5,000. Second, in Iowa, in cases where this criminal conviction requirement does not apply, the legislature raised the standard of proof up to that clear and convincing evidence standard. This standard must be met in connecting property to criminal activity and making it subject to forfeiture. Third, the burden of proof in Iowa has shifted from the innocent owner to the government. Under this law, the government must now show by clear and convincing evidence that the property can be forfeited by showing that the innocent owner exemption does not apply. In other words, that the property owner knew or should have known of the criminal activity. Fourth, I want to point out that that law established what's called a proportionality review of the forfeiture. And so the goal of this provision is the law is to allow the judiciary to review and ensure that the value of the property that was forfeited was not, and this is the quote from the statute, was not grossly disproportionate to the severity of the offense. So Iowa did include a proportionality review of forfeiture in its overhaul of its laws. Okay, we can go to Michigan now, Noah. Michigan's most recent changes occurred in 2019 with the passage of a 3-bill legislative package. And like Iowa had done, Michigan legislators made any forfeiture of assets contingent on a criminal conviction in certain cases. If you recall, the criminal conviction requirement in Iowa applied to property valued at under $5,000. The threshold in Michigan is actually $50,000 with some exceptions. An older law in Michigan that was passed in 2015 had raised the burden of proof standard from preponderance of evidence to clear and convincing evidence for drug crimes. And that also established new reporting requirements for law enforcement. And those reporting requirements are detailed in part 2 on that slide. No, we can go to Minnesota. Minnesota has been active for really over a decade and a half. Civil asset forfeiture laws have been passed in many legislative sessions since 2010. And that includes a criminal conviction requirement from 2014 for cases involving controlled substance offenses and drive-by shootings. But the legislature's most recent action on civil asset forfeiture came in 2021 in Minnesota. And that law really focused primarily on requiring more transparency and oversight. That law was House File 63, and it requires law enforcement to provide the state auditor with information in 15 different categories related to each forfeiture. Additionally, the auditor must get written reports on the total amount of money or proceeds from the forfeited property, as well as the manner in which the money and proceeds were used. The auditor must then provide this information annually to the legislature, as well as on a publicly available website. Okay, no, we can go to Nebraska. Nebraska, I think I had mentioned earlier, is kind of a standout state. It stands out from the others in the sense that it is the only state in the Midwest that has actually abolished civil asset forfeiture. And that is because of the passage of Legislative Bill 1106 from 2016. That made Nebraska one of 4 states to abolish civil asset forfeiture. Money and property only can be seized in criminal cases. So this means that a criminal conviction is required before any property in a related offense can be forfeited. The same law added some new protections for property owners, including the clear and convincing evidence standard. One other notable change in Nebraska that I'd point out was that the law barred state and local agencies from transferring property to the federal government for purposes of forfeiture. unless the property is worth more than $25,000. And I think this was a provision that was included in some of the Kansas legislation introduced this year. But the intent of this kind of provision is to narrow state or local law enforcement agencies from using a federal program in which forfeited assets can be shared and then the proceeds shared between state and federal law enforcement authorities. So Nebraska kind of limited the ability of agencies to use that program. We can go on to North Dakota. You'll see on this slide that many of the provisions in North Dakota's House Bill 1286, which got passed in 2019, are similar to the enacted changes on civil asset forfeiture in other states. One, the legislature raised the standard of proof to clear and convincing evidence before property can be subject to forfeiture. Two, the legislature required a criminal conviction or guilty plea in many instances in order to initiate forfeiture. One provision I'd like to point out in North Dakota too is that, like Iowa, North Dakota included language in its bill to try and prevent excessive forfeiture. And they did that by giving new direction, new guidelines, and authority to the judiciary. You'll see that the court is able to determine whether forfeiture is excessive based on several factors that include the value of the property, the extent of the property owner's participation in the criminal offense, the extent to which property was used in commission of the crime, and the severity of the crime. And they use those factors to decide whether the forfeiture was excessive. North Dakota also included some reporting and data collection requirements like many of the other states have done in recent years. Okay, we can go to Ohio now, Noah. Ohio's House Bill 347 raised the bar too regarding the burden of proof. The government must now show by clear and convincing evidence that the property was connected to a criminal activity and as a result can be subject to forfeiture. Additionally, in Ohio now, a criminal conviction is required in forfeiture proceedings when the property is valued at under $15,000, with some exceptions, such as if the property has been abandoned or the individual has fled the jurisdiction. Ohio also is one of the Midwestern states where the burden of proof has been shifted from the innocent property owner to the government. The property owner does not have to prove that he or she did not know about the related criminal offense now. Instead, the government has to show by clear and convincing evidence that the innocent owner exemption should not apply. And lastly, just to point out, like Nebraska, Ohio is now limiting the ability of state or local law enforcement agencies to transfer seized property to the federal government. This is for property valued at under $100,000. The threshold in Nebraska, if you recall, was set at $25,000. Okay, no, we can go to South Dakota. South Dakota is the one state in the Midwest where you didn't see kind of multiple changes to civil asset forfeiture laws over the last 5 or 10 years. What we did see is just, again, this reporting requirements that the passage of House Bill 1328 in South Dakota from 2022 dealt with strengthening reporting and disclosure requirements regarding law enforcement's use of civil asset forfeiture. We can go to Wisconsin now. The final state on our tour is Wisconsin, and legislators there did adopt what would be considered one of the region's most comprehensive set of changes, and that was Senate Bill 61 from 2018. It raised the standard of proof in forfeiture proceedings, required criminal convictions in certain cases, and shifted the burden of proof away from innocent property owners and to the government. Those are all changes that we talked about in some of the other states that we saw in some of the other Midwestern states. But I did want to point out 3 other unique and somewhat noteworthy changes in the Wisconsin law. First, that law, Senate Bill 61, changed how proceeds from forfeited property or money can be used. Other than law enforcement paying for using the funds to pay for the expenses related to forfeiture actions, the proceeds must go to a statewide school fund, not to the law enforcement agencies. Secondly, another noteworthy change, just to point out that's somewhat distinct in Wisconsin, is that attorney fees may be awarded to a property owner if law enforcement is found to have arbitrarily and capriciously pursued a forfeiture action. Third, a criminal conviction is required before state or local law enforcement can receive any proceeds from the transfer of seized property to the federal government. So that's kind of our tour of the Midwest. Let me just try to, we can go to the next slide to summarize these laws. And I'd like to go back to some of those questions that I posed at the beginning, just to try to kind of cap what we've seen in the Midwestern states for the last 5 or 10 years. First, that question of should our state allow for civil asset forfeiture by the government? Generally, based on state legislative actions, the answer has been yes, with that exception of Nebraska, which did abolish civil asset forfeiture. In Nebraska, it's now criminal asset forfeiture only. Second, should our state change the standard of proof for property and assets to be forfeited? This has been a very common change where the standard of proof has been raised in many of the Midwestern states. The most common change has been to raise that bar to clear and convincing evidence, often instead of preponderance of evidence, to show that the property is tied to criminal activity and hence is subject to forfeiture. Iowa, Michigan, North Dakota, and Ohio are among the states that have made this change in the standard of proof. Additionally, a conviction in the crime related to forfeiture sometimes is now required in certain cases in order for the property to be subject to forfeiture. Examples of this change include the laws in Iowa, Michigan, Minnesota, North Dakota, Ohio, and Wisconsin. Third, should the process be changed for innocent property owners? These third party, maybe that were not involved, maybe the property was involved in criminal activity, but the owner of the property was not. How do we change the process for those innocent property owners? And some states have said that the process should be changed, and that change has included shifting the burden of proof from the property owner to the government. And I point to the laws in Iowa, Ohio, and Wisconsin as providing examples of how this shift has been made in the who has the burden of proof. Another question that's been commonly asked: should more reporting and public disclosure be required of law enforcement and prosecutors? That's been a very common reform. Most of the laws that we just talked about do include some new reporting guidelines and requirements. Should the state define or change how proceeds from the civil asset forfeiture actions can be used? The one notable example in the Midwest on this would be Wisconsin, where the state now requires that proceeds go to a state school fund. You can go to the next slide, Noah. With that, I will wrap up this tour of the Midwest and all these changes in the region, reshaping the civil asset forfeiture process. And I thank you for your time.
Thank you very much, Tim, and I'm very thankful for the work that you and your colleagues have done to... Why am I getting the feedback? All right. To put this together for us, this is very informative, and I've always been grateful for CSG's willingness to assist us with research anytime that we ask. So thank you for doing that, and thank you for making yourself available for this presentation. Committee, we have questions for Mr. Anderson at this time. Seems like you did such a great job, sir, that there aren't any questions, which means your presentation was very clear and thought-provoking. So thank you very much, and we very much appreciate your work on this topic.
Thank you very much.
All right, we will now move into our presentation on Kansas asset seizure and forfeiture repository data, and welcome Jessica Crowder, program consultant for the Kansas Bureau of Investigation, to the committee to share that information with us. Is Jessica with us? Oh, okay. No problem.
Thank you
Not a
for your
problem.
patience. I'm Jessica Crowder, and I'm the program consultant at the KBI for the Asset Forfeiture Unit. What I do is I work with the law enforcement agencies on the submission of this asset forfeiture data. And so today's presentation is going to provide a little bit of an overview of some of the trends that's being seen in the data that's been collected so far. This data is particularly coming from the annual reports that have been submitted up to this point. So this data does not include everything, but it includes all of the data submitted on the annual report from the beginning of this data collection, 7/1 of 2019 until December of 2022. So we're not including the 2023 data since it hasn't been completed yet. But if there's more information that's not provided today that you'd like to see, I'm happy to follow up with that. I have about 10 visuals to share with you today. Feel free to stop me if you have questions, but I'm just going to kind of show a little bit of the trends that we're seeing within the data that's been collected so far. This first slide here, I think it's a good thing to talk about the number of incidents first as a very basic part of the information. This graph actually gives kind of the common pattern that you will see throughout the visuals that I'm providing today. This is, of course, showing the total number of incidents submitted broken down by year. Of course, the first year, 2019, is just half of a year with that data collection beginning in July. But you see kind of this upward trend and a significant jump once we get to 2021. There was about a 45% increase in the number of incidents submitted, and then a little bit of a taper in 2022. So I just wanted to point out that you're going to see kind of this rise and slight decline pattern throughout these visuals today. This is 3.5 years worth of data, but I think this kind of shows when you're seeing this pattern throughout this data, the consistency that we're kind of getting within the data that we've collected so far. All right, seized and forfeited currency and property. So this graph is comparing seized and forfeited currency and property, and you're going to see that the majority of what is seized is currency. However, if you look at the percentage, and I've kind of included some percentages here with some of these visuals as well. 62% of seized currency ends up being forfeited, and 60% of property. So we're still pretty close in the percentage of forfeited currency and property. Now, what you don't see in here is the remaining part of that seized currency, which is going to be your return to owners and your property and currency that's been transferred for federal forfeiture. I don't have those visuals because that's not part of the annual report that we compile, but I do have a little bit of data of some stats to share about that. The recovery rate, so when we're talking about return to owner, there are 499 incidents out of 2,000, so 25% that involved a return to owner in some way, either full or partial return to owner. When you're looking at the value of what was returned to owner, this is just among the 499 incidents, just to make a note, but 4.1 million out of 5.1 million. So 80% of that, and that's just within that 499 incidents had been returned to owner. The average days to recovery for this property is about 249 days. There were some outliers in that, and if you look at the data specifically, you'll see what is affecting that number. Transfer for federal forfeiture, so, excuse me. Incidents, there are 116 incidents that involve a transfer for federal forfeiture out of 2,000, so about 6% are being transferred for federal forfeiture. We do not collect the data on the disposition of the forfeiture case. From what I hear, it's a little bit difficult for agencies to obtain that information in some cases. So we collect the incident information and we find out, yes, it has been transferred for federal forfeiture. When it comes to value, currency, we've got about 5.6 million being transferred for federal forfeiture and about 89, or for currency, and 89,000 for property. I didn't point this out yet, but you'll see that the dates at the top, this is the only part that is including a little bit of data from 2023 because that is what I had readily available. Forfeited currency, state forfeiture case. So this visual is looking at the forfeited currency broken up by the forfeiture case disposition. And in this, you'll see that 82% overall is uncontested, 10% contested, and about 8% involving a settlement. But again, when you look at this, you're still going to have the same kind of yearly trend as far as, 2019 starts out at the lowest and having a little bit of a rise and fall in each of these different categories. Initiating law enforcement activity. So what led to the seizure for forfeiture? In most cases, it was a traffic stop. So we have about 59% of that involving or being initiated through a traffic stop. But again, you're seeing the same kind of pattern, the rise and fall in these responses here. When it comes to place of seizure, since, traffic stop is the most popular, it would make sense for that to take place on a highway or street most frequently. Legal authority under which property was seized. So about 65% of incidents involved a seizure due to probable cause, which is quite a bit more than your warrant, consent, or plain view. But again, nothing is really sticking out of the ordinary trend when it comes to each year for this response. Criminal case disposition at time of forfeiture action. Now, when we look at the criminal case disposition, things look a little bit more sporadic. It's not quite the same pattern, but pretty similar. In 2019, we do have quite a small number here, and that's just because we had added a field to account for this later in 2019. But overall, it still has kind of the overarching same trend. The big takeaway from this is most often when the forfeiture case is completed, when there's a disposition, the criminal case would be obviously still pending because, as you know, they can go on for many, many years. Ownership of seized property, claimed or denied. So looking at the number of incidents compared to what was reported as claimed or denied. So about 50% was reported as being denied for that ownership and 34% claimed. We do have a little bit that was not reported, so that could affect the numbers a little bit, but overall that shows the number of incidents as far as claimed and denied. And then I have that also broken down by the dollar value. So still overall, a higher value was reported as being denied versus claimed. And then, of course, the agency did not report on some of those cases. It looks a little higher, but that's just because the value of what was reported was higher for that particular incident or incidents. Are there any questions?
Yeah, thank you very much for that, Jessica. First of all, I would like to request, I didn't see that presentation was actually sent to the committee.
I think there was some confusion on exactly what was desired today.
Okay.
So
No
this
problem.
is what we provided. And I can send it if you'd like a
Sure.
follow-up. And I also have handouts if you'd like a physical copy.
Well, if you have enough copies for everyone, that would be great. And if you don't,
I have 15. Well, I've
that'll get us
close.
pretty close. But then also email it to
I
our
sure
committee
can.
assistants.
Absolutely.
To make sure that they get that.
Absolutely.
Thank you. A couple of questions that I have. So we didn't talk in that data, in that presentation, about the amounts that we're seeing seized in terms of individual seizures. Do you have like an average amount forfeited and then also, thank you, a median amount forfeited?
I don't have that with me today.
Okay.
But it's something I can follow up with to provide as well when I send that PowerPoint.
Okay. And one of the questions I asked earlier to the revisor was how we deal with agencies that aren't reporting. And you noted in your presentation, we have some agencies that aren't reporting all of the information. What does the KBI do in that situation other than just say you're not in compliance?
Well, unfortunately, there's not much that we can do for enforcement when it comes to that, as far as what's in the statute. We try really hard, we meaning me and my supervisor, to reach out personally to every single agency multiple times to get that information submitted via email, phone. I think we've even had agents go out to agencies occasionally to try to see what we can do to help them get that information submitted. And so we do feel like we're providing you the best customer service available to help them with that. So
it would be safe to say that an agency that doesn't report is knowingly choosing not to report based on the amount of attempts that you guys are making to gain that information.
that's accurate.
Fair enough. Natalie has a follow-up on that for us.
Yes, Mr. Chairman. So once I was able to take a look at that reporting statute, so while the KBI doesn't really have, like, she said anything they can do to kind of force compliance, a law enforcement agency that is not in compliance is not able to initiate forfeiture proceedings. So if you have, and that's in KSA 604127E, so it's kind of a
And
long...
sorry not to interrupt, but I will point out that we do send a letter to the district or county attorney as well as the agency to notify them that they are out of compliance and cannot do forfeitures until they return to compliance.
Okay, thank you for that. Was there anything else, Natalie, on that one?
No, I just was going to tell you that subsection's kind of long. So about halfway through that subsection, once the KBI notifies the law enforcement agency of being in noncompliance, it says, upon receipt of such letter, no forfeiture proceedings shall be filed on property seized by such law enforcement agency. And then when they have achieved requirements, the Bureau then notifies them again and that they're in compliance. So.
Thank you very much. The other question that I have was, do we have any data that tracks the number of forfeitures that are handled locally or by private counsel?
Yes, that is a data element. If they choose a private attorney, then they will report that on the incident report, but I don't have that today.
So I'd be able to find that on those annual reports?
Yeah, it would be included in the download section for the incident reports.
Okay.
And there's a lot of data elements in there, so you might have to do a little searching to find it, but it would be under, they would report that they would be using a private attorney for their counsel.
Okay, thank you very much. Committee questions? Senator Warren, or nope, Senator Haley.
Thank you, Mr. Chair. Senator Warren. I'm trying to understand the distinction in seizures from currency and property. The property, would that include vehicle seizures, or where would that be? Because that number, 89,000.
Yes, that seems low.
It does seem
and that's just what was transferred for federal forfeitures. I think typically we're seeing most often property is done at the state level. And so you would see that in the full data extract as far as the forfeited property at the state level. And that's not included in this data specifically. But yes, the difference is property is going to include anything that is not currency. So vehicles, real property, firearms, anything that is not currency. And I will point out also that that's just an estimated value when it comes to property, because oftentimes they have not sold that before the disposition, or excuse me, before the incident report is due. So.
Thank you. And beyond that property, others might include things or a value that might be subjective, like, for example, guns.
Right.
That would be a subjective value, or those values are based on.
We instruct agencies to use their best judgment, use tools online that might help give the best estimate for that, Kelly Blue Book for a vehicle, that sort of thing.
Okay. Thank you, Mr. Chair.
Representative Bond.
Thank you, Mr. Chairman. So I just have a question about how we enforce when an agency is not reporting and they're not supposed to be forfeiting after that. How do we enforce that? How do we know they're not doing that? And how do we inform the claimants that they have an absolute defense at this point?
The only thing, we do not have a way to enforce that I'm aware of. The statute says that we have to give notice. So by sending a certified letter to their district or county attorney and the agency, we're just notifying them that they're not allowed to, so there's no actual enforcement of that.
So if they, I'm sorry, if I can follow up real quick. So if the county or district attorney went ahead and proceeded, that might be probably an ethics violation on their part. But it's the agency that's actually doing the seizing that is actually in violation, right?
Correct.
Okay. And I do see that those numbers seem to actually be on the, well, between 2020 and 2022, actually increased fairly significantly. And I mean, I understand 2020 was pandemic year, so, but it just seems like 15% of seized property not being reported seems to be a problem. But I know it's not your guys' concern, it's just a comment more than a question. So, right, thank you.
Representative Lewis.
Thank you, Mr. Chairman, and thank you for your presentation. Very informative. I have two questions. One, what percentage of agencies aren't complying with the reporting requirement?
I don't have that number specifically at the moment, but I can definitely add that as a follow-up.
Okay, one more.
Yeah, and I can possibly answer that. So each one of the annual reports are in the documents online, and they have a specific section in each one of those reports on the non-compliant agencies. So it looks like 2022, there were 5 that were non-compliant. 2020, there's 3 that are non-compliant, and I haven't gone back further. Go right ahead.
Perhaps that, is that publicly available, the information on who's not, which ones aren't complying?
Yeah, I believe
Yeah.
that this report is sent to the legislature annually, which then becomes public record for anyone to access.
All right, thank you.
I believe we have some clarification
Excellent.
for one of those
If you would
points.
just state your name, well, I know your name, but state your name for everybody listening.
Good morning. My name is Sarah Washburn. I'm an Assistant General Counsel with the Kansas Bureau of Investigation, and Jessica's phone a friend. I believe I wanted to clarify a question that Representative Mon had. I think the data that you're looking at is not exactly the way you're understanding it based on your question. What you're looking at is the unreported or unknown property. That's not, 15% is not the number of agencies that are out of compliance with the reporting requirement. It's a slightly different data point. And I did want to clarify that because there's not 15% of the actual agencies not in compliance. So I did want to clarify that because we have much fewer than 15% who are not in compliance each year.
Good follow-up? Go ahead, Representative Bond.
Yeah, I did understand that it wasn't the number of agencies, but it does indicate, it seems to indicate that 15% of the seized property is done by agencies that aren't reporting.
And that's entirely possible by done when done by value. I'm sorry, I misunderstood. I wanted to make sure we were clear on that data point.
No, I appreciate it, but, and it's a good clarification, so thank you.
Representative Resman.
Thank you, Mr. Chairman. I was wondering if an agency hasn't applied for forfeiture, do they still have to report? Because I was looking at this list here. There's about probably a dozen agencies that says no annual report. So if they don't seize anything, do they still have to report?
Yes, so all agencies are required to submit an annual report, even if they do not do forfeitures. It would just be a 0 report. We do have a list of those agencies on the annual tab of our website as well. So if you're looking in there, you can see exactly which agencies reported as being a 0 report agency. But the ones that you're referring to, I believe on the non-compliance list, yeah, those are the agencies who did not submit anything. So we don't know if they're a 0 report agency or if they just didn't submit their annual data.
Very good. Yep, Representative Carr.
Thank you, Mr. Chair. So when an agency is found to be out of compliance, do we have a period of time in which they have to become back in compliance, or do we wait until the next annual report? And two-part question. And then what takes place during that time period with the seized property?
So the statute says we give them 30 days to make a correction, but there's nothing indicating how long they have to come back, to return to compliance after being marked as non-compliant or reported as non-compliant. And then, I'm sorry, what was the second part of your question?
During that time period where they're out of compliance, what takes place with the seized property if they're unable to hold those seizure hearings?
Sure, if they've seized property, but they're not allowed to do forfeitures at the time.
Correct.
I actually cannot answer that question. There's no enforcement from our end as far as, what they can do. I don't know if anybody else has any. You're my next thought.
Go right ahead.
Again, Sarah Washburn with the KBI. Because there's no enforcement mechanism in 4127 for the KBI to actually prohibit or actively stop agencies who are not in compliance from engaging in asset forfeiture, we have no way of tracking that. We don't know what happens with it. That's done at a local level. Apparently, based on the data, there are some agencies who are not deemed to be in compliant who are still engaging in forfeiture. So in that case, the property would simply move through the process and would either be returned to the owner or forfeited like any other property. But if someone was actually minding the KBI when we sent them the letter telling them they were out of compliance, that property would potentially either be held or returned depending on what the individual agency elected to do. And that would be up to them.
Thank you.
Thank you, Representative Carr. Senator Warren, did you have some questions?
Thank you, Mr. Chair, and thanks for your presentation today. Looking at a couple of your slides, it looks like 2/3 of the places of seizure are highways or streets. It's 65.4%, I think, on that slide. And then when it's forfeited currency, the statistics show that 82.6% is left uncontested by the owner, 82.6% uncontested when it's currency. Do you have any data about the reasons for it not being contested, people trying to get their currency returned?
We don't. We only find out if it's contested or not. So there's no additional correlation of data that we could collect.
Okay, and the one slide is titled Ownership of Seized Property Claimed or Denied. And there's a denied 50%. Does that mean, what does that mean? They deny, hey, that wasn't mine? Or what does denied ownership mean?
Yeah, so in that case, they've denied ownership of that property. And so sometimes, I mean, if that can be, they said it's not mine, or are you aware of any other situations for that?
I believe that graphic is designed to capture whether or not roadside, when their law enforcement is asking questions, or during the initial portion of the investigation where they're asking questions, trying to determine what's going on, does this belong to you? And that reflects when someone has said, no, it's not mine, or it doesn't belong to me, or it belongs to someone else, or something else like that. It's not a formal waiver or, surrender of property under a judicial process. It's just that, no, it's not my stuff.
And that's at, you said, kind of the roadside stops or on the highway where they're stopped while driving and...
If we're looking at that type of an interaction, yes. But there are also forfeitures that come out of investigations that are more long-term. And so just throughout the course of that investigation, as a law enforcement officer, you want to find out, one, what's going on, where did the money come from? Because so those questions also help you determine whether or not it is the fruits or instrumentalities of a covered offense, or whether it's designed or intended to facilitate a covered offense, to let you know, one, is there a covered offense? Is there a crime happening? And two, is this property subject to forfeiture?
Thank you. And may I ask a question for the revisor? Sure. During this process, during the traffic stop and the questioning, what are we doing? What's the process regarding Fifth Amendment if that person being stopped might face criminal charge? Do we have any protections in the civil asset statute, I guess is what I'm asking for, that regarding the Fifth Amendment and what you say won't be used against you in a criminal prosecution?
Sure. Thank you, Mr. Chairman. There are provisions throughout the civil asset forfeiture statutes related to being able to assert that claim against self-incrimination. But I kind of want to maybe clarify the question, because that would happen when you're filing a claim, when you're saying you're an owner or an interest holder. So, the forfeiture proceeding has already been noticed and you're filing a claim, then you can assert that right there. I'm not sure, there's nothing really in the statute that talks about doing that at the time of like a traffic stop or a seizure. So that would just be kind of governed, I guess, by, the other law on the topic, case law on the topic, not necessarily this act.
Whether they'd have to be read their rights at that time of questioning or not? And
Yeah, I mean, if they were being arrested, then they'd be able to, remain silent and not engage in activity that would incriminate.
But if they're being stopped and asked these questions and not arrested, something they say might be used against them later, or just trying to clear up
It's
that.
possible, yeah, that something would be then. I mean, then you're looking at, were they being detained? Should they have been Mirandized? That it would fall under kind of that area of law more so than civil asset forfeiture.
Okay, but it all kinds of seems entangled because it's the traffic stop. Okay, well, thank you for that. Yes.
If I may just address that briefly.
Yeah, go ahead, Ms. Washburn.
In a civil asset forfeiture case, you're right, it's a very entangled process, but even though it's a civil process, there are some remedies that are available to claimants if they believe that there has been an unlawful seizure under the Fourth Amendment, or if there have been issues with statements taking in violation of their Fifth and Sixth Amendment rights. They have the absolute right, once they are claimant, to file a request, a motion to suppress, other types of motions. In fact, I've had a forfeiture case where we did a determination of whether or not statements were voluntary or not. And Ms. Scott is absolutely correct. That area of the law, whether someone was in custody and being asked incriminating questions, would then trigger those rights. So while it is a civil process, the courts have consistently read in those protections and do apply those protections to asset forfeiture cases. So anything that you would, I won't say anything, but many of the same protections you have in a criminal case, you could assert those protections in a civil asset forfeiture case as well.
Last question, if I may. You talked about private attorneys being retained, but that's on behalf of the agency, right? Representing the agency, not the claimant and not the person whose property was seized.
Correct.
And in this process, there's no attorney provided for the person working to get their property back. Is that right?
Not that I'm aware of, but I will defer to.
There is no attorney provision because it's a civil case and property case, so that is not typically done in civil cases, so no.
Right, it's criminally usually. Thank you.
Thank you. Additional questions, committee. Representative Mon. Nope.
Thank you, Mr. Chairman. And ma'am, I understand that we only have, 4 years of data here, and that criminal cases go on sometimes for years. But as far as we can tell from the data, there's only about 18%, and if I include diversions, 19% of forfeitures that we actually have a criminal conviction. Is that the way I'm reading? Is this correct?
Correct, yes. At the time of the incident report being submitted, which is due within 60 days after the disposition of the forfeiture case.
Okay, so the property's already been forfeited at the time of that report?
Correct.
Okay, all right. So just to clarify, about 19% of the time that we know of, property is forfeited and there's no conviction at that point?
Correct.
All right, thank you.
Representative Osman.
Thank you, Mr. Chairman. Thank you very much for your presentation here today. As I recall in the Kansas Judicial Council's report, it didn't really delve into the reporting functionality so much as a recommendation. So while you're here today, do you have recommendations as to modifications to the reporting functionality capabilities that would allow for better collection of data or better enforcement of noncompliance?
At this time, I'm not prepared to provide that. I believe that there probably are some things that could be changed, yes. I just do not have that with me today.
Additional questions, committee? All right, seeing none. Thank you very much. Natalie, do you have something?
Yeah, I just have one more follow-up.
Go right ahead.
So we kind of talked about the reporting follow-up. That was one question that I wasn't sure of when we were talking. The other question that I needed to follow up about was engaging that private attorney. So I found the provision here, which is in KSA 604107. It's in subsection H. So if that county or district attorney declines the request for forfeiture, then like we talked about, the law enforcement agency can engage an attorney. What I was forgetting is that attorney has to be approved by the county or district attorney to represent that agency. And then also what was changed in response to the post audit that came out a few years ago was that that attorney cannot have any financial interest with the county or district attorney. So that county or district attorney essentially can't have like a separate law firm on the side where they handle forfeiture actions and then decline the action and refer it to their private. So that was the change that was made a few years ago.
All right, thank you, Natalie. But we still don't know the number. At least looking at the annual reports, I didn't see the number that are handled by private attorneys versus district attorneys.
Yeah, that's not included in the annual report information. It's only included on the incident report itself. So that's going to be under the downloads tab of the website. So that's just going to be the full incident report information.
And is that something that we have, public has access
Yes,
to?
yes.
Okay, then I will see if we can't dig into that. Thank you. Oh, Senator Warren.
Thank you, Mr. Chair. One last question from me on this issue of the outside private attorneys. Do we have information on how they're paid?
We do not. We don't collect that information.
Okay. Would that be available publicly somewhere?
I'm not aware of that.
Senator, the provision for paying an attorney who is private attorney asked to prosecute the forfeiture is specifically identified in statute. They're paid from the proceeds of the forfeiture, and the percentage of the forfeiture they may be paid is also set by statute. It's in the act itself. I believe it's 15% if it is uncontested, 20% if it is contested, and that's very similar to what a private attorney who's representing a claimant would receive on a contingent fee basis, some percentage of the recovered monies.
And just to be careful and clear, when you say that's somewhat similar to what a private attorney representing the claimant would be paid, you said 15%.
The mechanism is similar. I apologize.
Okay, I was going to say
clear.
those percentages, some attorneys might disagree are
Yes.
accurate, so.
The percentages are different. If you're talking about someone who is retained to represent an owner and interest holder, from my experience, they are usually asking for a contingent fee of 30% up to 50%, which is in line with other types of civil cases. But if you're going to represent the state in a forfeiture case and you're a private attorney, then it's 15% for a non-contested forfeiture, or 20% if you are an attorney who's asked by the county attorney to handle it if it's contested.
And so with 83 nearly percent of forfeited currency being forfeited, the private attorney gets 15% of that per statute, is what we're saying.
Up to that amount, yes, ma'am.
And it would be less because?
There may be an agreement with the county attorney for less, but generally speaking, that is a solid number, I would imagine.
15% is
Yes,
solid.
ma'am.
Okay, thank you, appreciate that.
All right, thank you. I'm formulating another question, but I can probably catch up with you guys a little bit later. I think I found your data on private attorney versus county attorney and who's handling these, but I mean, according to this data, it shows the district county attorneys doing the majority of it. But I'll dig into that. I'll come up with a question. I'll get with you guys later. Additional questions, committee? All right, seeing none. Thank you guys very much for sharing this. I know it's a lot of information. Committee, we're a little bit behind schedule, but I know we all still need to take a break. Let's go ahead and take 10 minutes and return back at 10:50 if we could be prompt about that. We have Judge Sexton, who is going to be presenting to us shortly thereafter. Thank you. Could begin getting back to our seats. That would allow us to get started. All right, committee, we'll go ahead and get started. Hopefully a few of our missing members will join us here shortly. Check, check, mic check. Hello, hello. There we go. All right, thank you guys very much. Want to go ahead and get started so that we can be timely. We will now welcome Judge Ben Sexton, who spearheaded the subcommittee on civil asset forfeiture through the Judicial Council. Welcome him to the committee and look forward to hearing his input and information. Judge.
Great honor to be here today. I very much appreciate the invitation. I want to start off and thank some people right at the beginning that were very much needed in this task. Jason Thompson was from the revisor's office, was of great assistance to us, and I'm always amazed when you tell Jason and Natalie, I want a big house, I want 20 rooms and 15 bathrooms, now come back tomorrow and tell me what it looks like. And they do that. They're gifted individuals. Amen. I want to give a special thanks to Nancy Strauss. She's the author of this report that you've been given, a tremendously gifted writer. And if you read that report, and as old as I am now, when you read things that are easy to read, they are a pleasure. And this reads like a story. So I want to thank her, and I also want to make sure, so if it goes bad, you know who to blame. It's not me. And then I want to thank the committee, a very diverse, all the stakeholders at the table. Committee, we have 3 members on this special committee that were a part of this advisory committee, Representative Osman, Representative Mon, and Senator Haley were all part of this advisory committee for the Judicial Council. Now, I don't speak for Judicial Council. I'm not a member of the Judicial Council, but they just do it right. Nancy did a tremendous job, and I think in the report, there's a mention in there that it was intentionally put together in this fashion. This would be an easy process to manipulate. And all you would have to do is, instead of inviting 3 law enforcement or 3 people from the other side, is to bring on enough people to give you the majority to write the report. And that's not the way it's done. That's not the way it was done here. So it was intentional to have all the stakeholders at the table. And while I can't give you and present to you a unanimous report or a vast majority report on the number of issues that are contained in House Bill 2380. What I can give you is a very real representation of where the stakeholders are and what their positions are. And I'm going to use the word unanimous about 3 times when I discuss our work in this committee. And I would suggest to you that when you hear that word unanimous, that it has a special meeting with this advisory committee and probably should be adhered to. There's one phrase out of, or one paragraph out of that report. It's on page 5. It's a third full paragraph. And it sums up this advisory committee to a T. And it reads, the committee was well balanced with members holding views across the spectrum. The difficulty with this topic, forfeiture, is that the people on the ends of the spectrum have opinions that can't be reconciled. One group believes that asset forfeiture should end, and the other believes just as strongly that it is a law enforcement tool essential for public safety. The committee worked diligently to find every possible area of agreement as the study of House Bill 2380. So this group got together initially in 2017, this advisory committee. And there were 2 things that came out of that. We were concerned at that time with a number of defaults and uncontested matters, that whether or not that there was access to justice, whether or not it was user-friendly for that pro se individual or individuals claiming property. And so we did a lot of work in that regard, and then we created the repository to help follow the money. And the KBI has done a tremendous job, tremendous amount of information in that repository and report. And so now we put the band back together about 6 years later. And we met 4 times in August. And this comes to us now as a request for a study on House Bill 2380 by Representative Owens and Representative Patton. And we were looking at the items contained in 2380. The big ticket items are requiring a criminal conviction before forfeiture proceeds, remitting the proceeds to the general fund, increasing the burden of proof required. Right now it's preponderance, and I think House Bill 2380 has it as beyond a reasonable doubt, making certain property ineligible for forfeiture, right to counsel, right to a jury trial, and allowing a person to request a hearing in regards to the excessiveness of the forfeiture. So we have data, as Ms. Crowder, and she presented to us, did a really nice job, from July 1st of 2019 to November 8th of 2023. And I will tell you, when I'm extremely jealous now when you tell me you are a paperless special committee, because that paperless takes a whole new meaning now in my life, because we are drowning in paper because of another incident. I love that word, incident. We have a security incident, and now we have 2,000 incidents in regards to the forfeiture. But out of those 2,000 forfeitures, you have 116 go federal. Now that's important to note, because one of the things in House Bill 2380 is in regards to whether or not we should block that ability for the feds to come in and take a case. And we're going to talk about that later, but out of 116 incidences out of 2,000 would indicate there's probably not an issue there. Those incidents involving federal or crossing state lines, law enforcement will tell you those are expensive investigations, so I don't think we have that issue. But we have 1,884 Kansas incidents. Out of that, you have about $17,500,000 seized since July 1st of 2019 to November 8th of 2023. You have about $14 million during that period of time forfeited. You have about $4,100,000 returned. So you have about a 24% return. Now, one of the things that was eye-opening to me is the median. You asked Chairperson about the median. There is a median. It's $3,116. And the reason why that is surprising to me, I'm the chief judge in the 8th Judicial District. That's comprised of Marion, Morris, Dickinson, and Gary County. And if you review the report, Gary County is prominently mentioned in that report. Great officers that patrol Highway 70 in Gary County. They're good individuals. And when I see that the median is $3,000, I don't see those cases. And I'm sure I've had 1 or 2, but they're not the cases that I'm used to seeing. I'm used to seeing much higher amounts. So when I see that $3,000, I think that's concerning, because one of the things we were worried about in 2017 is this would become such a popular that it would leave I-70 and go to smaller communities. And the smaller communities would then maybe start using it. And I know that the individuals, I love all these people back here. Ed Klump, I have nothing but great respect for, Director Mativi, but the word policing for profit, okay? That was one of the concerns back then. So you have the data, when we brought in the data, and we've looked at this data, and you have 249 days as the average amount of time from when the forfeiture starts to the ending. The committee had a hard time even agreeing on what the data showed. You had one half that said, see, this is clearly an abuse of power. The other side saying, no, it's clearly a proper way for law enforcement to disrupt criminal activity. So you have one side saying fundamentally unfair to take a person's property without proving wrongdoing, not enough procedural due process, and the other side saying, hey, it's an important tool for law enforcement to disrupt criminal enterprises. So we start talking about the House Bill 2380 reforms. And the first one we talked that we came to a unanimous, there's that word, and it's not going to be used very much here, unanimous was calling out certain crimes that give rise to forfeiture. This is pretty significant. So when we talk about disrupting criminal enterprise with forfeiture, in my mind, what I think of is manufacturing, distribution. Those are big criminal enterprises. However, the user is an addict. And when you take a user and you forfeit $500 of the user, you got his money. Is he still an addict? Now you don't have his money. What's that guy going to do? He's got to feed the disease. He's addicted. He's going to go out and it's going to create more crime, part of the wheel. So what the committee decided to do unanimously was to call out the crimes that are set forth in Chapter 21, Article 57, call out the user portions of those statutes, and they'll not be allowed to give rise to forfeiture. I think this helps the public perception, and it may help take away some of the forfeitures of the smaller amounts that the user is being dinged on. So I'm very proud of the work that the committee has done there. Making certain property ineligible, and this is kind of a big item. Now, we were not unanimous. We came to a consensus, and the consensus was there was probably a perception of the public that this wasn't good, that there was an optics problem. And so the House Bill 2380 starts off with the property of, if you have cash of less than $1,000 or property less than $2,500, that wouldn't be eligible for forfeiture. We've agreed to that. We agreed to that process. However, we've left those numbers blank. I think in our last hearing, Senator Haley tried to get us to fill those numbers in, but there was no way this advisory committee was coming to an agreement in regards to what that was. I can tell you law enforcement feels it should be much lower than what's contained in House Bill 2380, and Director Mativi gave a very clear report about a law enforcement agency that believes that no matter how low the money is, you're disrupting a criminal enterprise. And so they would want those numbers lower. There was another faction that said, if you take $3,000 being the median, and you take out anything under $3,000, you get rid of half the forfeitures in the state of Kansas. They're gone. The Institute of Justice says that it costs $3,000 to hire an attorney for civil forfeiture. I think that's wildly understated. I don't, because you have attorneys that now, and I don't keep track of it, I've been out of that game for a while, $300 to $500 an hour. That doesn't take very long to eat that up, okay? Well, who spends $3,000 on an attorney to get $3,000 in property and cash back? The only person I know is an angry banker, right? Angry bankers will spend a lot of money to get 10 cents back, but it doesn't help the individual. So when you take that into effect, this is a big thing right here. This is a very important part of this because the public perception, if you take away certain numbers of lower, you're probably taking away Joe Plumber, okay? Because part of the problem is these addicts, when we take away the user portion of those statutes, every addict is a distributor. Haven't met one that's not yet. And they're the most generous people in the world because I hear it in drug court all the time. Well, I walked into my friend's house and there was a pipe full of methamphetamine and I took it. I'm thinking, these people are very generous with their property. It's unbelievable. So that setting that number where you put it will have a dramatic effect on the number of forfeitures that take place in the state of Kansas. You're also concerned about the uncontested and the defaults. So out of that 1,884 incidences in the state of Kansas during this period of time, 1,300 are default, 70% of your cases. Now, some of that law enforcement's absolutely correct. These people are involved in it, they walk away from it, they don't want anything to do with it. But what about the individuals that aren't? Okay, and that's what you're concerned with. What about the individuals that are looking at it and say, you know, the cost-effective wise, it doesn't work for me to hire an attorney, and I don't feel comfortable with the process, so I'm just going to walk away with it and forget it. So this, filling in those numbers will have a dramatic effect in regards to the forfeitures in the state of Kansas. Now, when we did that, we have not used it per item. It's an aggregate value, okay? So it's not, so if you have $500 and a car of $2,500, it's an aggregate value of $3,000, not the $500. We certainly have firearms are not subject to portion of that aggregate value, and firearms, and this was unanimous, will always be subject to forfeiture. So it's the aggregate value we would be concerned with. So when you're talking about setting numbers, if you set $2,500 in property and they have a car and 2 or 3 other items and they value the car's $1,500 and the other items are $1,000 apiece, it would be $3,500. Okay, not just the 1,000, and then we go to the next one. It's the aggregate value. The seizing agency, we agreed by a consensus that we would reduce the time. They have 14 days, I think, in our proposal, in which to either make a decision to forfeit or return the property to the owner or the interest holder. Now that doesn't mean that they can't, within their statute of limitations, go ahead and file the claim for forfeiture, but it does, we're trying to push the state along and not delay. Roadside waivers, that's contained in House Bill 2380. It's unanimous, one of those words again. No roadside waivers. And Senator Warren, that's kind of what you're getting at when you're talking about what happens on the roadside. There was, and I'm not sure how popular it is here. I've never seen it, but the law enforcement having the person at the stop say, oh, you don't own this property, well, here, sign this waiver for me. It would specifically eliminate that. Now, it would not eliminate the officers just in the course of their investigation having that conversation and the person making a denial. That may very well come in to evidence, but it eliminates the written roadside waiver. The early probable cause hearing. In the way the act is written now, an individual has a right to ask for a probable cause hearing. And this was Director Mativi's suggestion. We have suggested putting that right up front in the proceeding. So when you file a criminal forfeiture, you have to file an affidavit for probable cause, and a judge has to make a finding of probable cause. In 2017, we changed it to make so when you send it to the claimant, you have to send the essential facts that give rise to the forfeiture. We're now kind of putting that up on steroids a little bit and moving it to the front of the process. Now, that being said, probable cause, low standard, right? And there's nobody there to argue against it. So I would imagine a large portion of those will be granted. But gatekeeping measures are important, and that's one of the gatekeeping measures that we have. Proportionality, again, this was unanimous. contained in House Bill 2380. It can be requested at any time of the process. And the court can take that up in regards to the whether or not it's excessive. Now, the burden of proof is different. Right now in House Bill 2380, it's beyond a reasonable doubt. Civil is preponderance of the evidence. And the way I've always explained that to individuals, and it comes in, and most often in PFAs and PFSs, because they automatically think it's a criminal case when they walk through the door for some reason. But it's like the lady in the scales of justice who's blind holding those scales. If that scale on a preponderance tips ever so slightly in one person's favor, that person wins. Beyond a reasonable doubt, and this is a discussion that we had, and it'll come up again later on this morning, when you merge criminal procedure and civil procedure, there's real dangers there. And there's, beyond a reasonable doubt, is a criminal burden of proof. Clear and convincing is another one that we would be subject, and we've had this conversation of the burden of proof. I know Mr. Representative Mon was a big proponent of changing the burden of proof. And they can tell you that on the beyond a reasonable doubt, when we discussed it, it failed on a vote of 9-4. Clear and convincing was 7-6. Very close. And you see from your discussions prior that it's popular in other states. Now, requiring a criminal conviction, there wasn't any appetite on the advisory committee for that. And I will tell you that the best argument made against requiring a criminal conviction came from Chris Joseph, the defense attorney. And it's a good argument. So his concern was if you require criminal conviction, you're probably actually subjecting defendants to be charged and prosecuted more than they are now. And you involve money. So if you have right now, a prosecutor has a close case, chooses not to prosecute the case, fine. Now the prosecutor has a close case, but he has $200,000 sitting out there in forfeiture funds. In order to get the conviction, in order to get those funds, he's got to get the conviction. Is he filing the case? And those are bad optics. Those are optics that the public sees, and in our business, you know, you have that appearance of impropriety, and you may do it perfectly. You may do nothing wrong in that process, but that appearance of impropriety cripples us. And that would be one of those things. So we came up with an automatic stay, and it kind of like the bankruptcy court. So if you have a criminal defendant, forfeiture's filed. Now, under the current act, you have to request a stay. Automatically now, the stay takes place. And the stay's in effect on discovery, and so it preserves that individual's Fifth Amendment rights in that regards. It kicks the case on back. Now, it can be lifted if the defendant absconds, if you have an innocent owner, anything like that, they can come in and ask for the relief from stay to be lifted to proceed, but the automatic stay protects those individuals. Please.
Thank you, Judge. Was that, did the automatic stay fall under unanimous consent?
Let me look. My guess is no. No, I think that would be probably a majority.
Okay, thank you.
Fee shifting, important part of it. We now have a fee shifting that we have defined a little bit differently. I think federally it's substantial, and I can see Judge Hill of the Court of Appeals saying substantial. How do you define substantial? So we have it so if you receive back more than half of the aggregate value of what was seized, then the state of Kansas has to pay your fees, costs, et cetera. Puts a little bit more skin in the game. And you know, the Colin Woods of the world, I'm not worried about. Colin does great work and conscientious and looks at his cases, but it does put other individuals that are going after these funds on a different level. Now, items that we did not agree to. Right to counsel. It's not that we don't believe individuals should have a right to counsel. We had a couple of problems. How do you fund it? We couldn't come up with a funding mechanism. And two, are there enough attorneys to do it? I can tell you that in my district, they're not, just simply not. And farther west you go, there's probably less. And if you tie it in with the criminal, again, and make it part of the criminal process, there's that optics problem. And the bids counsel, Brandon Barrett, wasn't too enthused with having bids attorneys and be part of the forfeiture process. And intermingling those and blurring those lines between civil, between an in-rem process against property and bringing in the criminal property, I think that, as stated earlier, there's just an optics problem. Requiring a conviction before proceeding to forfeiture, again, we've discussed that. And again, it's the optics, it's the blurring, the criminal and the civil. Is it punitive? Is it not punitive? It's the same discussion, quite ironically, that we had during the advisory committee on the Kansas Offender Registration Act. Is it punishment? Is it not punishment? You know, and there's blurred lines that are similar in both these. Raising a burden of proof is again one. I know that's beyond a reasonable doubt, House Bill 2380. And again, this was a close vote. From as far as a clear and convincing, there wasn't any appetite to go to beyond a reasonable doubt. However, the close vote on clear and convincing was 7-6 against, so that's an area that could possibly be involved. The right to a jury trial, again, there was no consensus on the right to a jury trial that's contained in House Bill 2380, and that's for several factors. One, if it's both sides and you have the plaintiff's attorney requesting a jury trial, how much of a disadvantage does that put a pro se person, or do you make the pro se person the only person to have the ability to request a jury trial, or the claimant the only person to request a jury trial? And in the end, there was just no consensus on the granting the right to a jury trial. Transferring money to the general fund, as I pointed out earlier, this is just not an issue. It could be. And law enforcement will tell you it could be. But what you're worried about there is law enforcement skirting you folks, skirting the legislature and what you folks decide and sending the money federally to have it seized and then receiving their percentage back on that. And that's just not an issue here. There's no indication out of 2,000 instances, only 116 are going to the feds. And they will tell you that there's probably well-reasoned that it should go that way because of the costs of the interstate investigations, et cetera. And the money, this is one where I teased all the members in there, and I told them I was going to bring popcorn when we started talking about who gets the money, and it fell on deaf ears. I thought it was a pretty good joke at the time, but I got more laughs today than I did then. They just kind of stared at me. And there's a couple of things here. One, the committee acknowledged that this money being used by law enforcement, it saves taxpayers from having to fund all these items at law enforcement. It replenishes their investigations, et cetera. But there was talk about maybe earmarking those funds for other things. And Director Mativi does a wonderful job, and I've heard him talk 3 or 4 times about fentanyl. And very upfront and very honest. And one of the most profound things he says when he talks about fentanyl is policing's not going to cure this by itself. And when you think about it, that's an important statement, because there's got to be something else other than policing. So to me, that means grassroots level. We got to get the word out. We got to start educating our children, educating the public, and other avenues. And one of those other avenues is your specialty courts. When we talk about culling out the personal users in this matter and taking them out of the game as far as forfeiture goes, the addiction is there. And nothing here cures the addiction. The only thing that's going to cure the addiction, in my opinion, in 23 years on the bench with these individuals, is drug court, specialty courts, where you have those individuals and you take them in and you don't let them go. No matter how many times they test hot, no matter how many times they reoffend, you just keep them there, and you hope long enough, and it takes months to get those individuals back to be functioning members of society. So maybe earmarking some of those funds for your specialty courts so you can work at these at a local level, and maybe, you know, I always think about a doctor that talked one time about child abuse, and she said, I can either treat the symptoms. She goes, I can go to the well where they draw the water. She goes, I want to go to the well. And that's kind of what I'm talking about here. We can treat the symptoms of forfeiture and what takes place in possession and criminal acts, or you can go to the well where they draw the water and try to cure the people that have the addiction. So while I can't give you, you have a report that says accepted without recommendations, and I wasn't at that meeting. While I can't give you just a wonderful Bo report and said, here you go, it's easy, run with it, you do have a very good idea about where the stakeholders' positions are. And I will tell you that the stakeholders on both sides of this issue are sincere. They were an absolute pleasure to work with, and they both make very good arguments. And I'll stand for questions.
Well, I also want to be clear, we've thanked an awful lot of people in this room except for you leading the charge on this, Judge Sexton. I know that we asked a lot of you, given how busy you are in your daily schedule, to focus on this issue and be engaged in it. So I'm grateful for your leadership as you tried to find that balance as it relates to this subcommittee. So thank you. So just to make sure I understand, was there any other discussion on I know the recommendation in the bill was transfer all civil asset forfeiture proceeds state general fund. Was there any other options contemplated there?
Yes, I can tell you that when we took that vote, that failed 9-4, right. 9 against. Then we took another vote to take no action on it, and that passed. I think it passed comfortably to take no action, to leave it the way it is. There was a lot of discussion on where the money should go. Should it go to the local governing agency and have them dole the money out? Should it stay with law enforcement? Should it go to the general fund? And there were thoughts on both sides of the table. Obviously, people that don't want forfeiture would like it to go to the general fund. Law enforcement would like to keep it to proceed on the way they're doing. We did discuss other options, such as earmarking it for other items, such as drug court, et cetera. And so our last vote was a vote saying not to change it, but noting that we were going to leave it to you folks in regards to where you were going to have the money to go. You have the final say, obviously.
All right. Thank you very much. All right, committee. Additional questions for Judge Sexton? Senator Warren? Oh, Representative Ressman.
Was there any discussion when it comes to where the money should go? Like you said, specialty courts, for like maybe back taxes that person may own, or whoever took whoever has the property, or child support?
No, there was not.
Okay.
And I was self-serving. I'm the one that raised the drug court, specialty courts. So okay. I need to have full disclosure here. I had an agenda going in there, guys. But there was not, Representative, no.
Okay. Would that be a consideration?
Absolutely.
Okay. All right. Thank you.
Senator Warren?
Thank you, Mr. Chair. Thank you, Judge, for presiding over that subcommittee and presenting here today. And just to clarify, I do serve on the Kansas Judicial Council, one of its 10 members. It's created by statute, and as chair of the Senate Judiciary Committee, I have the honor of serving on the council. The subcommittee that you served on and chaired was not comprised of any members of the council, but we thank every subcommittee member for their hard work and thank them for their report. And also want to thank my predecessor on the council, Senator Wilborn, and for his fine work on the council as well, that I think helped enact some of the 2018 reform that we saw a few on this particular act in statute. So it was lively discussion on Friday when the Kansas Judicial Council received the report, and it was very purposeful that the Kansas Judicial Council made no recommendations based on the report. So it was simply accepted, and thanked the subcommittee for their hard work, and it was felt these are important policy decisions to be discussed at the legislature, and also want to thank Nancy Strauss for her hard work on presenting it to the council. So I do have a couple of questions. We heard some of the other states have considered shifting the burden of proof when you are an innocent owner, and that kind of innocent owner defense. Right now, the law says that as you have to prove your innocence. Hey, that property wasn't involved in a crime and it shouldn't be forfeited. Some other states have switched the burden of proof to the government to prove this property was involved in crime and we should be able to to keep it. Was there any discussion about changing which side has the burden of proof?
There was not, Senator. That was not a topic of discussion. I can certainly see where it would make sense for the latter of your description to be appropriate to put it on the state to prove their case.
Appreciate that. Thank you. And was there any evidence presented? We've seen some data from the reports that are required to be made from the agencies. Was there any evidence over the couple of days that your subcommittee met that this procedure helps fight crime, that we have data that when forfeitures go up, crime goes down, or do we have any studies that show either direction?
You know, I have Sam McRoberts sitting behind me, and I'm sure Sam's in his chair saying, can I get up there to that microphone now? That was a point of contention. Director Mativi made a very impassioned discussion in regards to a small law enforcement agency that believes that all these forfeitures are disrupting criminal activity. The other side of that coin, I remember it quite clear, is a conversation that he and Mr. McRoberts had in the courtroom about prove that to me, because I see no data in that regard. And the comeback is, well, they know at the local level it's working. So while I can say there's no evidence-based data, although I will say Director Mativi did discuss about crime and about the changes in the percentage of the crime going down, there's no evidence-based proof directly right on point is how I would respond to that.
Was there any discussion about how the forfeited currency and property was used? You talked about maybe specialty court funding. I serve on the advisory committee regarding funding of the specialty courts and haven't heard...
Who do I need to talk to?
Apparently, and haven't heard that this would be sort of a funding stream for courts, so I'm interested to hear that discussion. But was there any discussion about how these dollars are actually used? How much is going to fight drug addiction education? How much is going to schools to put on those programs? Was there any discussion? How much is using it to hire more law enforcement? Was there any discussion about how these proceeds are being used?
No, time prevented that. I will tell you that law enforcement, I'm sure, will be able to direct their attention to that. I can tell you that it was a topic of discussion in regards to when we started realizing that maybe users should not be part of this process. It was the median number that concerns me, the 3,000. And so that means half of them are below that. And I've had a chance to talk to other judges around the state. Judge Wilder was on our advisory committee. And I made the statement, I said, I'm not seeing these cases. She goes, oh, I see them. I talked to a judge out west, and he says, I see forfeiture cases. And he said, the problem is I don't see any criminal cases filed on those forfeiture cases. So it's the low numbers that concern, and the fact that the addiction does not go away. And that's where we kind of merged in. I saw my opening and took it, that maybe these funds, if we want to talk about really affecting drug enterprise, let's take these people that have these addictions and help them, and vastly fund our specialty courts, because it's hard. We got lucky in Dickinson County, and we have one that will not depend on we have our county commissioners that have bought all in, and it's now kind of self-funding. It runs itself. But other drug courts in Gary County failed because of that lack of funding. So in my mind, that's where it leads to. Funding will help specialty courts. And this, I don't know if you find a better place for the money to come from than drug forfeiture. You know, back in the day, they used to have the car that I'd see driving around Gary County, big letters all over it. This was taken from a drug dealer. This is, and they were quite, and it was for the purpose of showing people, hey, this is what happens if you're in the drug trade. What better way than to take that money and help people at the addiction level and get them back working, get them back being functioning members of society?
Well, that's certainly an important goal, but we have to make sure that the process is
Yeah,
is.
one ends doesn't justify the means.
Right,
Gotcha.
right. So, and I know there's been lots of lively discussion over many years about this topic. So thank you for your work on this.
You're very
Appreciate
welcome.
it. Thank you, Mr. Chair.
Additional questions, committee? All right, seeing none. Judge, thank you again very much. Appreciate you
Thank you,
spending
folks.
half your day with us and again, all of the work of your committee, subcommittee, the Judicial Council, everybody. This is what really helps us be able to do our job effectively. So thank you. All right, committee. Well, it turned 11:30, right on the dot. That's pretty impressive. I got to give that to you. So we're going to go ahead and break for lunch now from 11:30. We intentionally budgeted an hour and a half in to give people time to leave and then come back. If you could make a special effort to be here at 1 o'clock, because the later we start, the later we finish. And we all know how that works. So until 1 o'clock, we will be adjourned. Thank you. And recess, excuse me. go ahead and get started. Thank you for getting those doors closed for us. Try to do our best to stay on schedule to the extent that we can today. So thank you guys all for being back and ready to roll. All right, we're going to start to hearing from our proponents for changing the Kansas forfeiture laws, and we'll start out with Sam McRoberts, Litigation Director and General Counsel for the Kansas Justice Institute, and welcome to the committee.
Thank you. I am Sam McRoberts. I am the Litigation Director at Kansas Justice Institute. I had the pleasure of sitting on the subcommittee over the last 3 to 4 months. And I had the pleasure of listening to Judge Sexton prepare his comments and explain to you all kind of how the committee met and what the agreements were, what the disagreements were. And I think after his conversation, I just kind of tore up my written remarks because he covered almost everything that I had planned on covering, but in a really good way. And so one of the things that I would really like to highlight before I get into Kansas Justice Institute's position is I thought that the report was really well written in this sense. I thought it did a very good job of explaining the different viewpoints between law enforcement and Kansas Justice Institute and criminal defense lawyers and bids. And the report did a great job of explaining positions and kind of the nuanced arguments that were made, and also maybe some not nuanced arguments. And so I think that the report kind of set that all out there for you all to read. And I think having the report is very important because it helps kind of see what all these different viewpoints are. One of the things that Judge Sexton mentioned was page 5 in the report. And I think it's really important to kind of go to that because that really sets the tone for what I think is going to happen this afternoon. So in the middle of page 5, the report says, and I'm not going to read everything here, but on one side of the debate are those who believe it is fundamentally unfair for the government to be able to take and keep a person's property without proving that the person had done anything wrong. That's Kansas Justice Institute's position. That's been our position from the very beginning. We were the ones who initially drafted HB 2380. That remains our position today. What I also think is true, and I think it's accurate, that there are not enough procedural due process rights for innocent people. That, in short, it's too easy under current asset forfeiture laws in Kansas to take a person's property. It's too easy for the government to take a person's cash. And the way that the whole system is set up, in our view, is stacked in favor of the government. So what initiates the initial seizure is really just a probable cause determination. And once that determination is made by law enforcement, the forfeiture process essentially begins. And I'm going to cite to you a couple of law review articles and other things, but I'm not the only one who believes that the protections aren't good enough in Kansas. Yes, there are protections here. I believe the opponents to reform are going to say, look at what is in the statutes. It's true, there are some things in the statutes that at least make it appear that there are protections for innocent owners. But at the end of the day, it's not enough. It's not enough, especially when you consider the amount of defaults that are happening, which Judge Sexton mentioned, which the report says. We all agreed that that's a problem. And I think that at the end of the day, there are common sense solutions to fixing forfeiture, which is a problem. Some of the things that I hope this committee and other legislators consider is, again, the number of defaults. It's incredibly high. Law enforcement acknowledges it's high. We acknowledge it's high. It's troubling. But when you drill down into the actual forfeiture regime, it's complex. Imagine if you got stopped by the Kansas Highway Patrol, you didn't have an attorney, and you tried to fight the state of Kansas over $800. Take a look at the actual statutes. I've read the forfeiture statutes time and time again. They're not intuitive. They don't make sense. There are terms of art that mostly law enforcement understands because they've been doing this year after year after year. And private attorneys don't have the experience to defend people in a forfeiture case. I think one of the things that I thought was very interesting when we had our meetings was it would be difficult to find attorneys to handle forfeitures. I mean, that is a very big deal that there are not enough attorneys and there are not enough attorneys who are willing to help out people who have had their money taken. And some of it has to do with how Byzantine the process is, how difficult the process is, and how, again, that Judge Sexton pointed out, the average worth was around $3,000. It would be almost impossible to find an attorney to do that type of case. It's also not a fair fight. If you look through the statutes again, and I would encourage you to read every single one of the forfeiture statutes, it's not a fair fight. It is set up to favor the government. It just requires the notice of pending forfeiture, and then now the burden shifts to the person to try to prove their innocence in court. For some people, it is incredibly scary to go to court at all. Imagine trying to go up against the government to prove your own innocence. You have no idea the rules of evidence. You have no idea about the rules of civil procedure. You have no idea how a trial works. You have no idea how to try a case to a judge. You have no idea if the judge is going to be impartial or not. You have no ability to demand a jury trial. You don't have the ability to have a jury of your peers sitting there as a check against the government. That's one of the things that we've talked about since the founding of America, a right to a jury trial, the right to have your peers, your neighbors sitting in judgment. We don't have that ability in Kansas because of the statute. I think a common refrain this afternoon and a common refrain throughout the last couple of years and on the hearings for 2380 is that law enforcement believes that this is a tool to disrupt criminal enterprise, that is a critical tool, and that it's a tool that should not be amended or changed or really messed with, that the status quo is good enough. And I think my ears perked up when Judge Sexton said, oh, I'm sure Sam McRoberts wants to come up and grab the microphone. And it's true, I did. I wanted to do it right then, but I had enough self-discipline to wait. This is a report from Institute for Justice, and the title is, Does Forfeiture Work? So it's right here. Does forfeiture work? That's the one thing we're going to be hearing about today and again over the next several months. And law enforcement will say we need to have this tool. And before I go any further, we're not suggesting that forfeiture should completely go away. We're not suggesting that forfeiture should be abolished, but it needs to be fixed. So again, does forfeiture actually work? On this report, under the analysis and results, it says, my analysis finds no material evidence that forfeiture increases police effectiveness or reduces illicit drug use. The relationships between forfeiture and these outcomes are weak and statistically insignificant, with one exception that links increased forfeiture to decreased clearance rates for violent crimes. The entire report goes through, it follows 5 different states. It talks about the effects on forfeiture on crime clearances. The data is here. The data finds no meaningful relationship between forfeiture revenue and police effectiveness. So the question remains, is it a valuable tool for law enforcement? I would concede that in some instances it is a valuable tool, but not the way it's being used in Kansas, and not especially when you consider this report, does forfeiture work? I think the problem is that in our review, forfeiture is almost used indiscriminately in Kansas. That's the number of stops on I-70, the way that it's just probable cause that initiates this, and then all of a sudden, once the forfeiture is initiated, then again, it's incredibly difficult to counteract what the government is arguing, because you have to prove your own innocence, which is in some ways nearly impossible. How do you prove your own innocence? Another common argument that law enforcement will use, which I think is, it should be carefully considered, and in some ways, I think the argument makes sense. they will say, well, what if somebody dies during the pendency of a forfeiture? Or what if somebody absconds and here we have this bag of money? What are we supposed to do with it? Of course, we should be able to seize and forfeit that money. I think that is a worthwhile point to consider and discuss. And I think that there are very easy ways to deal with that very specific scenario. I think the legislature can fix that. They can close that loophole so if somebody does abscond or if somebody does die, there's a way that the government can forfeit that money. But what I don't think is that that is a sufficient reason to continue this current asset forfeiture regime. That's not a good enough reason to have 80% defaults. That's not a good enough reason to prevent jury trials. That's not a good enough reason to have an innocent owner trying to prove their own innocence in court. I suppose there's could be a criticism that it's just special interest groups who are up here saying, oh, we need to fix asset forfeiture, but I reject that. And the reason I reject it is because it's not just Kansas Justice Institute who is trying to reform Kansas asset forfeiture. And I think there are two very important law review articles that this committee should consider. And I think the title of the law review articles are instructive. The first one is Kansas Standard Asset Seizure and Forfeiture Act, an ancient and failing approach. An ancient and failing approach. This isn't a special interest individual who is writing a letter to the editor. It is a scholarship on the history of forfeiture, the history of Kansas, and suggestions to make it more in line with due process, to make it fundamentally more fair for those individuals who get caught up in this process. The next article is also a law review article. Again, the title is instructive. The Silent War on Individual Property Rights, the Necessary Reform of the Kansas Standard Asset Seizure and Forfeiture Act. The necessary reform. As you can see in my written testimony, I quoted from that law review article, and I think it nicely summarizes the opposition, or excuse me, the support for forfeiture reform. And this is from the law review article. As it currently stands, the Kansas Forfeiture Act is unjust and perverse. It incentivizes law enforcement agencies to take property from innocent persons, fails to reflect the basic purpose and intent of civil forfeiture, fails to protect innocent owners, fails to reflect the values and interests of society, is ripe for abuse, and does nothing to prevent law enforcement agencies from bypassing the protections within the act. That's not a special interest group writing that. That's a law review article. I think for all of the reasons that I put in my written testimony, for all of the reasons that were discussed within the subcommittee, there are really good, solid changes that should be made to Kansas asset forfeiture. I'm not going to go through all 10 or 11 that were contained within 2380. I think that'd be repetitive and probably not useful for this court's time, or excuse me, for this committee's time. But I do think a couple are worth highlighting. One, absolutely the burden of proof needs to be increased. If the government is going to take somebody's property or take somebody's cash, they need to be able to prove that beyond a reasonable doubt. And if the committee doesn't feel comfortable with proof beyond a reasonable doubt, then the next highest level of proof needs to be imposed. There also needs to be thresholds. As Judge Sexton mentioned, if the legislature imposes thresholds, that's going to stop, depending upon the number, 50% of the seizures and forfeitures in Kansas. That would be a fundamental change that would help all Kansans. A jury trial right. Again, individuals need to be able to be judged by a jury of their peers, by their neighbors. This one, I hate to bring up because it makes me look like a shill for attorneys, which I'm not. But the attorney's fees provision, I think, is very, very important in this type of case because as Judge Sexton mentioned, as the report mentions, as other data suggests, if the average forfeiture is $3,000, it's going to be, or roughly $3,000, it's going to be nearly impossible to get any private attorney to help even the absolute most innocent person in Kansas. They can't afford to do it. They can't afford to represent that individual, and the individual can't afford to pay for that attorney. And the way that the statute is written now, the government can actually seek attorneys against an individual if they win in court. But if the pro se individual wins, they would not be able to seek attorney's fees. That's just one example of how this system is tilted against private individuals in Kansas. So we think that would be a good common sense approach to making the system more fundamentally fair. I'm happy to stand for questions.
All right, thank you, Mr. McRoberts. Committee questions. Representative Lewis.
Thank you, Mr. Chairman. Real quick, who authored the law review article that you mentioned?
So there are two law review articles. I mentioned both. The first one is Amelia Self. That was in the University of Kansas law review. The other one is Alyssa Ellis, and that was in the Washburn Law Journal. And I have cites as well that I can provide either now or.
Thank you.
Additional questions? Senator Haley.
Thank you, Mr. Chair, and thank you for the thorough review that you've brought today. Beyond speaking to whether or not we go from the reasonable doubt, clear and convincing, let's see, the other element, I should have written it down, the jury, speaking to a jury trial, but, the seizing agency. Was there any discussion or any contemplation in any of the law review articles that you've presented or in other discussions regarding ensuring that the whatever's seized doesn't stay within the seizing authority or going to some other entity? If you understand what I'm asking. There's been some discussion of that, and as a fallback, or in the event that everything we know is still implemented again, at very least, is there some discussion, or can you add to that discussion as to where that which is seized, currency or property, would go to some other entity?
The short answer is yes, that's discussed in the law review articles. The medium answer is we did talk about that in the subcommittee. The longer answer is, and this goes back to Judge Sexton when he mentioned the appearance of impropriety. When the agency is able to use the cash that it seizes and forfeits, it does give, at the very least, the appearance of impropriety. Now, I have great respect for Kansas law enforcement, and I think that the best way to describe it is the appearance of impropriety. And I think because that money could be used to purchase items for law enforcement purposes, it creates this really bad perception. It creates a really bad perception in communities where forfeiture is being used aggressively. And I think that if you knew people who are getting things seized and forfeited, I think your natural inclination would be, well, they're going to use that money for law enforcement purposes, so of course they're going to do this. If it's a borderline call, they're going to make the call in favor of forfeiture because they get to use that money later. And so, again, great respect for law enforcement, but it certainly does give, at a minimum, the appearance of impropriety.
Okay. Thank you for illuminating, Mr. Chair.
Thank you. Representative Resman.
Thank you, Mr. Chairman. You mentioned about how law enforcement can spend the money. Is there anything in statute that would spell out what the funds can be used for?
I believe that there are things contained within the statutes that allow, or that would kind of dictate how law enforcement can use that, but I know Director Mateve is going to come up, and I'm sure he will talk about that, and I trust him to be able to articulate what those are in the statutes.
Natalie, do you want to pull that up from your presentation real quick and just share what that list is?
Sure. So, Mr. Chairman, my memo doesn't go through the specifics, so let me kind of find the statute, and I can send that list to you.
Very
guys.
good. Thank you. Additional questions, committee. Representative Mon.
Thank you, Mr. Chairman. First of all, could you kind of tell us a little bit more about what Kansas Justice Institute does so that we know the context from which your testimony is coming?
Kansas Justice Institute is a free law firm dedicated to pushing back against government overreach. We file lawsuits against, we filed a lawsuit against the state of Kansas. We have one pending right now. It's at the 10th Circuit. We file lawsuits against municipalities for government overreach. We comment on matters of public concern. I've written about forfeiture in, I think, the Kansas City Star, the Cap Journal. We do litigation by letterhead, meaning we will send letters to government agencies or municipalities, or if we believe that they're violating the law, but we think we can correct the issue without having to engage in unnecessary litigation. We're part of Kansas Policy Institute.
And follow up, if I may. And I think I know the answer to this, but for the non-lawyers on the committee, what other civil law cases, what is the right for jury trials in other civil settings?
Mr. McRoberts, would you pull that microphone right in front of you for me?
Yes, I talk loud, so I didn't want to blow out everyone's eardrums.
Well, but that's how everybody online can hear as well.
Okay.
So, thank you.
So the question is essentially, how are jury trials given in other matters? That's a really great question that requires a complex answer. There are constitutional rights you have the United States Constitution that talks about jury trials. You also have a Kansas constitutional right to a jury trial. There was a case a few years ago by the Kansas Supreme Court discussing the right to a jury trial. And just recently, there was a case out of Indiana, I believe it was the Indiana Supreme Court, that said you do have a right to a jury trial under the Indiana Constitution, because at the time of the Indiana founding, there were jury trial rights for forfeitures in other jurisdictions and similar type of matters in Indiana. The Indiana Constitution is very similar to the Kansas Constitution, so I think you can draw conclusions from that case that from a legal perspective, not a policy perspective, from a legal perspective, Kansas should provide jury trial rights under the Kansas Constitution, and that the bench trial only requirement under forfeiture is unconstitutional. But that's a separate question from whether or not it makes good policy sense.
Additional questions, committee? Senator Warren.
Thank you, Mr. Chair, and thank you, Mr. McRoberts, not only for testifying today, but your participation in the subcommittee as put together by the Kansas Judicial Council. As you know, the report of that advisory committee was accepted by the Kansas Judicial Council, but without recommendations, kind of leaving it open for policy discussion. And one of the policies that you discussed today, and a couple of things that might be looked at for reform, was increasing the burden of proof. We heard some prior testimony about shifting the burden of proof from the innocent property owner having to prove, and in fact, I think you talked about it a little bit, having to prove their innocence rather than the burden being placed on the government to prove. We're in civil court, so it's not really guilt, but to prove liability, I suppose. And I think most Kansans, recognize, well, you're innocent until proven guilty. And so could you talk about maybe that shift in the burden of proof that we've seen other states enact in law?
Yeah, so I think that it's an open policy question on what's the best way to deal with these types of matters. The cases are at times grappling with, should the government have the burden of proving something? But in this matter, in forfeiture cases, we are resolute. If the government's going to take your money, if the government's going to take the family car, they have to be held to a strict burden of proof. They should not be allowed to come in with an easy burden and be able to prove their case. It should be difficult for the government to try to take the family car. And so from a policy perspective, we would urge the committee to impose the strongest burden of proof that the legislature can agree on, which we believe would be proof beyond a reasonable doubt.
That's a little bit what I was asking. That's kind of what is the standard of proof, but who bears the burden of proving it? And right now, the property owner bears the burden of proving whether it's preponderance of the evidence, clear and convincing, or beyond a reasonable doubt that they and their property were innocent of what the government is alleging the crime was. What's your position on shifting the burden to the government of proving your, again, not guilt, but your liability? And if the government doesn't meet that burden, then the government hasn't won its case and doesn't get to keep the seized property.
I'm sorry that I wasn't articulate enough about that. Our position is the burden should not shift to the property owner during the case unless the government can prove something which would be difficult on the front end, that the burden really should always remain with the government. So in your scenario, if the government doesn't meet their initial burden of proof, the family car should be returned to the property owner. They shouldn't have to put on evidence or put on their version of the case. The burden needs to stay with the government to prove their case.
Thank you, Mr. Chair. May I ask a question of the revisor? Just for clarification, I think we heard earlier from the revisor, but I just want to make sure that currently in Kansas law, where does the burden of proof lie? With whom? Does it lie with the government? Does it lie with the innocent property owner to prove? And what's the proof? I think we heard that the proof was the innocent property owner defense was you've got to prove your innocence rather than the government prove your liability.
Sure. Thank you, Mr. Chairman. So the current statute requires first that the state prove by a preponderance of the evidence that the property involved is subject to forfeiture. And so once that happens, then a claimant can come in. And then if they are trying to claim an exemption, they would be required to prove by a preponderance of evidence that the exemption is valid.
And so the original preponderance of evidence proof is once the forfeiture case has been started by the government?
Yes, yeah, that's the standard for the court to make a determination that the property should be forfeited.
Okay, and then you've got to, within the parameters of time set forth in the act, make your claim, well, no, it's innocent property and I should get to keep it.
Right, yes.
Okay,
so in a case where there are no claimants, there's no one coming forward to claim an exemption or no owners or interest holders coming forward, then it would just be the state has the burden of proving by a preponderance that the property is subject to forfeiture.
Okay, thank you. May I ask another question? Well, thank you. Mr. McRoberts, we heard a couple of folks talk about these phrases that I'm going to repeat, appearance of impropriety and policing for profit. Do you have any facts? Are there any reports about how once the currency or the property is gone through the process and retained by the government, how is it spent? Do we have any information about that? Is it spent for, to educate folks about drug addiction, how not to fall victim to drug addiction and how to fight that? Is it spent on local policing efforts? Is it spent on more patrol cars? Is it spent on more hiring of officers? Do we have any information about how that money is spent?
I'm not aware of a repository or a database that would show exactly how the government is spending that money. I think that that's a question that the public should be asking. They should be asking, where does this money go? How is it being spent? What is it being spent on? And why is it being spent? But I do not have that information.
And you don't know where that could be found publicly available?
So Institute for Justice has written reports. One of them is titled Policing for Profit. It was discussed at the subcommittee, but that is a bigger view of forfeiture, not necessarily specific to Kansas.
All right, thank you. Thank you, Mr. Chair.
Certainly. Further questions, committee? All right, seeing none, Mr. McRoberts, thank you very much. Natalie, do you have a follow-up for us?
Sure, yes. Thank you, Mr. Chairman. So the list of appropriate uses for the asset forfeiture money, I just sent that to Natalie Nelson. It's in that statute that we talked about during my brief, 60-4117, but I didn't include the specific list in my memo. So I sent a copy of that statute to Natalie with that list highlighted. There's 12 different things, so I don't think you want me to read them all aloud to you, but she can send that out to you and you guys can look through those.
Excellent. Thank you, Natalie. All right, we'll now hear from Greg Glod, Senior Criminal Justice Policy Fellow, Americans for Prosperity. Normally those have to be turned in ahead of time, but if you have enough for everybody.
I do. We can wait for it and.
Oh, that's all right. Go ahead. Natalie will help get those things disseminated. Please make sure that you send digital copies of those, though, to our committee assistants so that we can get those uploaded for public records.
Absolutely. Well, thank you, Mr. Chairman. As you said, I'm Greg Glod. I'm the Criminal Justice Fellow for America's Prosperity. I run our public safety and criminal justice portfolio at our headquarters in Arlington, Virginia. I think you all know my colleague, Jonathan Luth, who works here in Kansas as a deputy director here for our organization. I don't want to go over a lot of the same stuff that's already been said. Really wanted to first say that I think we're all here for the same reason. I thank you all for having a special committee on this. We all want public safety. We all want less drug use. But we also want to be mindful of, constitutional protections for people. And, John Locke said we have, inalienable rights, and that's life, liberty, and property. And property was put on that same level. But for life and liberty, we have a robust criminal system that provides substantial protections and due process for individuals, while property does not. And I think that's really where the disagreement goes, is the process that's currently due for this civil proceeding for the government to take your property. Is it enough? Is it necessary? Is it due process for an individual? Or is it not? And I think that's really where the differentiation goes. I don't think anyone's anti-public safety. I don't think anyone's anti-law enforcement. I think we're all here to do the same things and make sure our communities are safe and that people are being deterred from criminal activity and behaviors that are negative, like drug use and things like that. So I'll touch on a few things on that where I think that civil forfeiture is kind of failing on those purported goals. And then I'd be happy to answer any questions. And so I really want to touch, and I know Sam brought up this study from John Kelly does forfeiture work and looking at those 5 states. I just want to mention a couple other things. You look at the purported goals that it helps law enforcement, prevent crime, solve crime, do their job, and it also is a way to deter drug use and drug possession and drug crimes and things like that. What the evidence has shown is forfeiture really does not have an impact on these things. It potentially, as you talked about, could have a contradictory impact on nonviolent crime solving. So as we talked about, the money's not that much. It's, I think the average across the country in 21 states that actually report that is about $1,000 on a median. I know we're about $3,000 to $5,000 here, and so it's a little different, but that's how it is. Even the federal ones, for the DOJ, the average forfeiture is $12,000. I mean, that's a federal case. I mean, and for the Treasury, it's even less. It's $7,000 is the median average. And so you looked at New Mexico, and we kind of heard these same arguments when they passed a law in 2015. Very similar structure as Kansas, where 100% of the proceeds went back to law enforcement. They had a preponderance of the evidence standard, and they completely eliminated civil forfeiture. The money went to a general revenue fund instead of back to law enforcement. And they also put a cap on when you're actually able to do an equitable sharing of that cooperation with federal law enforcement. I believe it was at $50,000 or more until you could actually cooperate with the federal law enforcement on those things. You can still cooperate, it's just you couldn't forfeit the cash and put it back into your deposit boxes or put it back to the general revenue fund. And so there was a lot of concern and opposition saying that this is really going to hurt law enforcement. What we've seen has not happened. And so in that study, they looked at the crime rates in Texas, Colorado, and New Mexico, 2 bordering states. Texas uses forfeiture almost more than anyone in the country. And so we really wanted, the study really wanted to see, okay, these 2 states have not done anything to their forfeiture laws. This one completely shifted away from civil forfeiture. Crime rate stayed steady in each one. There was no impact from forfeiture on the crime in New Mexico as compared to Texas and Colorado. And then they even actually looked at neighboring counties on those 2 sides and saw no impact on crime, where you'd you'd think you'd see a lot more like on those neighboring counties. And so on both instances that happened. And what they looked at really was, did the amount of crimes rise? No. And did the amount of arrests go down? And that wasn't the case either, because the argument is that we'll have less resources and tools in our toolbox to actually solve or clear crimes. And arrests did not go down in New Mexico. So they're arresting the same amount of people. Crime did not go up as compared to other places that had not changed their forfeiture laws. So I think that's really important to see an actual effect. I mean, that's been 8 years now. And so I think that's a pretty robust set of data that we're looking at. I wanted to mention another study that actually the one that Sam went through, and just touch on a couple other things, particularly on drug use, because that was a big, argument that we're actually going to, fentanyl is a major issue. This is going to be a way to get into the cartels, stop drug use, and stop this scourge in our cities and streets and communities. This study looked at these 5 places that look at forfeiture. It did not lead to a decrease in drug use. And actually, when you saw unemployment go down, which is a major indicator of economic health, you actually saw an 11 to 12% increase in the amount of forfeiture activity from these jurisdictions. And so you're actually seeing a connection between unemployment in this, and rather than the actual stated goals of forfeiture. And so, again, I think it's getting back to, this is a necessary tool to keep, but we need to make sure that we're getting the right people, and it's actually getting these goals and setting law enforcement up to actually have those tools in the toolbox that are effective at reducing crime. And so I think it gets back to another argument. I was reading through testimonies and things like that. The funding is a huge aspect where this is necessary funding. I've seen KBI testimony, I've seen other testimony, and I agree. We need to support our law enforcement. We need to fully fund them. One of the documents I'm sending you around, and you can find this also, and I'll send it also on endviolentcrime.com. It's a part of a coalition that we're a part of that has 4 stated principles on how to reduce violent crime. And our first principle is, let's support the police and let's fund them properly. I live in D.C. I've seen the horrible effects of what happens when you don't fund your police properly. We're about to hit 1,000 carjackings. We're actually going to surpass Baltimore in murders this year, which has not happened in decades because of the way that they support their law enforcement and how they literally did defund them there. Some people talked about it. D.C. actually did it, and you're seeing the results of that. So we need to fully fund our law enforcement, but we should not be funding them from these sources from fines, fees, and forfeitures that we actually require law enforcement to enforce. They should be coming from a fully transparent budgetary process, and we should give them those tools. We've worked in other states like Ohio and Tennessee where we have supported budget increases for things like training, mental health training, mental health uses for the law enforcement themselves. I think that's something that really gets lost in a lot of this. It's a highly stressful job. My dad was a cop. I know the stress that he went under. I saw the strain that it had when he was out on overtimes and things like that. We need to make sure that we are giving law enforcement the proper tools, how to deal with different situations. If there's a kid with, mental issues in the house and he's going in there, how do we train law enforcement properly? Getting money for these types of things, it's not what's helping. We need to actually fully fund law enforcement through a transparent process, not through fines, not through fees, not through forfeitures. Let's do that. Let's support them. That's something that this legislature and this body and local jurisdictions can absolutely do. And so we've supported those types of grants and increases, like I said, in Tennessee and Ohio, and I'd love to discuss that further with you all. And like I said, our 4 principles are right there. And so I'll just end kind of on that and see if there's any other questions here. Like I said, generally, I think we're all here for the same reasons, and we really want to see a reduction in crime. We want to support law enforcement. We want to make sure that they have the tools that they have, but I think that we are just using this in ways that deprive people of their constitutional rights, and it's actually not getting the impact that we have. If the government's going to take someone's property, let's make sure that process really protects the rights of that owner as full as we can without actually undermining the efforts of law enforcement. I think that this body can really find that balance, and other states have. So with that, I'll end, and I'd be happy to take any questions. Thank you.
Absolutely. Committee, do we have questions? All right, seeing none. Thank you very much. Oh, Senator Warren has one after all. Not quite so lucky.
As usual, right?
No, you're good.
Thank you, Mr. Chair, and thank you for your testimony today. The legislature this session in particular took action to help fight the fentanyl crisis, and I think I don't want to say unanimously, but pretty darn close on regarding fentanyl test strips, increasing the level of crime severity regarding fentanyl, especially if you're making it look attractive to children, you know, rainbow-colored pills and things like that. So it's something we took big action on this last session. Do we have any evidence as we're fighting this that from other states, from our state, I mean, we've had this law in place for almost 30 years, that it's an effective tool to stop the drug trade, as it currently is in statute?
Right.
Forfeiture, not the drug trade.
Sure,
I mean,
sure,
so.
yes, yeah. I mean, really, no. You know, you're looking at the types of values that you're getting out of this. This is not going to hurt cartels that are making billions and billions of dollars each year, a $6,000 bust here and there. And so when you're looking at those types of medians, it's just not happening. And like I said, the studies that, Sam had mentioned and I did showed that it did not lead to any types of, decreases in drug use or something like that. The things that really do work are ensuring that large suppliers that are coming from, the borders in China and Mexico, and I can get into a lot of the fentanyl stuff and how it's actually getting into our country. It's pretty terrifying, actually. I hear these stories. I've talked to Border Patrol, about where they'll get a call to get pinged that someone has 2 kilos of fentanyl going over the border. They'll arrest them because there's 10 coming behind it. This is just the cost of doing business in a lot of these places with the amount of things we do. The things that we do know work are increasing treatment and ensuring that people are actually getting the help that they deserve. I think the judge brought it up earlier where, we're actually just removing a couple $100, $3,000 from someone that if we do think that they actually are a user and are going to be helped, they're going to get their fix one way or the other. So they are going to fundraise for that one way or the other, either from drug dealing or something more violent. And I think we're seeing that in a lot of cities where people become incredibly desperate, particularly from fentanyl, because it is that dangerous and it is different. It's different than any other drug that we're dealing with. Heroin doesn't really exist on the streets anymore because fentanyl's overtaken it. It's not that it's getting, flipped into something. It is the drug of choice now. And so what we're seeing actually, as for decades long, as forfeiture has been implemented, the drugs have gotten cheaper, they have gotten stronger, and more people are dying. And so obviously something else needs to happen because we're failing at all three of those points. We don't want people to die and we want people to be prosperous. And so we need to look at that. And, I'm looking at page 6 and 7 of the KBI report on the state expenditures. The vast majority of it's going to vehicles, overtime, salaries. There's one large expenditure that maybe we can ask some of the law enforcement representatives here on evidence purchase funds. And then I look down to prevention awareness programs. In 2022, it says about $20,000. And so that's coming from the forfeiture money. And so if we're really serious about doing this and we don't do anything else, maybe all this goes towards treatment diversion, drug course therapy, things like that, at the very least. Things that we know that are effective, using medically assisted treatment within prisons and jails, and so people aren't just rotting out in a corner of the cell and then just being kicked back out where they're going to get their fix again. Those types of things are effective at preventing and treating crime. We have to start on the demand side as well as the supply side, and we don't do enough on the demand. So hopefully that's something that we can, look at as well as we go through the session.
And could I ask just for some clarification?
Sure.
Thank you for that. You talked about when the unemployment rate goes down, and then you talked about crime goes down as well, or it goes up, and how does this play into civil asset forfeiture?
So the study looked at when unemployment decreases, does forfeiture activity, essentially, are we raising more revenue? Because unemployment is a really good indicator of economic health and how much revenues and things are going towards government. So when unemployment was decreasing, you saw this increase in forfeiture revenue. So every 1% of unemployment decrease, you saw an increase in forfeiture activity of about 11 to 12%. Now, people can make other distinctions on that, and maybe there's other conclusions, just relaying the information that was provided to it. That was what the methodology looked at. It's objective numbers, and you can put your interpretation on it, but we saw that across those 5 states, that was the average increase. And so something is, I believe that there's a relationship there, but you can take that with your own interpretation.
Okay, thank you for clarifying that
Sure.
again.
Thank you.
Thank you, Mr. Chair.
Representative Lewis.
Thank you, Mr. Chairman. Just following up on that, the studies that you've mentioned, I think maybe 3, how do I access those?
I will send those all along. All of them are linked within my testimony, but I will send the separate copies as well.
Thank you, Mr. Chairman.
Certainly. Additional questions? Representative Carr.
Thank you, Mr. Chair. I'm curious if you have any information on whether or not, do you see an increase in the amount of seizures with relationship to the dollar amount seized? Does it go up exponentially? In other words, if there's an area or a particular department that does an enormous amount of seizures, I can see how that would also mean that the dollar amount of those seizures would go up, or so it should. But one would question that if seizures were actually being done evidence-based, then some jurisdictions that would have a lower number of seizures would then quite likely have an equivalent dollar amount. Do you show any relationship there with the number of seizures versus the total dollar amount?
That's a really great question, and I don't know if any data's really looked into that, but I think what you're getting at is almost like the quality of the seizure rather than kind of casting a net. Yeah, without knowing if there's data to show that, I would assume that places that are actually spending a little bit more time on longer investigations when they're given that right to do more surveillance, to pickups, are getting larger amounts, even if they're doing less ones. So more quality than quantity, but I don't know of any information. I will take a look at that and definitely get back to you, Representative.
Thank you very much.
Thank you.
Thank you, Mr. Chair.
Yep, certainly. Senator Warren.
Thank you, Mr. Chair. Just to follow up, you've studied other states and how civil asset forfeiture has worked in their states. We saw here in some of the reports that the majority of initiation of the taking is a highway stop or a street-related stop. Is that the same in other states or not?
That's a pretty par across the board. It's that some areas, a lot are done at airports. I know in Illinois, there's a lot of the adjoining counties there. I used to work with a police chief from Peoria, and they would do a lot of interdictions at O'Hare or Midway. They would actually go there, which has its own huge issues as well. And that's some of the stuff with the cooperative things. You know, you kind of get ping pong back and forth between the local issues and then the federal ones, and you don't really even know where to challenge it. But that's a whole other can of worms that we can get into. But that's pretty much across the board. And then also the reporting does a really great job of seeing what the instant either offense or the reason for the taking. And it's in that report from KBI. I think the vast majority were either drug possession or drug dealing in some way, probably from a quantity standpoint on that traffic stop. So it really is targeting traffic stops where some sort of either amount of drugs are found or none are found, but it's alleged that the money is connected to those drugs. So I think that's the vast majority in Kansas and across the country.
And you mentioned getting the federal government involved, and there's some discussion at the advisory committee for the Kansas Judicial Council about should there be thresholds before you can bring in the federal government unless it's a joint task force already. And how have other states handled that? Because sometimes if you don't have a prohibition against turning over the property to the federal government, then how does that tie in with the state procedures? If we keep the act as it is, if we reform it, whatever the legislature does or doesn't do, the legislature, wants the law to be followed and not circumvented. Is there evidence in other states that turning it over to federal helps circumvent the state procedures, or how does that interplay work? If you could speak to that for a minute.
Certainly. So on the first point, there are other states that have looked at this and tried to kind of close that loophole or at least minimize the loophole, because there is a big word of caution in states that have not really touched equitable sharing, that have done things with forfeitures. I know we got evidence earlier that very few federal forfeitures are being done right now. I think mainly because the bar is so low here, and essentially the way that you execute and adjudicate a forfeiture is almost parallel in Kansas as it is in the federal. When people start raising the burdens and doing things, there is a route to bypass that through equitable sharing, either through a task force or an adoption, where you actually just send this stuff to the feds. They weren't involved with it at all, and then they just take the case and give the money back. And so we've seen an increase in those in places where you haven't really closed that, but in places like Wisconsin and New Mexico that have put those threshold caps on there. I don't think we want to deter, obviously, at all. Federal cooperative agreements, they can be incredibly helpful, particularly when you're looking at violent crime. There was I think I'd urge you to look at some of the weed and seed programs that were going on in the early 2000s that really provided cooperation between federal and local, particularly on targeting violent crime rather than potentially the drug stuff. So we don't want to really interfere with that, but having that threshold, I think, can really help kind of close that, so you just don't essentially bypass state law and the will of the electorate and the voters.
Right, and we want to make sure we, provide for the common good and for law enforcement as best we can and navigate all those issues. So thank you. Thank you, Mr. Chair.
Certainly. Any further questions, committee? All right, seeing none, thank you very much.
Thank you, Mr. Chair.
Absolutely. Committee, John Pollock, coordinator for the National Coalition for Civil Right to Counsel, submitted written-only testimony, which I would encourage you to take a look at your leisure. Is there anyone else here that is a proponent? All right, seeing none, we will move into our neutral testimony and would welcome Director Mattivi, Tony Mattivi, from the Kansas Bureau of Investigation. Welcome to the committee, sir.
Thank you, Mr. Chair. Good afternoon, Mr. Chairman, Madam Vice Chairman, members of the committee, and several friends that I see. Thank you very much for the opportunity to address this committee. I want to start by echoing the chairman's praise for Judge Sexton. He really did an admirable job of reconciling a lot of very vehemently and passionately different feelings about this topic. And he did it masterfully. He was the perfect person to shepherd this particular herd of cats. So he did a very nice job with it. Let me start by saying that there is a narrative that I believe is prevalent among some of the proponents of change that the Kansas asset forfeiture laws are being improperly used by the government to strong-arm innocent property owners. And I believe that that is not the case, and I believe that there is no evidence in the data to support what I passionately believe is a false narrative on that topic. Let me say that there's a lot of misinformation out there about asset forfeiture, and you've seen some of it already today by this idea that's being propagated that the burden is on the property owner when it comes to asset forfeiture. That is not correct, and Natalie explained that already very well, that there is this narrative that the government, through rogue deputies or troopers, is out there just grabbing money and seizing it, and the property owner then has to come forward and prove that that money is not involved in criminal activity. That's actually the opposite of the way the law works. The way the law works is a forfeiture proceeding doesn't even begin until the government proves by a preponderance of the evidence that that asset, whether it's cash, a vehicle, a gun, or any other property, the government has to prove that that asset is somehow tied to illegal activity, either a proceed of illegal activity or something that's being used to commit illegal activity. That is a predicate to a civil asset forfeiture. Okay, so the idea that the burden is somehow on the property owner is a contortion of the state of the law. And I think it's important that we get that out there right away. At a time when Mexican drug cartels are purposely flooding our state with deadly fentanyl, and Kansans, especially Kansas kids, are dying by the dozens from fentanyl, now is not the time to eliminate or even curb one of law enforcement's most effective tools. Now, you asked just a moment ago about whether there is proof that asset forfeiture works. Let me challenge you to ask that. So you've noticed that I'm sitting over here among my law enforcement colleagues, and I can tell you that when the response came from the Washington lobbyist, all the cops around me got a little bit twitchy. let me encourage you to ask the law enforcement professionals who are going to follow me what their opinion is about whether asset forfeiture works, because I think that's something that's important for you to hear before you make thoughtful, reasoned decisions about what to do with the asset forfeiture laws here in Kansas. I should probably explain why I listed myself as neutral on the issue of change. I stand or sit shoulder to shoulder with my colleagues in Kansas law enforcement, with the superintendent of the Highway Patrol, in steadfastly opposing changes to the Civil Asset Forfeiture Act. That said, I had the great pleasure over the last several months of sitting on the committee. I applauded Judge Sexton in the way that he ran it. Nancy did an outstanding job. I had the pleasure of meeting people like Mr. McRoberts, who are not just thoughtful and smart and articulate, but very well-intentioned people. And at the end of the day, we just disagree, right? But the end result of that committee is that we offered, and I support, what I submit are thoughtful, reasonable, measured changes to the asset forfeiture law that the committee believed, and that I believe, increase the protections to property owners without curbing law enforcement's ability to continue using this as an effective tool. So because I support those changes, you could argue I'm a proponent, right? But I oppose any changes beyond what the committee recommends. And to me, the only way to reconcile both being in favor of some changes and opposed to others is to list myself as neutral. I apologize if that misled anybody. I didn't mean to. I was trying to reconcile the nuances of these 30 minutes that I have. The primary area where civil asset forfeiture most benefits law enforcement's efforts to curb criminal activity is in drug trafficking. There's no question that it's not the only purpose. It is used for other crimes as well. But that's really the heart of this. Don't let anyone mislead you. Drug trafficking is a profit-driven activity. The reason we're seeing our state flooded with fentanyl right now is because fentanyl is the most profitable drug that our society has ever seen, okay? Asset forfeiture is a tool to help law enforcement go after those profits. Let me give you a real-life example. Last week, the KBI, along with a number of our law enforcement partners, seized a shipment of drugs in Wichita. Almost 60 pounds of crystal meth, 4.5 pounds of fentanyl powder, and 60,000 fentanyl pills. 13 pounds of fentanyl pills. Okay? The lab hasn't told us yet what the purity of that powder is, but depending on where that analysis weighs out, that was about $1 million worth of drugs in Wichita, Kansas, last week. This isn't a problem that is affecting other people. It's a problem that is affecting our communities, and that's why these people are so passionate about this issue, and that's why this group of folks showed up in force to testify today. Now, think about that shipment. Interrupting that shipment helps law enforcement fight this battle. Arresting people helps us fight this battle. But seizing the profits from drug sales, seizing the instrumentalities or the items used to traffic those drugs, that helps us fight this battle. And that's what the civil asset forfeiture laws allow us to do. Another thing that I want to mention before I get into refuting some of the other information you've heard today is I want to reject this misused and misleading characterization that we hear of policing for profit. Contrary to some of the flatly wrong assertions that you've heard in the course of this debate by special interest groups, law enforcement doesn't profit from asset forfeiture. Natalie listed the statute. I encourage you to read it, because if I'm going to get through all of the stuff I want to talk about in 30 minutes, I can't list out for you all of the appropriate and permissible uses for asset forfeiture funds, but they are tightly prescribed. And there was a conversation earlier about whether there is a repository of how these funds are spent. And the answer was there's no repository. And I don't want anyone to take away from this debate the idea that somehow that information is hidden from public view, that law enforcement doesn't want you to know how the money's being spent, because that's not the case. Sheriff Easter, for example, the money that he uses asset forfeiture funds for is listed in his budget, which is an open record. Is there a repository of that information? I'm not aware of one. But is the information publicly available for you or any of your constituents to look at, to scrutinize, and to ask that that department head be held accountable over how that money is spent? Absolutely. I'm going to give you an example of how asset forfeiture funds are spent for the benefit of Kansans. Chanute Police Department does a lot, in fact, a disproportionately high amount of asset forfeiture. And I don't mean that to sound derogatory, because it's not, but they're a department that we looked at that did a disproportionate number of small value seizures. And when we talked to them about why they do that, what we did not find evidence of a police department just grabbing 20 bucks from this drug user here and 30 bucks from this drug user there. What we found was a department that uses asset forfeiture thoughtfully and in a measured way to try to combat drug trafficking in their jurisdiction. What they use those asset forfeiture funds for, though, are things like they fund their canine program. Okay, their drug detecting law enforcement canine program is funded through forfeiture funds. If you take those forfeiture funds away, the chief of that department has two options. He diverts funding from somewhere else, or he gets rid of the program. I submit to you that the better way to fund that program is not through tax dollars, but from money taken from drug dealers that are arrested by the Chanute Police Department. This is a little bit tangential, but we had a discussion earlier about the repository. There was a question from Representative Osman about whether there are any suggestions for improvement. You might not be surprised to hear I have some. This repository was created as a result of this committee's directive 4 years ago. It wasn't funded. It was a duty that was taken on by the KBI, and I wasn't here then, so I'm not sure what the discussions were that led to it. One of the suggestions that I have to improve the amount of data, the reliability of the data, the breadth of the data, is to fund the repository. This is not kingdom building, okay? It doesn't matter to me whether the repository is at the KBI or at the Highway Patrol or in the legislature or at the courts, but whoever is managing, operating, and maintaining that repository should be funded to do that. And the reason goes directly to something that, an issue that was raised by Representative Mon about the number of non-compliant agencies out there, whether they are continuing to do forfeiture and what the ramifications are of that, okay? One of the things that we know from looking at the data is for 2022, there were only 5 departments in Kansas out of the 423 law enforcement organizations in the state. There were only 5 that didn't meet the reporting requirements. 3 of them reported. The only reason they didn't meet the requirements is that the balances didn't reconcile. Okay, so there was just a number difference between beginning balance and ending balance. 2 departments were actually non-compliant. They didn't report. I'm not trying to call them out, and I won't, but they are very small departments who I'm guessing they didn't do any forfeitures, and they didn't realize that they had to submit a 0 report. Okay, but because it's, in my estimation, a part-time department, right? It's very difficult to follow up with them. KBI folks spend a lot of time trying to provide good customer service when it comes to the asset forfeiture database, okay? That takes away from other things that the KBI is able to do. My main suggestion for improving the quality and breadth of data that we have is to fund the repository wherever that repository lives. There was a presentation this morning about trends in the Midwest with regard to asset forfeiture. The thing that troubled me about that presentation is we are seeing, there is a trend there in the Midwest to change asset forfeiture laws. Right now, we are seeing another trend in the Midwest. We're seeing a trend toward decriminalization and legalization of marijuana. To me, the question becomes, should we follow the trend just for the sake of following the trend? Can we? We can. Have we? Not yet. Should we? In my view, no. We shouldn't follow the trend for legalization or decriminalization of marijuana, and we shouldn't follow the trend for taking away law enforcement's ability to effectively use asset forfeiture. Those trends may exist, but to me, they're trends that are not worth Kansans following. There were a couple of stats thrown out earlier that I want to address. Representative Mon asked a question about whether 15% of the asset forfeitures being conducted were being conducted by agencies that hadn't reported and therefore were precluded under the statute from conducting forfeitures. I think we were able to clear up, and I would ask for your agreement, Representative, we were able to clear up that that's not happening, right?
We were able to
Okay,
agree
so
on that.
I didn't want anybody to walk away from this hearing thinking that 15% of the assets seized in this state on an annual basis are being seized by departments that shouldn't be seizing assets, right? That's not the case. The other statistic that I'm concerned about is Representative Mon asked about whether it was true that in only 19% of the asset forfeiture cases were criminal charges actually filed. And we found that that may be true based on the reporting requirements and the timeframes, okay, because I think even Representative Mon agreed that the report had to be filed within 60 days, but I think anybody who's worked in the criminal justice system knows that it takes much longer than 60 days for a criminal case to run its course. So we do have that data. It's actually closer to 70 to 80% of cases in which asset forfeiture is filed and criminal charges are also filed. So not 19, 70 to 80, pretty reliably. There has been some discussion about threshold amounts and whether that would have an impact. The reason that the committee wasn't able to come to a consensus with regard to thresholds is, I believe, because of the completely opposite views on the law, the purpose of the law, and what we're trying to accomplish. One group in the room looked at thresholds from the perspective of what would it take to hire an attorney to enter an appearance to represent the property owner in that case. That's one way to look at it. How much would it take for you to get an attorney involved in a case? I don't think, and I believe my colleagues in law enforcement agree with this view, I don't think that's the appropriate question to ask when determining a threshold amount. To us, the question is, at what amount does an asset forfeiture make an impact? At what amount are you accomplishing the purpose of asset forfeiture, which is to help you address the profit motive of drug dealers? We believe that amount is much, much lower than $3,000. We think it's $250, maybe even lower than that. Again, I would urge you to ask the cops in the room, at what level do they think a forfeiture makes an impact on drug dealers in their community? To us, that's the way that you look at this issue. Not whether some attorney is going to be able to make their BMW payment, right? What is the amount at which that forfeiture makes an impact? To us, that's where a threshold should be set. There is a question here that's not answered by the data. And I think it's a logical question based on the default level. Okay, there is a default level that is pretty substantial. The problem is the data doesn't tell us whether somebody is defaulting because either it's not worth their time to fight it, or it's not worth their money to hire an attorney, which is, I think, what folks on the proponent side of the issue believe, or whether they're defaulting and walking away because it's so clear that the assets are tied to criminal activity that they don't want to fight it, or they don't want to tie themselves to that asset, right? They don't want to claim responsibility for it because it's so clearly tied to criminal activity. The data doesn't answer that question, okay? The folks who are proponents of change, in my view, are advancing to you an argument about how to protect a hypothetical innocent property owner, when I believe that the law enforcement officers in this room would tell you to a person that they're just not seeing those. They're not seeing innocent property owners whose assets are being forfeited. It is a hypothetical concern at best, because when you talk to that Chanute chief, or you talk to the Bourbon County Sheriff, or you talk to any of the law enforcement officials in this room about the forfeitures that they have done, that their department is doing on a daily basis, they're not seeing those innocent property owners. They're seeing drug dealers who, when the sheriff's deputy or the police officer files notice of forfeiture on that property and initiates a complaint or a claim, the drug dealer walks away. That's what they're seeing. There's a question about where the money should go. Should it go to the general fund? Judge Sexton articulated probably far better than I could do what some of my concerns are with regard to fentanyl and fentanyl enforcement, and the fact that we're at the leading edge of a tidal wave when it comes to this drug epidemic. And I'm very, very concerned that we're not ever going to be able to enforce our way out of this problem. So we have to look at other ways to do it. Is funding drug courts a thoughtful, reasonable approach? Funding it with asset forfeiture funds? I'm not going to disagree with that. I think that's a logical argument, right? But if that argument applies to drug courts, it applies equally to drug enforcement. And that's what this money is being used for, okay? Look at the open records. Look at how these departments are spending their forfeiture funds. That's what they're spending it on. Training, equipment, overtime for drug enforcement, okay? So we may not be able to enforce our way out of this problem, but that doesn't mean we give up. And maybe we should look at using some of this to fund drug courts. I'm not going to object to that, and I'm not going to argue with it. I think it's a thoughtful approach. But if the approach applies to funding drug courts, it applies equally to funding drug enforcement. Mr. McRoberts, one of the comments that he made that I feel like I have to address is on page 5 of the report, he said, it's wrong to take someone's property without proving that they did anything wrong. I don't think there's anybody in this room who would disagree with that statement. But that statement is not an accurate representation of the law or of the process. I mentioned already, an asset forfeiture case doesn't get filed without the government initially meeting the burden of demonstrating that that property, not the person, but that property is tied to a crime. That's the difference between civil asset forfeiture and criminal asset forfeiture. In criminal asset forfeiture, which the state doesn't really have, but the feds do, you have to connect the person with the property and the crime. In civil asset forfeiture is a recognition of the fact that sometimes these organizations, not sometimes, almost always, these organizations are smart enough to use property that can't be attributed to them, right? That's one of the reasons civil asset forfeiture laws exist. And I'll use last week's arrest as an example, okay? The organization responsible for that huge shipment of drugs into our state was smart enough not to put the name of the drug dealer on it. That's why we have asset forfeiture statutes, and that's why it's so dangerous to tie civil asset forfeiture to a conviction. Even though we see it 70 to 80% of the time, If we mandatorily tie them together, it takes away our ability to get after things like that organization that shipped that huge load of poison into our state last week. So nobody's going to disagree with the statement that it's wrong to take people's property without proving that they did anything wrong. Okay? That is not a reflection of the way this actually works. That's the difference, to me, between hypothetical and reality. I disagree with Mr. McRoberts that this system, his representation, this system is set up to favor the government. I think that ignores the very robust set of due process protections that are already built in to the Kansas Civil Asset Forfeiture Act. I join him in his request that you please take a look at the statute. It is dense and it's difficult to navigate, but that's because, in my view, it is tightly written and it narrowly prescribes what the government is able to do. Could we improve it? Yes, and I think that's what the committee has done. The committee has given you some thoughtful recommendations on how to improve the system that based on the unanimity on the committee, neither side disagrees with. Both sides support, right? Any good system can be improved, and I think that's what the committee's report has done. The troubling thing about this hypothetical argument concerning innocent property owners is, in the view of the proponents, there are so many of them out there that we need to adapt the system and change the law to protect them. That begs the question, why haven't we heard from any of them? If there are so many of them out there, why isn't any single one standing up here at the podium or appearing before any other committee constituted by this legislature or at any other hearing to talk about how the Kansas asset forfeiture laws were abused to deprive them of legitimately owned property? We haven't seen any of those. Given the arguments of the proponent that there are so many of them out there that we need to change the law to protect them, where are they? Mr. McRoberts talked about helping protect that person from having the government take the family car. Man, that goes right to your heart, doesn't it? Nobody wants to see that. Everybody in a public position of trust wants to help that person. That's not what we're seeing. We're not seeing the family car being taken from anybody. More than that, the system is set up to protect that family. Okay? Those protections are already built in. It's the innocent owner defense, right? And it's just like the criminal law. Once the case is filed, if the defendant has a defense, the defendant can bring that defense before the judge and the judge makes a decision. It's not burden shifting. It's the same way it works in the criminal system, okay? We're not seeing law enforcement take the family car. We're seeing law enforcement take the drug dealer's car, okay? That's what he drove to get to the sale where he sold those fentanyl pills to that person. That's what forfeiture is for. Now, if his mom or his dad or his wife or anybody else comes forward and says, hey, that's my car, I didn't know he was doing that, that person is already protected under the Kansas Civil Asset Forfeiture Act. Let me just close by addressing one last of Mr. McRoberts' arguments, and that is, this is a fundamental change. What he's asking for, House Bill 2380, is a fundamental change that would help all Kansans. I submit to you that is not accurate. It is a fundamental change that would help drug dealers, human traffickers, and other people against whom the asset forfeiture laws are being used. We are not seeing it used against innocent owners. Protections already exist under the statute. What he's asking you to do is make a fundamental change that would protect the drug traffickers, the Mexican drug cartels that are flooding our state with fentanyl, and with the human traffickers that are following behind them. Those are the people, other than the hypothetical innocent owner, those are the only people that are protected by the changes proposed in House Bill 2380 that the committee hasn't already agreed to. With that, Mr. Chair, I'd be happy to stand for questions.
Certainly. A lot of comments and questions and thoughts come to mind as it relates to your opponent testimony that fell under the neutral category. But we'll cut you a break because you haven't been in front of a lot of committees to understand how this works, so it's all right. So first, I want to be really clear about something. Simply because the members of this committee are sitting here studying this topic and trying to find the correct balance between government overreach and individual liberty does not make a single person on this committee anti-law enforcement, okay? I have worked with nearly every one of the law enforcement men and women sitting in this audience. And if any single person, I challenge any single person to find a member of this committee that is anti-law enforcement, because they're not. What they are is trying to find the government's obligation and balance to government overreach versus individual liberty. And so that is really what we are seeking to do here. And I appreciate that. And I want to clarify that very clearly, because every one of us support law enforcement. We even have ex-law enforcement sitting on this committee. So I just want to get that out of the way.
Mr. Chair, you and I have talked about that before, and I agree with you. And I hope my passion about this issue doesn't give anybody an impression that I don't think that already.
Fair enough. I know this is a passionate topic, and I understand that, which is part of why I thought it was very important that we take it on and that we do so in a committee that looks at this from all angles and all perspectives. Because I also think it's safe to say that not everybody on this committee agrees with every single thing the proponents of change believe in either. Sure. So I also wanted to just clarify, this was an invitation-only committee. This was not open up to members of the public. I actually had a couple members of the public who wanted to testify here today, but we limited it to those because of the testimony that we've heard, the proponents, the opponents, the Judicial Council, and things like that, recognizing that if a bill were to be introduced, we would then have that public hearing, and I made sure that they would then have the opportunity to do so. You mentioned the seizure of drugs, and that sounds like an incredible seizure. And thank you guys, and thank all law enforcement for your work on that. I read about that, and I had a good feeling that you were at the heart of that, because I know how passionate you are about fighting fentanyl.
I wasn't, sir. It was the KBI agents that were at work in that case that were at the heart of it. But thank you.
Absolutely, and I understand that's what a good leader does. With that being said, can you share with me how the civil asset forfeiture laws that are on the books here or in Minnesota where changes have been made would have had any impact on that seizure?
I can't, because I don't want to go into details of that seizure, because it's something that we're still working on a daily basis. But I can talk with you about hypotheticals, and I'd be happy to do that.
Sure.
By the time you get to a seizure of that significant a quantity, you're dealing with organizations that are sophisticated enough to realize that they don't want property titled in their own names. They don't want vehicles titled in their own names. They want to use straw men, straw people to conduct those transactions. That's what we see on a regular basis when it comes to that kind of shipment. So trying to tie a conviction to someone who might have been driving a car that they didn't know contained drugs, for example, receiving a package that wasn't actually sent to them, they just wanted to send it somewhere else. Those kinds of situations, that's what we see sophisticated organizations doing. It's not just the sophisticated organizations that do that, though. I mean, you might see the leader of a drug organization in a particular municipality or a particular county who, by the time they've been through the system enough, they recognize that they don't want things titled in their own name. That's exactly what the civil asset forfeiture system was designed to help law enforcement address.
But say, hypothetically, civil asset forfeiture was eliminated today, it would not have stopped you from doing your job in making that seizure and arresting those people.
No, but it would potentially seriously inhibit us from doing the job that we're doing now. Now that we've made the seizure, we're trying to figure out who's in this organization, and we're going after them. And we're gonna try to intercept more shipments. We're gonna try to take their proceeds. We're gonna try to take their instrumentalities, and the civil asset forfeiture laws allow us to do that.
And absolutely, as you should. I totally agree. and I'm sorry that I'm hogging the microphone, but that's one of the privileges of being the chairman is you get to hog the microphone sometimes. So you guys hold on to your questions. The law that was sent out to us, KSA 60-4117, talks about the specific uses of the funds. And to be clear, for about 12 years, I sat on the Heart to Heart Child Advocacy Center board in Harvey County. Our child advocacy centers do a phenomenal job. And I saw year after year forfeiture funds supporting that agency. So there is no question in my mind that the funds that are received are going to a good purpose in various different aspects. But the very first line on here basically allows law enforcement to use it for anything. And it says, the support of investigations and operations that further the law enforcement agency's goals or missions. That is a very wide open door that says you can use it for whatever you like, right? And so when we talk about some of these great things that they do, there's absolutely no doubt, but they're not compelled to. There's no expectation that these seizure funds are going to be used for drug court or drug abuse related things or anything else. It is, in essence, what law enforcement deems is acceptable, which again, I just wanted to clarify that. Yeah, go right ahead.
There are some restrictions on that, even though that passage is broad. I don't believe the interpretation is nearly that broad, but I will candidly admit to you I wasn't prepared for that question. Sure. So let me go, I would welcome the opportunity to go back and do some research and figure out what cabins that. But I don't think it's unfettered discretion of the law of the agency head to spend the money on whatever they think they should spend it on.
Fair enough, fair enough. And I was just sharing that as amongst, there's so many pieces of what you shared that I just had little thoughts that are important that we address. Would changing, so in criminal court, and I'm not an attorney, I fancy myself an honorary attorney for being on judiciary for 5 years, just for the record. But I am not an attorney, but as I understand the criminal system, you have probable cause to issue a warrant, but then to prove guilt, you have a preponderance of the evidence. So you go from the lowest to the highest for a conviction. Is that correct?
Probable cause to issue a warrant or make an arrest beyond a reasonable doubt for conviction.
Beyond a reasonable doubt. Yep, I've got that one mixed up. So you go to lowest to highest. But in the civil side, we go, in essence, lowest to just the notch up. We go to preponderance of evidence. Do you feel going to the clear and convincing is going to limit your ability to do your job and to seize assets? And if so, to what extent?
I don't, practically speaking, I don't know how much of an impact it has. And there may be some value in the optics of doing it. I think really the issue that we talked about in the committee is consistency within the criminal, or the consistency within the civil code. And when you look for actions against property, preponderance is typically the burden of proof that's met under the civil code. And asset forfeiture falls clearly under the civil code. So from a pragmatic point of view, is it going to make a difference on a case-by-case basis whether the standard is preponderance or clear and convincing? I don't know that I can credibly tell you that it would, but there is a body of law out there about when it comes to actions against property, and preponderance is the standard.
Okay, very good. Thank you for that. And thank you, committee, for enduring my questions and comments. I do appreciate it. What questions and comments do you have for the director? Representative Carr.
Thank you, Mr. Chair. I just had a quick one. You referenced the statute that that gave a pass, if you will, for those family members that may have the. Could you or someone provide me with what that statute is and some explanation as to how that plays out and how that's effective? I'm certainly new to this committee, and I've always been told and heard otherwise. So I would like maybe one of the revisors to clarify that for us.
You want to take that one, Natalie?
Sure, I can kind of briefly go over that, and then I'm happy to sit down with Representative Carr to go over it kind of in more detail. My brief did kind of get into that, but KSA 60-4106 covers the exemptions. So that's going to be the list of what counts as something being exempt from asset forfeiture. And as Director Mativi stated, one of those is that the owner or interest holder did not know about the conduct giving rise to forfeiture and could not reasonably have been expected to know about the conduct giving rise to forfeiture. So usually the example we hear from that is kid takes grandma's car, kid is involved in some illegal activity, car is seized, grandma has no idea, grandma would be able to make that claim. Now, the process for doing that and getting the recognition of that exemption comes a little bit later, and that is outlined in both KSA 604110. That's where it talks about the recognition of the exemptions, and then you are going to be like making one of your claims, and that's covered by 604111, which we went into how that claim process works. And then, of course, that claimant does have a burden, again, by a preponderance of the evidence to show why their exemption should be recognized.
That answer your question, Representative?
Yes, it does. I have a follow-up question.
Sure.
So that claimant's ability to provide evidence that property is exempt would be the same proponent of evidence that needs to be provided in the actual asset forfeiture proceedings, correct?
Yes, and I want to find the exact provision here. It may take me a second, but any and all evidence is admissible at that time, and that is where you also get into that protection for your right against self-incrimination that you can put that in. But yes, you provide a description of the property, how you got the property, and why that exemption applies in this case.
And so then again, that procedure wouldn't be one that that would be done in a courtroom in front of a jury. That would be some other form of a procedure. Is that correct?
Mr. Chairman, it's done in a courtroom, but it's done just in front of a judge. So all of this is just determined by the court. There's no jury involved in these proceedings.
Thank you.
Certainly. Additional questions, committee? Or did you have something?
Well, I just want to answer Representative Carr. So the statutory mechanism is for that to happen in a courtroom in front of a judge as part of the proceeding. But I can tell you on a practical basis, the way that probably gets resolved is when the family member goes to the sheriff or the police chief and says, hey, look, this is the situation as it really exists. Under the forfeiture laws now, the department head has the ability to negotiate and settle with that person. And I can tell you that that's likely how that's going to get resolved, and it would never have to go to court.
Fair enough. Additional questions? Representative Lewis.
Thank you, Mr. Chair. I want to delve a little deeper into the difference between probable cause and preponderance of the evidence. I mean, probable cause suggests more likely than not, right? And preponderance of the evidence is the same standard. It's just a question of whether there is either ex parte proceeding or challenge proceeding. Am I accurate about that?
So I would struggle to articulate the legal difference between probable cause and preponderance of the evidence. That would fall to somebody who's a lot brighter and more articulate to me. To me, they're about the same. But there are ex parte proceedings, and probable cause is often provided at ex parte proceedings. Preponderance of the evidence is a standard that's applied by a judge or a jury. In this case, just a judge.
Thank you, Mr. Chair.
Additional questions, committee? Representative Mon.
Thank you, Director. First of all, I'd like to tell you that I agree with you that I don't think there's a widespread abuse of this law. And I also agree that the repository should be funded. And I think our Judicial Council Committee was maybe remiss in not adding that to our recommendations, and we should probably look at that here in the Legislature. But I do have questions. So I was looking at the 2022 report from the KBI about the totals that were seized and the totals that were forfeited. And it looks to me like it was about 4.6 million that was seized and about 3.45 million that was forfeited. So my question is, if the legislature simply funded the law enforcement agencies to the extent of the amounts that they're actually getting in these seizures, or would that resolve this issue? Because while I know you say that there's the hypothetical innocent owner, it's not so hypothetical when you're the innocent owner. And it does happen. And so my question is simply, if we just increased funding for law enforcement, would that meet your and your law enforcement brethren's concerns?
Well, as a preliminary matter, let me just mention that many of the departments, many of those 435 law enforcement agencies in the state of Kansas aren't funded by the legislature, right? If you're talking about giving the KBI more money for counter-drug efforts, I will take it.
But the legislature could fund some of the local agencies or set up some way to do that.
We would love to see additional funding, strengthened funding, augmented funding for law enforcement regardless of the mechanism, sir.
So if we did that, would that nullify the need for civil asset forfeiture?
It's a great question. I don't know. It might. Yeah. It seems like a slippery slope, though.
I do have a question about, it came to mind because of the example of the large bust in Wichita. That probably is going to be, whatever civil asset forfeitures occur in that are probably going to go through the federal government. Is that correct?
It's hard to say at this point. We've talked to both state and federal prosecutors. We're not sure which direction that case is going to go.
Okay. But the question that came to mind was, when the federal government does a civil asset forfeiture, what % of that comes back to the agencies of the states?
I can't answer that off the top of my head, sir. I'm sorry. I can get it for you.
Thank you, sir. That's all I have.
Anything else, committee? All right, seeing none. Director Mativi, thank you very much for being here.
Mr. Chair, could I give you follow-up on one question you asked?
Absolutely.
Thank you. I am tremendously fortunate to have at the KBI an attorney who really is a subject matter expert on civil asset forfeiture. While you and I were talking, she handed me a note that says the legal authority that cabins the ability of a department head to use asset forfeiture funds for any purpose is an Attorney General's opinion. It is 2007-15, and it says that asset forfeiture funds cannot be used for normal operational expenses in a law enforcement department.
All right, thank you
with that,
very much.
Mr. Chairman, thank you very much for your time. Thank you very much for the opportunity, the give and take, and thank you for your indulgence of my passion on this issue.
Absolutely, and rumor has it you guys stole that great attorney from the Highway Patrol.
I can neither confirm nor deny,
Just
sir.
saying, just saying. Thank you guys very much. Committee, John Goodyear, General Counsel with the League of Kansas Municipalities, introduced written only. We are at a point that we have a bit of a break, but we have a lot of people lined up still to speak. If anybody, I'll tell you what, if everybody's all right with it, let's just go ahead and keep rolling because we're behind schedule a little bit. If you need to step out for a restroom break, then by all means do that. But I would like to keep moving forward. So with that in mind, we have our opponents to changing the Kansas forfeiture laws, and we will start out with Colonel Eric Smith, Superintendent for the Kansas Highway Patrol, and welcome him to the committee.
Good afternoon, Chairman Owens, Vice Chair Warren, ladies and gentlemen of the committee. Thank you for taking the time to consider the viewpoints of the Kansas Highway Patrol as it relates to House Bill 2380 and the report of the Judicial Council's Civil Asset Forfeiture Advisory Committee. I appreciate the thoughtful consideration that you've given to those appearing before you today, and I trust that your continued deliberation will result in a balanced outcome for all Kansans. Kansans who trust that their leadership will continue to make public safety and anti-crime efforts a priority. I also want to echo the points of my colleague, KBI Director Tony Mativi, and underscore that his agency and mine are in lockstep, along with my colleagues from the other law enforcement associations represented here today, in our resolve to keep civil asset forfeiture alive and well, protecting the program while working double time to ensure that its efficacy, not only as a crime deterrence, but more importantly, as a remedy to repatriate ill-gotten gains. I want to note that I appear today as an opponent to the bill as originally drafted, but more of a proponent in support of the Judicial Council's report and recommendation. On balance, I have very little concern with embracing the recommendations made in that report. But before I address the recommendations themselves, I want to briefly comment on the remarks made on page 5 in the introduction, and I quote, "There is at least a perception among some members of the public that abuses are occurring." In my view, this perception is not supported by the data collected for the last 4 years. In fact, this body should be proud of the fact that it has in recent history continued to prioritize that balance between effectively disincentivizing the profiteering from illegal enterprise and the constitutional and property rights of Kansans. We need to make sure as both policymakers and as law enforcers that everything we do achieves the goal of changing that perception. In continuation of that priority, the advisory committee has recommended 8 reform measures that I believe continue to strike that balance. In the interest of time, I want to speak to just 2 of those recommendations. The first one is recommendation number 2 that's found on page 6 of the report, and it's captioned, "Making certain property ineligible for forfeiture." That essentially leaves open the question of setting a threshold value on cash or property before civil forfeiture is appropriate. The committee stopped short of setting that value, but noted that the estimated legal costs of contesting a forfeiture are roughly the same, $3,000, as the median value of those 2,000 seizures that were reported to the KBI repository. What that seemingly infers simply is that if the statute were to be amended to set a $3,000 threshold before forfeiture can commence, those undervalued assets are potentially returned back to a criminal enterprise. And the point that I'd like to underscore for each of you today as you consider what that threshold ultimately may be is really a question that I think you need to wrestle with. If those illicit proceeds are not forfeited to the government, where do they go? Drawing on my nearly or over 2 decades of experience at the U.S. Drug Enforcement Administration, I can tell you with certainty that the majority of those proceeds are ultimately funneled to 3 entities: the Sinaloa cartel, the CJNG cartel, or a Chinese criminal syndicate. Our neighboring government to the south is often influenced or corrupted by the power, persuasion, and the money of Sinaloa or CJNG. Our geopolitical foe in the Far East, the Chinese government, also is a recipient of some of those funds. Every dollar derived from drug trafficking, sex trafficking, indentured servitude, and the related money laundering schemes that this lowered threshold would return to those criminal enterprises is a dollar that we've allowed to fund those corrupt practices. Here's another take. If the average cost for a fentanyl-laced counterfeit pill on the street is $30, you're effectively exempting from forfeiture the profits from the first 100 pills sold. If an agency can link any amount of illicit proceed to a crime that serious, it should never be exempt. The next recommendation I want to address is recommendation number 8, which is found on page 9 of the report. And it's captioned fee shifting. And it creates the possibility that the seizing agency can be ordered to pay the claimant's attorney's fees. And while I'm generally neutral on that provision, because I believe in I am confident in the process, I believe in the process, I would ask that additional consideration be given to a recommendation that was previously submitted to the advisory committee by KHP's counsel. And that provision substantially mirrors the fee shifting scheme that's found in the federal civil asset forfeiture statute found at 28 United States Code 2465. I believe that doing so would provide a little bit clearer guidance to the courts that's not present in the current bill as drafted. Finally, there were 6 measures proposed in House Bill 2380 that the Advisory Committee does not recommend for reasons that I believe are clearly and articulately stated, and I strongly believe that the Advisory Committee reached the proper consensus in each of those recommendations, and I would urge this body to find itself also in concurrence. Again, this review process has found equity and fairness in the due process protections. And in terms of tackling a serious criminal justice problem facing us today, those measurements that are not recommended, I believe, would tilt the scales in an untenable balance. In conclusion, the Kansas Legislature and this committee have taken thoughtful steps to ensure the balance between law enforcement and our citizens is protected and trustworthy, both in 2018 with the passage of House Bill 2459 and now with the deliberations of the Judicial Council. I acknowledge their hard work, and I would strongly urge that this special committee seek outcomes that are consistent with those recommendations. Thank you, Mr. Chair, and I'm available to stand for questions.
Absolutely. Thank you, Colonel Smith. Appreciate you being here and sharing your thoughts. Committee questions for the Colonel. Representative Lewis.
Thank you, Mr. Chairman. You mentioned a federal law on fee shifting and how it differs, but you didn't explain how it differs from the state proposal, the proposal in the bill. Could you go into some detail on that?
Sure. I don't know how much detail I can go into. I would defer the intricacies of that answer probably to the attorneys. But just on a general level, I think what it does is give guidance to the courts on what to do and how far to go in terms of either capping or awarding fees when that sliding scale of preponderance of the evidence, which is razor thin already, shifts from the government back to the claimant. It's guidance that I think is not existent in the current draft.
Thank you.
Representative Mon.
Thank you for being here. I do have just a general law enforcement question. So when somebody's arrested, they're in a car and they've got drugs on them and a bunch of cash. Now the cash is evidence, right? So are the drugs. So those get seized regardless of the civil forfeiture procedure, right? So my question is, when you're talking about taking money away from the bad actors, and I'm all for that, I just, at what point is the seizure of evidence as opposed to civil asset forfeiture, where does that line cross? And I have some inkling of it, but you're the law enforcement professional, so I wanted to kind of give you the opportunity to kind of get into that a little bit.
Well, I think if I understand the question right, or as you're asking it, it really goes to the weight and the admissibility of the cash or the existence of a monetary instrument as evidence in the criminal case. Much like the drugs, while the drugs themselves are a nice prop to parade in front of a jury, the heart of the evidence really is the laboratory report. Similarly, a cash asset that is processed and seized civilly, the evidentiary value lies in the bank count.
But my understanding is ultimately those evidentiary seizures, especially if there is a conviction, aren't released without a court order anyway, right? So certainly the drugs will be destroyed, but if the cash is evidence and there is a conviction, my understanding is that without a court order, that money is not released. That's seized under criminal forfeiture rather than civil asset.
If a criminal indictment or a criminal forfeiture was sought, as opposed to a civil asset forfeiture. In the federal system, those can run in parallel tracks. I can't speak to the state system. I've been out of that for too long.
Okay. Thank you, sir.
Representative Carr.
Thank you, Mr. Chair. I have somewhat of a follow-up question to what my colleague asked. From a policing standpoint, at what point are the assets seized? Is there a certain dollar amount that's associated with a certain drug amount? I know one of the previous presenters had mentioned that they would like to seize amounts down as low as $250, and just doing some quick math in my head and thinking that with an average wage of only $20 an hour on a payday, if there was and I dare to say younger individual, but someone who was out enjoying recreational use of certain narcotics, and that was simply just the proceeds from a paycheck. Where do we make the distinction that we're going to seize this? Is it tied directly to an amount of actual drugs and a dollar, or where does that, from a policing standpoint?
So I have two answers to the question. The first one is, I think the heart of your question goes to a recommendation that I believe the Judicial Council adopted unanimously, and that is the elimination of simple possession as an underlying offense that would give rise to forfeiture. So I think that would answer or address that concern. The second answer that I have with respect to what is the dollar amount, that's a policy decision that's driven by each law enforcement agency head. The Kansas Highway Patrol has a threshold. They have two different thresholds. One threshold that's set if a dollar amount exists concurrent with a felony drug arrest, and then another higher dollar amount that exists absent the presence of drugs at the time of interaction. So a lower threshold if drugs are found, and a higher threshold if no drugs are found, but other probable cause exists to link it to a drug trafficking crime or any of the other various underlying offenses contemplated by the code.
Thank you. Thank you, Mr. Chair.
Certainly. Further questions? Yep, sure. Representative Mon.
If I could just, I know the Highway Patrol often, because of the I-70 corridors, will often pair with the federal agencies. So I was just going to ask, I asked the same question of the director of the KBI about, do you know when there's a federal seizure or forfeiture, how much of that goes back to the agencies?
Yes, the federal forfeiture, the AFMILS, and forgive me, the acronym escapes me, the Asset Forfeiture and Money Laundering Program at the Department of Justice authorizes up to 80% of a seized asset to be returned or equitably shared with a partner agency, either at the state or local level.
So up to 8%, and that's you guys, the state agency negotiates with the federal agency and decides how that's split, is that?
Essentially, sometimes those percentages are set per memorandum of agreement when a task force is set up. Sometimes those decisions are made based on the substantial contribution of a particular agency.
Okay. It's not necessarily pertinent to exactly what we're doing, but I was just interested to know. Thank you.
All right. Very good. Senator Warren.
Thank you, Mr. Chair, and thank you, Colonel, and for your law enforcement efforts as well. And since we heard that the vast majority of civil asset is begun on our highways and streets, and you being the superintendent of the Kansas Highway Patrol, I feel this question is best directed to you. Could you explain, when a taking occurs at a traffic stop without arrest, what does the officer in that situation, what kind of burden of proof are they held to, or what kind of assessment do they have to make to undertake that taking, again, during a traffic stop without arrest?
So there has to be a sufficient nexus between the money, the currency, the asset that's found and ultimately seized between the asset itself and a drug trafficking crime or another crime that's considered in the Forfeiture Act. The mere presence of money is in and of itself not enough. I can tell you just anecdotally that there are many times where currency is encountered, but there's insufficient evidence to link that currency to a crime, specifically a forfeiture-related crime, and that money is returned to from whom it was seized, and it drives back on down the road. So there has to be enough evidence to meet that reasonable suspicion or that probable cause standard for it to be seized to begin with.
So you've said reasonable suspicion and you've said probable cause, and those are two terms of art, and I think they mean different things. If I'm correct in that, Ms. Scott, that reasonable suspicion is different than probable cause, and which applies if you're an officer making a traffic stop and you're not going to make an arrest, but you're going to civilly seize the property that you've come across in your traffic stop.
Sure. Thank you, Mr. Chairman. So if you look at 604107, so subsection A provides for the scenario where a court actually goes through the process of issuing a seizure warrant, which of course is done on probable cause. And that's the first way that that property can be seized. But I think the scenario that you're talking about is going to be more under subsection B, which provides that property may be seized for forfeiture by a law enforcement officer without process on a probable cause to believe the property is subject to forfeiture under the Act. And that's all it says. So they need to have probable cause to believe that the property would be subject to forfeiture.
And that's in 604107D.
B is in boy.
B is in boy.
Mm-hmm. And that is a higher standard than reasonable suspicion. Like
probable cause.
Yep.
Okay. And as Representative Lewis asks, all of this is ex parte. The person who's having the property seized doesn't have any opportunity to put on argument otherwise during that traffic stop, other than make some statements, but they don't have counsel present. They don't have a third party adjudicating, is it proper to seize this at this traffic stop or not? It's completely the police officer making that determination.
The police officer in conjunction with their supervisor and perhaps their legal counsel, the agency's counsel.
But no third party, those are all on the law enforcement side, no third party adjudicator or court or, and then, is that correct?
That is correct. And forgive me, Madam Chair, as you noted, those terms are terms of art. And when it comes to probable cause or reasonable suspicion or preponderance of the evidence, much like the director from the KBI noted in his testimony, it's very hard roadside to distinguish the differences, and so I fall into that as well.
And yeah, it's a few minutes you're there or longer, and in the middle of a traffic stop, you're trying to first of all ensure everyone's safety. You're on the side of the road or whatnot, and you don't know as the officer who you're approaching or what scene you're approaching, and so those are decisions made on the spot. And if I may just clarify. There's been a lot of reference to the advisory committee's report. That was the advisory committee put together by the Kansas Judicial Council. And the report is not the report of the Kansas Judicial Council. The Kansas Judicial Council was very certain to make sure that the Kansas Judicial Council didn't make any recommendations that were contained in the report of the advisory committee, because it was too much, like I said before, discussion, and we didn't have an opportunity. We didn't have days and days to determine, well, which recommendations do we adopt, which don't we? So I want to make sure that the report is used accurately. It is not the report or the recommendation of the Kansas Judicial Council to adopt or to reject any of the recommendations of the report. It's simply the Kansas Judicial Council accepted the hard work of the committee and appreciated that they had worked hard on it, and we didn't come to a vote or any consensus other than the Kansas Judicial Council's position was it was received, it was accepted, but without recommendation. So I don't want it to be used other than as it came out of the Kansas Judicial Council as we discussed last Friday. So, thank you.
Thank you. Colonel, one last thought. One of the lines in your testimony really struck me. And it's one that you read under that recommendation number 2, but it says, if an agency can link an amount of illicit proceed to a crime that serious, it should never be exempt. And that's a statement I can absolutely agree with. Where I think we're trying to find the balance is, one, defining that link, because we have set that standard so low. The question is, for those folks that are just willingly giving up that money for whatever reason, does anybody fall in that category of having their assets taken when there is not truly a link? There's other factors. And then 2, a crime that's serious. How are we defining that? What is that crime? And have we set that standard too low? And so, yeah, I think that most everybody agrees that you know, if that tie is there, then it should absolutely be seized. It's just making sure that we have set the bar at an appropriate level to ensure that link is made and that crime is that serious. So I appreciate that. Certainly. Senator Warren.
Thank you, Mr. Chair. Brings up another question for me, and thank you, Colonel, for your indulgence. If we're talking about that there aren't that many innocent property owners involved in this system, which we've heard testimony from earlier today, that there are not that many innocent, and I thought everyone was innocent until proven guilty or proven liable. And we're so certain that the asset, the currency that's being seized is linked to a crime, why don't we just go ahead and prosecute these alleged criminals? Isn't that the best way to stop crime?
I think that there are circumstances where criminal prosecution is appropriate, but the decisions to prosecute don't lie with law enforcement, whereas the responsibility to initiate a forfeiture proceeding does begin with law enforcement. One of the probably one of the most predominant anecdotes that I've heard this afternoon in testimony has to do with this fact that only civil forfeiture can be used to forfeit property held in the names of third-party owners not convicted of a crime. One of the witnesses, I believe it was the KBI director, testified earlier about the fact that sophisticated criminal organizations are smart enough and sophisticated enough often to put property ownership in a third-party name. It's not that third party for which a criminal prosecution can be initiated, and only civil asset forfeiture can address properly that property itself.
And we don't have a prosecutor testifying today, so that's why I kind of directed the question to you, understanding that law enforcement doesn't initiate or file criminal charges. And but again, we don't have a prosecutor testifying here today, so just wanted to know your thoughts on it and appreciate that. Thank you, Colonel.
Certainly. And Mr. Chair, if I could just briefly follow up on the comment that you just made. I don't disagree with the statement that you made, and that's why I think that it's very important to both understand and draw the distinction between setting a threshold versus setting predicate offenses. It's in that provision where you articulate and delineate what the predicate offenses are, where you define the crimes that are that serious. And when you have those crimes that are that serious, you don't need that threshold.
Understood. Thank you for that.
Thank you.
Representative Carr.
Thank you, Mr. Chair. And not to belay this, but could you give us an example of what a traffic stop would look like where there would be a seizure of property and no arrest made?
Certainly. I can actually give you a few. So some of these are hypothetical and some of these are real instances. Roughly 5 years ago in western Kansas, Kansas Highway Patrol troopers stopped somebody who they believed was involved in interstate drug trafficking. In the trunk of his car, they found approximately $3.7 million in cash. In and of itself, that would be an instance where you would expect a criminal prosecution at some point to be initiated. However, he committed suicide at the scene of that traffic stop. No criminal prosecution. There are instances where assets are seized from somebody who criminal prosecution is initiated, but that that person becomes a fugitive from justice. So while a prosecution was initiated, no conviction was ever obtained. And the cost and the resources needed to house, store, and maintain assets, not necessarily cash, but assets, can become significantly burdensome and costly to the seizing agency. Another example, freight companies, the UPS, DHL, FedEx. Colloquially, in federal law enforcement anyway, we often called them some of the more significant transshipment organizations because drug traffickers, money laundering organizations, drug trafficking and other transnational criminal organizations use these common courier facilities to move bulk cash across the United States and out of the United States. If money was seized at a DHL facility or a FedEx facility, for example, it's not an officer or employee of FedEx or DHL that can be prosecuted. That money necessarily must be seized, forfeiture proceedings must commence, but there's not a person for which criminal evidence exists to initiate an arrest. We've talked, I think, enough about third-party owners. And then I think the last reason or example of where I think it might be appropriate would be in one of these instances where I just articulated evidence that might exist, but ultimately a prosecutor in a criminal setting might elect not to initiate a criminal prosecution. Perhaps the beyond a reasonable doubt standard might not be met, whereas the civil standard could be met. Perhaps money was seized from somebody who ultimately became a cooperating defendant who negotiated some type of immunity agreement. You wouldn't see a prosecution or an ensuing conviction from a cooperator, for example. So I think there are a variety of instances where civil asset forfeiture remains appropriate and a criminal prosecution may not be appropriate.
So we're not talking about a situation where it's just a random traffic stop and an officer believes that they smell marijuana and doing a subsequent pat down of the driver, they determine that a driver has what they consider an excessive amount of cash, and we understand already that amount can vary. Then in a situation like that, then that would not be a situation where a seizure of said property would take place.
In my experience, the answer is no. Do I think that that's the experience of others? Perhaps not. I think that's why the proportionality argument needs to be given due consideration, and also the recommendation, and I apologize if it's not an actual recommendation, but the discussion about removing simple possession crimes from the underlying offense.
Thank you. And thank you, Mr. Chair.
Absolutely. All right. Well, I think we've peppered you enough with questions. Colonel, I appreciate you being here and sharing your thoughts. We'll now move on to Lieutenant Colonel Eric Houston of the Overland Park Police Department. And welcome to the committee, sir.
Chair Owens and members of the special committee, thank you for allowing us to share our comments regarding the important issue you are considering. The city has provided written testimony that has already been provided to you, so I won't read it. However, there are some points that we want to emphasize. An important purpose of asset forfeiture is to remove the tools used by criminals to commit crimes and deprive wrongdoers of the proceeds of their crimes. If not seized, the property could be used to commit future crimes and/or be used by criminals in any manner they choose. Removing assets used by criminals already includes due process via the civil courts. Law enforcement must convince a district court judge the property was appropriately seized and subject to forfeiture, and anyone with a claim to the seized property has the ability to present evidence for the judge to consider making their decision. Legislation previously proposed requiring a criminal conviction for an asset forfeiture action. In addition to the comments and concerns in our written testimony, another complication to consider is when there are multiple defendants. Consider the scenario where where property of a criminal enterprise is seized from 3 or multiple people. Would all 3 require a conviction? And how would the property then be divided if only one was convicted, but the others took diversion or had another non-conviction disposition prior to their trial? These are reasons why we believe it would be better for this to be sorted by the civil court in a separate proceeding and not bound by that criminal conviction. Lastly, it is important to remember that asset forfeiture is not only used in controlled substance investigations. The current act allows forfeiture proceedings for several crimes, including but not limited to terrorism, human trafficking, mistreatment of a dependent adult, electronic solicitation, sexual exploitation of a child, theft, and several fraud-related crimes. Our city has experience with criminal organizations committing theft, something we call organized retail crime. And we have seen several recent crimes of violence committed by these ORC criminals, and we want to be able to have every tool possible to stop these crimes from happening and remove criminals from criminals any proceeds of their illegal acts. Today, there's been some comments and questions about the transparency of the purchases and the actions. I wanted to point out that we do quarterly reports to our city council on the any proceeds or expenditures of our state and federal forfeiture accounts. We also have a purchasing policy that the city must follow for all purchases, and we do follow it. And a couple of comments on that is that, first off, I can't, as the deputy chief, approve any type of expenditures from a forfeiture account. That has to be done only by the chief. And then we also have to follow the city's purchasing policy. And there are limits to that, and a certain threshold passes, the city council actually has to authorize that purchase. The other thing I wanted to point out is that there was a question about the family car, and I don't have a hypothetical example, I have a real life example of that situation, where our officers on the street had obviously plenty of probable cause to seize a vehicle that was used in distribution of drugs case. And we started the process to review that for that forfeiture, and our assistant city attorney quickly discovered that there was plenty of evidence and reason that this turned out to be that family car scenario, and so that was stopped immediately. There wasn't any further court proceedings, so we feel like we're making those good decisions as far as being reasonable when it comes to the family car type situation. And lastly, there was a comment about policing for profit, and one of the things that we do is we make sure that any of the expenditures that we use from forfeitures proceedings is that it's a one-time expenditure. So we're not looking at something that is something that we would expect or have to make an ongoing purchase for. It's a one-time purchase. So with that, again, thank you for your time today, and I'll stand for any questions that the committee may have.
Very good. Thank you, Lieutenant Colonel. Questions for Mr. Houston? Senator Warren.
Thank you, Mr. Chair. I don't have any questions, but just wanted to give a special shout out and thank you for coming today. I represent part of Overland Park where you're working, so appreciate you keeping our community safe. Thank you for your work.
Yes, thank you.
Excellent. Thank you very much, sir. I appreciate your time and your willingness to be here.
All right, thank you.
We'll now move on to Chief Darrell Atterbury, Bel Air Police Department, Legislative Committee Chair, Kansas Association of Chiefs of Police.
Hello, good morning.
Good to see you,
Thank
Chief.
you, Representative Warren or Owens and Ranking Member Warren. No? Assistant Chair. Vice Chair. Okay. I'll promote you. So I want to thank you for the opportunity to come and speak today on this topic. It's very clear from talking to Ed Klump and others that you put a lot of work into considering House Bill 2380. And that particular bill caused me a lot of heartburn as it was originally written. But after looking over the committee report, a lot of those concerns were allayed. I thought that the committee was very mindful about a lot of the things that they decided while they met, and we were very relieved that some of the things that we were concerned about were removed and removed from consideration. But one of the things we are concerned about is that 50% threshold. I've been in many court hearings where a judge has simply said, you know, I believe you're guilty, but today I'm going to find you not guilty. And, you know, you hate to hear something like that after you've put a lot of work into a case, but it's happened. And I have a concern that, you know, some judge might think, well, I think that property needs to be seized, but, you know, you have 4 kids and your wife's in the hospital. Okay, and that throws a burden on law enforcement to then shift, with that shift in who pays, we're on the hook. What we would like to see instead is if there is a finding of bad faith on the part of the law enforcement agency, throw the book at them, have them pay. But other than that, we're trying to do the job that the statute says we're supposed to do as it's written, not with this change, and we would like no change in that. The KECP would also support legislation to remove the simple possession. And we know that the committee has already given that due consideration, but Representative Carr brought up a question about if somebody stopped and we smell marijuana, we search the car, we find an amount of money and maybe some drugs, do we seize the drugs, the money, the car? And in most cases, that's no. And that is because we differentiate, in my organization and many of the organizations that I know of, we differentiate between a user and somebody who's in the distribution business. And that's transporting for sale, and with possession with intent to sell. That sometimes is a very small amount. And that's going to lead me to one of the other recommendations for minimum amounts. And that is that sometimes, and the chief for Chanute is here today with a couple of his department members, and he and I have conversed, and he's, as stated by KBI Director Mativi, they have done a lot of seizures. They have 4 dogs. They're the same size as my city, essentially. I do not have 4 dogs, but their environment is a little different than mine. And they do a lot of seizures. And the ability to take any amount that is for sale or distribution, even a very small amount, should be open to an asset forfeiture. Because as Chief Peffley pointed out to me, that sometimes you have the dealer, the distributor, and then you have a mule, somebody who takes it from one location to deliver it to a user over here. And that needs to be subject for seizure just like as if it was the dealer himself. So, and that's our opinion. And so we would ask that there be no minimum set, and if they are set, make them minimal. One of the other things that hasn't been talked about today is the cost to conduct an asset forfeiture from the agency standpoint. Well, if we have an attorney, like I'm a small agency, I don't have an attorney that would handle that. I would have to hire an attorney, probably pay them a percentage of whatever that was. But to file the notices and all the paperwork, it's going to be about $400, $500. So do I seize money below that or above that? That's a decision you have to make. But we would recommend not 1,000 or 2,500. We would recommend something lower than that because that's what we run into. A little personal experience that I had. Early in my career, I saw a car going the wrong way on a street. Had a temporary tag. I pulled the car over. Driver had warrants. He wanted the title out of the glove box of the car. So I'm looking for, he said it was in a bag, so I'm looking through bags, and I looked through a bag, I put it down, I looked through another bag, and I picked up the first bag, and it had 25 grams of cocaine, individually packaged. We seized that car, okay? what I'm saying is a lot of times the cases that we run into are purely by accident. If he had not wanted that title out of that glove box, I would not have known about those drugs. But because I did find it, we had a seizure. He had no money. He had just spent all of his money buying the car from the car lot, which he had gotten from the sale of narcotics. So I wanted to address a few other things that that we've heard today, and that is one about the Judge Sexton spoke about addicts. Well, we run into some addicts when we're on patrol on a local level because you've heard from Overland Park, you'll hear from me, you'll hear from the sheriff's office. We're not state organizations. And the drug court that was brought up and funding drug courts with the seizure funds, I have a municipal court, I don't have a drug court. So being able to fund a drug court, we would have to create a drug court to fund a drug court with any seizures that we made. The government's goal is to protect our communities, protect our citizens, and the people who are selling these drugs in our communities are hurting our children, our family members, friends of ours, especially with the epidemic sale of fentanyl in our communities. And yes, as the proponent said, we call them tools for our toolbox, but they are certainly tools for our toolbox because we need every tool we have to keep our community safe. And this is one of those tools that we can use to interrupt that flow of cash back into the drug trade. Specifically the drug trade. There are other things listed in the statute, but we primarily find people with drugs and selling drugs in our communities. So we want to be able to interrupt that. And if we have to take their money because we have probable cause to believe that they're transporting the money right next to the drugs that they're selling, we want that tool to be able to keep our community safe. The fee shifting, back to that, we don't believe that is something that we should see. But I wanted to add that with the safeguards that we have in place, personal opinion, I don't think we're going to see very much of that. I think that these cases are vetted so well before they're filed. They're examined by a detective, or by the initial officer, a detective, a review officer, or a supervisor, the prosecutor, before they ever get to a seizure proceeding. And we think that that's not really going to be a problem, although we object to that 50% threshold. And with that, I'll stand for questions.
Thank you, Chief. Appreciate that. Committee questions. Well, you got off pretty easy, sir.
That's because they did so well.
There you go. Appreciate your time. Thank you. All right, now we'll be pleased to hear from Lieutenant Jason Thompson, Newton Police Department, and the first Vice President of the Kansas Narcotics Association, Kansas Peace Officers Association. Welcome, sir.
Thank you. Good afternoon. I appreciate the opportunity to speak before you, and I want to first thank you for taking on the daunting task that you have in front of you for this. You might have been better served to pick the 4 playoff teams for the college football than this, and so we'll leave that for another debate. I've been given the opportunity to speak on behalf of the Kansas Narcotics Officers Association and the Kansas Peace Officers Association, and I kind of have a unique perspective in the fact that within my own agency, I kind of serve a dual role in the fact that I'm an administrator and command staff, but at the same time, I have the opportunity to go out and work the roadways and the highways. And I've been lucky to be part of small street level user arrests, all the way up to federal level cases. And so they do have a different perspective. And so, asset forfeiture funds are critical for the enforcement of those units that use those. And quite often, I know we've had a lot of testimony today about drug forfeiture and drug seizures and things like that, but there's a long list of crimes that forfeitures go along with, and those are things that these funds can be used for, whether it be human trafficking, sex trafficking, child sex crimes, computer crimes. All of those things are all funded by money, and the reasons they exist is because of money. Putting a monetary amount or a minimum amount on currency seizures or property kind of, I see, has a twofold effect. One, it educates those criminals that are doing these crimes to make sure they stay below that threshold. So if they are carrying currency or if they are driving a car at a certain value, and then where do we assess the value? Is it what they believe the property is valued at, or is it valued by someone else? And as you know, the majority of our state are small, rural police department, sheriff's offices that don't have the ability to have a budgeted item for investigations. Many departments don't have an investigations unit. Their investigations are handled by the very same officer wearing a uniform that takes that report. And being able to utilize those funds that are in that account. And I will go off of what Lieutenant Colonel Houston said, is those funds, as far as I know, in the agencies that I've spoke with, are only delved out in very specific reasons for very specific instances, and they are kept in their own line item in the budget. And again, in my agency, that approval can only come from the chief in what items can be purchased out of that. And secondly, with that, a lot of currency, you do still see bulk cash currency. That's not uncommon, but there's a lot of Cash App currency that's being transferred from one person to the next through Cash Apps. Reloadable debit cards, green dot cards, things like that. And with that is technology that you have to have the equipment available to you to download that information, download cell phones to get some of those things that you may need. And so, and as with technology, that changes very often, and so comes the need to upgrade that. One of the topics, and I'm not sure what has been addressed today, but I did see something that addressed roadside waivers and things like that to sign away property, if you will. And I think, and I don't know how much information or if it was misleading. In my experience, a lot of times, and the majority of those times, the roadside waivers are only used in those instances where somebody says, I don't know whose cash that is. I've never seen it. It's not mine. You probably better take it. It probably is illegal. And they have no ownership value in that, or they claim no ownership value in that. In that case, obviously a waiver is a paper trail to start that. I do believe it probably should still go through, the proper forfeiture proceedings to make sure that it's handled properly. But I don't know that, at least in my experience, I've never seen anybody on the side of the road offer a waiver for property in exchange for not being arrested or things like that. I just don't think that's not a good practice, and I've not seen that. We do, the KNOA and KPO, we do support the change in language from users to fall under forfeiture proceedings, things like that. And I think that may be where a lot of the information where it's being misused is because there's, a lot of users that may be subject to forfeiture and that may be inflating some of those numbers to make it appear that it's being misused and not being done correctly. And so we would support that. And then just to go with what Chief Atterbury had said earlier, the fee shifting, I think, has been talked about a number of times today. And I do think that that's, I don't know that that's a good practice in the aspect of you don't want certain places to shy away from following through with a forfeiture that is probably a good forfeiture in fear of having financial retribution if the forfeiture doesn't go their way. And there's many levels to a forfeiture, just as the chief said. Again, in my position, it's reviewed. It's reviewed again. It's then reviewed by the legal staff, whether it be the county or district attorney's office who does the forfeiture. If there's a private attorney's office that does those, they're often reviewed. And I would be, I don't know that the numbers exist, but I can assure you the number of property and currency that is either not seized during a traffic stop or that is actually returned during an investigation is probably outweighs the number that is actually seized. There's a number of instances where that reasonable suspicion or probable cause can't be reached, and oftentimes we know in the back of our head they got us that time, but not the next time. And so, there is times where that property and currency is just released because we don't have enough to do that. And so those are probably more often than not. So that's all I have. Again, thank you for your time, and I will stand for any questions.
Yeah, thank you very much, Jason. I really appreciate you being here. Jason's from my neck of the woods, down in Newton, and I could tell a real fun story about when he pulled over my wife about 10 years ago, but I won't.
She did keep her assets, though.
Yeah. The places I could go with that, but definitely won't when it comes to my wife's assets. Let's talk about the digital currency that you were referring to. So that's something that I haven't contemplated in this conversation. When I look at the data, especially the raw data, I see currency. How do you guys handle that digital currency piece? And how do you find that nexus, or even do you at this point?
Well, I don't know that finding the nexus requires anything more than what requires if you have a duffel bag of currency. You still have to establish that nexus. I think it comes through, if you get the ability to, if you have their cell phone, everybody has those apps on their cell phone, and that's why, being able to, seize their cell phone, get search warrants, get that data, additional search warrants for the different apps themselves. So establishing the nexus is not any different than if you had a stack of cash sitting right next to me here. That remains the same. It just requires a little bit more, investigative stuff, just as it would be obtaining the information. It does actually, it's essentially an electronic drug ledger. If you can look in there and see who they're obtaining the currency from, you can check those names and if they're likely not their real name, whatever their nickname that they're using is. And that type of stuff. So establishing that is the nexus is not that much. Obtaining that currency does take a little bit more steps if you do get forfeiture on that. The reloadable green dot cards, they make readers for those. You can scan them, see what's on those. Again, the nexus itself remains the same. You still have to make those ties together as to why that's illicit and why that's not. And so, so I'm sorry, go ahead.
No, you're good. I'm just thinking through this, right? Because obviously I want to make sure that those ill-gotten gains are able to be seized as well. And if we're talking earlier, we've talked about a lot of this happening on the roadside through traffic stops. Well, at a traffic stop, you wouldn't necessarily have access to somebody's cell phone. You would have to get a warrant and
sure, and that's where if you're talking about, most of those are through longer standing investigations, not necessarily the roadside. People will give you consent to look through their phone on the side of the road, so you have that opportunity. But again, if you just looked in a cash app and saw an amount of money, at that point, you'd really have to have a lot to go on that. With that, I'm thinking longer standing investigations, something like Director Mattivi had spoke about, that type of investigation therein. I'm certain there's probably some of that currency being transferred electronically back and forth. So on the side of the road, that's probably not applicable. We do see a lot of green dot cards, credit card, or not so much credit cards, but debit cards. You'll see a stack of those, and that's not common for people to carry. So you can check those. They do make roadside or in-car readers. People can carry those and see what information is on those and see the amounts that's on that as well.
All right. Well, thanks for sharing that. It's just a piece of this puzzle that I hadn't contemplated, which makes perfect sense. Additional questions, committee? All right. Thank you very much, sir. Appreciate you taking the time to come up here.
Thank you.
All right. Our final conferee that's listed is Sheriff Jeff Easter, Sedgwick County Sheriff, Legislative Committee Chair, Kansas Sheriff's Association. Sheriff Easter.
Good afternoon, committee members. I appreciate the opportunity to speak to you today on behalf of the Kansas Sheriff's Association. I'm not going to regurgitate a lot of what's been said. I will tell you that the work that the committee actually did to give you recommendations, I thought was fantastic work. There's no doubt there's two sides to this issue, okay? That's very clear. But I think there is some middle ground within what they have recommended to you all. Some of that middle ground, absolutely the possession of a controlled substance simply because you're in possession because if you're a user, I see no reason why that should still be included. The second topic is the firearms exemption language, the minimums. Agree with that as well. As you've heard from other conferees, the threshold of what that amount should be, I think that's more of a longer discussion because there is already some jurisdictions have those limits. I happen to reside in one of those. Some things that I do want to clear up though. I as an agency head cannot start the process of or be the one that says we're seizing this property, okay? We have to, in Sedgwick County, we come up with the paperwork, we come up with the probable cause statement, which is another thing that's a recommendation here. We give that to the DA's office. If the DA says no, we're done. If the DA says yes, it goes forward. He will not do anything that is less than $500. So we have those minimums with us. I'm not saying that applies for the rest of the state of Kansas, though, because every jurisdiction in the state of Kansas is dealing with these issues differently, okay? But I'm trying to give you, because of several questions that were presented, what happens in my jurisdiction. That is controlled by the DA's office. It is not controlled by me as the sheriff or anybody. We simply start the process of the probable cause affidavit. So those thresholds, that's another discussion. I'm not here to say what they should be set at or if there should even be any, but I recommend that there's more discussion on that particular topic. The next topic is the 14-day period to submit a request to the county or district attorney of jurisdiction. The time period currently is 45 days. I've talked to our narcotics officers or deputies, and we don't think that that is an overreach to have a probable cause affidavit simply saying that we are going to seek seizure on this particular item to the DA's office. Now, if the expectation is that the DA's office makes a decision within 14 days, that is no way, shape, or form will happen. In reference to some of the questions of why prosecution doesn't occur, I offer to you the other thing is not enough attorneys. Not enough defense attorneys, not enough prosecutors. I can tell you in our jurisdiction, there is thousands of cases that do not get prosecuted. There is probable cause to do it because they don't have the funding and they don't have the attorneys. And they're spending their money and their attorneys' times on violent crime. And so that is another reason sometimes you do not even get to criminal prosecution. The next thing is the 50% threshold for assessment. Several people have talked about that. We do strongly oppose that from the KSA aspect. You can read my rest of my testimony on that. There's been several things that have been touched on. We are generally talking about drug trafficking, but I do not want this committee to forget sexual exploitation of children. We are seizing property from people that take nude photographs of 8-year-olds and sell those over the internet. That also applies to this. So please remember that. The next thing that I'd like to talk about is there's been a lot of questions about what those standards are. We have two other sheriffs in the room, the current president and the president next year. We were having discussions about those agencies, and I believe there's two that are not in compliance. If they don't want to play by the rules, we as a KSA do not have any issues with implementing those rules to make them play by them, okay? So that is not an issue for us. I will tell you, I've been doing this kind of business since about 1994. So I've been involved in a lot of high-profile drug cases, seizures, led the RICO investigation that happened in the city of Wichita in 2007, which dealt with a lot of bad characters. And so I will tell you the standards, and some of you I've tested, this has been going on for 3 years, so I've testified in front of several of you during courses of this when different aspects of reform has been taking place. The standard that I set for our department or for the sheriff's office is the federal standard, period. Because there is open interpretation into the state standard. The federal standard requires us to only spend the money on a finite amount of things. That's anti-crime investigations, that's training, that's equipment to provide anti-crime initiatives, and community programs. We spend money every year on community programs, Big Brothers Big Sisters, Child Advocacy Center, other education. We've done a lot of education on fentanyl. Part of our asset forfeiture money helps fund that. And so my ask on that is if there needs to be clarification on that, I proposed this 2 years ago, look at the federal standards on what that money can be spent on. Because it is very finite, and it takes out this argument that we're misusing the funds. I don't believe any agency is misusing the funds, but it takes away that argument. The other thing that I will tell you in reference to, and trying to understand the language that the committee's used, what you guys are using today, the innocent party, in law enforcement terms, until today, what I'm hearing is an innocent party is people that have not been convicted. Innocent parties are your third parties. That's the folks that own the vehicle, that own the home, that it's in their name, and the drug user is using their property for their benefit. I can tell you by federal standards, we can't seize that property. It's a third party. That property is immediately given back. I can tell you that Mark Bennett in our jurisdiction immediately gives that property. Now, I will tell you that this has been going on since 1997 of me being involved in this. And here's what happened out of that. Every drug dealer in the city of Wichita realized if you register the car in somebody else's name, if I buy a home in somebody else's name, they're not seizing it. Don't get me wrong, they're still using it, but we're not seizing it, okay? And so that's what I look at as the innocent third parties. I now understand the terminology of innocent people because they have not been found guilty. I take a little bit of issue with that because, you know, we have a nation right now that wants to, everybody's a victim. Drug dealers and people who distribute child pornography are not victims. Some of the other things that I wanted to clear up with some of the questions that were asked. Weed and seed statement from the one conferee. I can tell you I was in charge of the weed and seed for the Wichita Police Department. It was a wonderful program. It did a lot of help to our Northeast community. That money was taken away by a president when they came into office. The statement was made, though, that strictly went to violent crime and not drug stuff. That is absolutely not true. Because part of the problem is that what's causing the violent crime is the drug crimes. We had a ton of citizens that were scared to death of these folks that, well, gang members for the most part, that were committing drive-by shootings and murders. Didn't want to talk to us. What's the other avenue to get at them? Their drug sales. We went after a lot of murderers with drug sales. And that freed up people to actually talk to us and tell us what happened in the murder, and we were able to get a conviction on that murder. So that's a misnomer. That's not true. The other statement that was made, we're not taking heroin anymore. Yes, we are. Absolutely, we are. The other fact of the matter is there's a lot of studies, or there's a lot of analysis being done in Colorado. I'm not trying to muddy the issue with marijuana, because that's a whole separate issue. But the argument to legalize marijuana in the state of Colorado was it was going to reduce heroin and opioid use. It's done the exact opposite. It's increased it. And there's studies on that as well. So heroin does still exist. Representative Carr, you asked a question about third party, not seize, given back. We don't even try to seize the vehicle. So hopefully I've giving you a little bit more information of at least how it works in the jurisdiction you live in. Representative Mon, you asked what happens that it's evidence. So for us, initially, we're making an arrest for a drug crime. That money is being seized as evidence in the crime, okay? The process for us is we don't keep large amounts of cash in our property and evidence room. So we make photocopies of it for evidence reasons. We then deposit that into a separate Sedgwick County account that's audited and all those type of things. At time of trial, we then produce that photocopy of the money and those type of things for trial. So it still exists as evidence. At the same time, after charging, and I will also tell you the DA's office, if there is somebody that needs to be charged and there's an asset, he will charge it because, let me rephrase this. You've heard several instances where there's times that money, there's nobody to charge a crime with. I would offer another one. The mules that are transporting the stuff back and forth. That's roadside stop. Deputies are asking them questions. One guy's telling us, oh, I'm going to Houston. The other guy says, oh, I'm going to Tennessee, because we separate them. And then by all those stories, you figure out you have enough probable cause to take a look in that vehicle. We locate money. Both of them say, not mine, not my car. We seize that money, and then we go through the process. Most of what you see of the folks that don't show back up, I can tell you drug dealers are not going to show back up to claim that money because they're afraid of being charged if they haven't been already. And so at the same time, we can start the civil process procedure, which you've heard all about, the arguments on whether it's the right thing, the right way to do it, or it's not the right way to do it. I'm not going to sit here and talk about that even more than what's already occurred. But I just wanted to clear up that it is evidence, but we can start the civil asset forfeiture procedure at that time. So with that, I will end at this point and take any questions that you might have, and thank you for your work on this.
Yeah. Thank you, Sheriff Easter. Appreciate you making the trip up here for us today. Committee questions for the sheriff. Representative Mon and then Representative Carr.
Well, seeing as the chairman and vice chairman both welcome folks from their jurisdiction, I thought it important to say thank you and acknowledge not only from Sedgwick County, but my neck of the woods in Sedgwick County as well. So thank you. But I do have a kind of a broad question for you and for any of the other conferees. You mentioned that all the jurisdictions handle these matters differently, and I understand a big jurisdiction like yours has much more tightly held rules. Should we be working more on trying to make that uniform about how different jurisdictions handle these things? I mean, if there's no, if each entity is kind of doing it, I don't want to say making it up, that's not the right phraseology, but kind of coming up with their own terminology of how, or way of dealing with these matters. Should we be working more on trying to make that uniform? And it's not just for you, Sheriff, but if any of the other conferees want to answer that as well, I'd be just interested.
Yeah, so thank you for the question. You know, the issue is more than just us. You're going to have to get district attorneys from across the state or county attorneys across the state to come in and talk about that because they're the initiating people. And in our jurisdiction, everything is initiated through the DA's office. So being a bigger jurisdiction, I don't think that that is the level that everybody else should be at. So there is differences. And I understand the differences, as we've talked about in Bourbon County, and what they face. So that's not something that I'm comfortable saying, oh, yeah, it should be standard across the board, because every part of Kansas is different. I think if you want to get to that point, you need to have district attorneys from across the state come in and talk about how they handle these things, and then if there's a happy medium that the attorneys can come up with, then that's the standard you use. And that's what we would have, the rules that we'd have to play by.
Representative Carr.
Thank you, Mr. Chair. Like my colleagues, I would like to shout out my sheriff, Sheriff Easter, and I just appreciate the passion at which you do your job. It's kind of refreshing to see that that you approach it in the fashion that you do, and that you've been at it for such a long time. You know, we have a little history that goes back quite a ways, and I'd just like to take a moment and say thank you for the job you're doing.
Thank you, sir. I appreciate that.
Certainly. Further questions, committee? Or comments or accolades or anything else, you know, good opportunity to do so. Well, thank you all very much. We really appreciate every one of the conferees on all sides of this issue, those that have studied it and spent so much time on it. And now we'll go into some deliberations, but first I do want to go ahead and take maybe a 10-minute break. It's 3:50. If we come back here and begin at 4 o'clock for our discussion and recommendations, we'll be right on time. So let's go ahead and be in recess until 4 o'clock. Thank you. We're now at that part of the committee where we have discussion and recommendations from within our committee. And so I'm going to go ahead and start this off. You know, I really appreciate the work that the subcommittee did, and I think that anytime we have consensus between all parties, then those are recommendations that we should have a conversation about and consider moving forward. And so I'm going to work to begin with just first off of the Judicial County Subcommittee report on the reform measures recommended by committee. And that first recommendation, deleting certain crimes from the list of covered offenses and conduct. That is a recommendation that I would like to see this committee make a recommendation to the legislature that we adopt in the Civil Asset Forfeiture Code. Is there discussion about that recommendation? Senator Warren.
Thank you, Mr. Chair. I have a question. 3 of the recommendations from that advisory committee were unanimous. And was this one of those 3? It's hard to tell.
So I wrote down, yeah.
Oh, I see. It says the committee agreed unanimously.
Yeah, and I wrote down, I believe I had 4 that were written down as unanimous consent, but we can definitely look at that. But yeah, this one was unanimous. Instead of doing a motion and a second and discussion and all that, I'm just going to go about, we'll make the recommendation, and then I'll ask, we'll discuss it, and then I will ask if there's any opposition to it. And if there is opposition, we'll go ahead and go to a vote. So on this item of deleting certain crimes from the list of covered offenses and conduct, is there any opposition to making that recommendation? Seeing none, we'll go ahead and add that to our recommendations for the committee. As far as the list, what I've done is I've just pulled back up the Judicial Council's report, and I'm working through that.
The Judicial Council's
The Judicial County Advisory Committee, Subcommittee, Reporting Committee, yes. The other, let's see, I'm going to flip over here. Yes.
I cannot find this report.
Okay. You want to, yeah, Judge Sexton's report. We'll have Natalie come over.
In the list of testimony under agenda for the committee, agendas and minutes.
Natalie's going to come behind you and help you find that. Yeah, let's go ahead and get everything pulled up here before we continue. You're perfectly fine. We want to make sure everybody's on the same page. Very good. We're just waiting on Senator Wilburn. Yes. Or Senator Mon.
So while I voted for this in the advisory subcommittee, and I have no real objection to it now, I just would like to note that, we have heard testimony from law enforcement that some of the items that we would be eliminated from the list of crimes that are available for forfeiture. It might be a bit broad, but we can bring it up when we actually deal with it in the various committees, and I just...
Yeah, absolutely, and this I think is, we don't have to drill down to the finite detail on these because we'll work on the revisor with that. I think that the piece within that report is kind of the recommendation that we will take the verbiage of and then move over into our recommendation report. At least that's what I would envision that the revisers and our legislative research colleagues would utilize. Is that fair? Natalie, go ahead.
Thanks, Mr. Chair, and I'm sure you guys already saw this, but if you look at the kind of end of the Judicial Council report, you'll actually see a revisor draft. Like Judge Sexton mentioned, Jason Thompson was working with the subcommittee, and so a lot of those recommendations, I think maybe even all of them, are, you can see
Yes.
what the statutory language would be in the bill draft there. So
Excellent. That's perfect. Yep. Yes, as proposed by the subcommittee. All right. Let me go back up here. The other one that I believe was unanimous consent was the seizing agency must return property if timelines are not met. I believe that was one of our. You're on page 7. Seizing agency must return property if timelines are not met. Committee agreed with this provision in 2380. Is there further discussion around that recommendation by this subcommittee? Is there any objection to adopting that recommendation? Seeing none, we'll add that to the report. Another one was prohibiting the pre-forfeiture waivers of rights to property, the roadside waivers as they were referred to, is another recommendation that I would like to put forward that was unanimously agreed to by the subcommittee. Is there discussion about that recommendation? Is there objection to that recommendation? I am on page 7, the end of 7, beginning of 8. Prohibiting pre-forfeiture waivers of rights in property. Further discussion, question? Representative Mon?
It's not a question on this. I was just wondering if we jumped over some of the recommendations. We had deleting certain crimes from the list of covered offenses, and then there was also making certain property ineligible. Is that just one that wasn't
So
unanimous?
yeah, fair enough. What I'm working through are the unanimous consent items first,
Okay.
because I think those will be the quicker ones to roll through. And then circle back to some of those other recommendations for further discussion.
Absolutely.
On the prohibiting pre-forfeiture waivers and rights to property as recommended by the subcommittee, is there objection to adopting that unanimous recommendation? All right, seeing none, we'll add that one to the report. It was the end of page 7, prohibiting pre-forfeiture waivers, the roadside waiver. And then I believe the other unanimous consent item was proportionality. I am looking that one up. Yeah, top of page 9. Said the committee unanimously recommends the language in section 5 HB 2380 providing that at any time following the seizure, the person for whom the property was seized may petition the court for a hearing to determine whether the seizure is constitutionally excessive. Is there further discussion on proportionality? Is there any objection to adding proportionality? Senator Warren.
Thank you, Mr. Chair. No objection. The advisory committee talked about they couldn't agree on the burden of proof for the proportionality hearing, which I guess we're not deciding right now either. We're just saying that a proportionality hearing may be requested at any time. Thank you.
Yep. Thank you very much. Further discussion? Objection? Let's get that one added to the report as well. Let's move to the one right above it, because I believe that's all we had as far as unanimous consent. And let's discuss the early probable cause hearing. It said one of the committee's recommendations in 2017, which passed into law in 2018, was the requirement for an affidavit to be sent with notice of pending forfeiture. I'm reading down here. Let's see, the committee has now taken the idea one step further by upgrading the description of essential facts to an affidavit describing the probable cause supporting forfeiture. The affidavit, which used to be provided only to the claimant, now must be filed with the court. So before, if I remember correctly, and Natalie, correct me if I'm wrong, under current law, the whoever is claiming to own the property or defend the property had to request the probable cause hearing. And under this recommendation, it will immediately be filed with the court. Am I understanding that one correctly?
So if you look, if you kind of scroll down, these changes are in section 5 of the draft, which is on page 26 of the Judicial Council report. So right now, that forfeiture proceeding is commenced by filing that notice of a pending forfeiture. And so this would add the requirement that along with that notice, that affidavit describing the probable cause has to actually be filed at that time with the court. And then if you go down further into that, that's talking about the filing fee. Down in paragraph 5, when you have that notice again, that again, that's just the requirement that the affidavit be filed with that notice. So I don't think there's anything about the actual requesting of the affidavit. I'm not sure under current law if they have to make that request, I assume, because I don't know how else they would get that affidavit without making a request. Is that what you're asking? How else the court would get the affidavit?
Yeah, I'm trying to make sure that I understand the early probable cause hearing recommendation here because,
Mr. Chairman.
Representative Mon.
And those of you who were on the subcommittee, correct me if I'm misstating this, and including some of the conferees. But my understanding was that currently the claimant, or that there has to be a request for a probable cause hearing, but this change would make a probable cause hearing mandatory immediately, kind of like getting a warrant, an arrest warrant or a search warrant, and then taking it to the judge and saying, here's the evidence, or here's our probable cause affidavit and statement, and then the judge would decide, okay, is this sufficient or not? It doesn't change the ability for a further probable cause hearing at the request of the claimant later on. And I think that's where we weren't unanimous, is that there was some discussion about, well, what's the point? If you've already had a probable cause hearing, why would you still have another opportunity to have one? But it is different when it's basically an affidavit presented to a judge with no one there advocating on behalf of the claimant. It's kind of like an arrest warrant. The only person there is law enforcement saying, Judge, here's the probable cause affidavit. And then you get to have a prelim later on. So I think that's kind of where this was kind of going.
And that's the recommendation that, as I understood it as well, I want to make sure that is clearly put into our report, that is the recommendation. I mean, I'm assuming the wording here, and Jason has that correct, but we're kind of reading it on the fly. And us making recommendations here, again, it's more the intent versus the perfected language. We'll have them perfect that later. But that is what you shared was my understanding as well. Senator Warren.
Thank you, Mr. Chair. Generally, or maybe not, in interim committees, we make recommendations, but you just said to have the revise or perfect language. Are you proposing that we're having a bill created as a result of this interim committee?
No, I am proposing that should the recommendation be used to have legislation drafted, that at that time it would be perfected.
Right, that's what I was thinking the process would be,
Got
too.
it.
Thank you.
Sorry. No problem. Representative Osman.
Thank you, Mr. Chairman. So while I agree with the early probable cause hearing and I support it, so I don't have an objection to it, but I do have concern. It's the same concern I think that Representative Mon brought up, which is this is going to take place so early in the process that there won't necessarily be an attorney present. There won't necessarily be a secondary side to the argument. And so it'll be like a grand jury hearing where effectively everyone gets indicted because there's only one side being presented. So I think that this is a necessary feature to it, but my concern again is just that will this actually bring out anything that will cause the situation to be not probable cause heard during this process, because we're only going to get one side of the argument.
Fair, but none of this also, as mentioned, prohibits the individual from bringing up and having that representation in an additional hearing.
Yes.
So, yeah. Senator Warren?
Thank you, Mr. Chair. At the probable cause hearing, though, the claimant isn't present and isn't represented and has no opportunity to present their side, correct?
I believe as it is now, that is correct.
And that's our recommendation per usual probable cause hearings? They're ex parte, meaning the claimant isn't present, the defendant isn't present, and that would continue with our recommendation as well. You request it, but a probable cause hearing, you don't have, or do you have an opportunity to be heard if you're the claimant?
How about we ask Natalie?
Well, so the language that you guys are talking about would be on page 26 of the report. And again, this could be, change. You can make whatever kind of recommendation you want, but this is how it's envisioned right now. So that affidavit has to be filed, and then it says after an affidavit is filed, further proceedings shall be had only after a judge of the district court has determined from the affidavit that there is probable cause to believe that the property is subject to forfeiture. It doesn't mention the claimant necessarily being present or having counsel there, but it also doesn't seem to preclude it. So I wasn't really, present at those meetings, so I don't know if maybe Representative Mon or Representative Osmond has insight as to whether they talked about that or not, but.
So I think as I'm understanding this, current law says, forfeiture shall be commenced by filing a notice of pending forfeiture in the judicial forfeiture action. This is adding another step to that, saying that, okay, an affidavit is then also filed and there is a judge reviewing that probable cause. It's that added step in that process that the committee recommends. Representative Mon?
That was my understanding, and that this doesn't preclude the claimant from having another hearing later on with counsel or with them present. My only real concern about it is, once the judge has made a decision on probable cause, are they really going to change their mind later on? But that's only my concern as after practicing for 25 years.
Representative Lewis and then Resman.
As I understand the change which I support, it would insert a judicial officer in the process.
Right.
And it would be similar to a prosecutor going and seeking an arrest warrant or a search warrant. You go to the judge ex parte, the judge makes a determination, and I can tell you from my experience that, judges do deny requests from prosecutors from time to time on probable cause determination. So I don't think it's a rubber stamp.
Very good. Further discussion, committee. Representative Resman.
Thank you, Mr. Chairman. Well, I can tell you that it is not rubber stamped because I've been denied search warrants before because public cause wasn't there, but or it didn't meet a standard. would it be, I guess, a little different if the probable cause hearing was held, that a different judge would then hear the case if it went further, so that there wouldn't be any prejudgment on it?
I think the challenge you run into there is the limited number of judges in our judicial districts.
I figured that. Okay, all right.
Further discussion on this topic? Is there objection to this recommendation? All right, no objection, we'll get that added. Now we'll get into some that aren't maybe quite as unanimous in consent. And one of those that I particularly like, because when we originally heard this bill, this was one of my concerns to begin with, and that is the automatic stay of discovery. And while it was recommended by the committee, it wasn't unanimous. But as I understand it, under current law, there is a stay that can exist if requested during the criminal proceeding for the civil proceeding, but this would actually make that automatic. And so I'm going to see if we can scroll down to Section 7 of the proposed legislation. Because what it should do is to make it an automatic stay of discovery in the civil forfeiture case during a related criminal proceeding alleging the same conduct. Whereas right now that has to be requested. This would make it automatic. It's one of the concerns that I've always had about civil asset forfeiture is, the idea that assets are taken before a criminal proceeding is completed. It's always been one of my concerns, if there is a criminal proceeding. And this at least puts an automatic stay on that if there is a concurrent criminal proceeding occurring. So I would like to put forth that recommendation and further discussion on that recommendation. Representative Carr.
So to be clear, this puts a stay on the actual forfeiture of the property prior to what might be the criminal charge or the official civil procedure.
Right. So yes, it does. If there is charges filed where there is a concurrent criminal proceeding alleging a criminal conduct and the asset is tied to that, it puts a stay on that civil process pending the outcome. Now, it doesn't say even if the outcome is, that they're found not guilty or that the charges are dismissed, that they can't proceed with the civil hearing. But what it does is it says that at least during that time that there is an automatic stay on the discovery of the civil forfeiture case during that criminal proceeding.
Thank you.
Mm-hmm. Senator Warren or Representative Mon, whichever one of you would like to.
So to answer Representative Carr's question, so in the civil case, obviously, it's not a criminal case, so the claimant is subject to discovery requirements and to have to answer questions and things, which might, if they're also a criminal defendant, might impact their Fifth Amendment right to remain silent. And so the idea is that let's not subject them to that sort of discovery process where they may have to answer questions while the criminal case is still pending. So if that answers the questions.
Very good. Representative Lewis.
So I understand the concern about Fifth Amendment rights. I appreciate that. And although this idea isn't fully developed, but I'm just wondering, right now it's discretionary, the stay the judge can be asked for it and deny it. And I'm just wondering, a criminal process could take, by the time you do your appeal, it could take 5-6 years. And is that going to then undermine the civil process for forfeiture? And I just wonder if it's not wiser to leave that kind of balancing to the judge that's being that's being asked to grant the stay rather than impose it as automatic. pursuant to law. I raise that as a question more than an argument at this point.
And I certainly think that's a fair question. Committee, do you have comments or thoughts on that question? Representative Mon.
Yeah, I would just point out that the recommendation also included that the stay could be lifted upon good cause shown, and so it might address.
That's a good point. Yeah.
Excellent. Senator Warren.
Thank you, Mr. Chair. Was there any discussion regarding in the advisory committee that you have an automatic stay of discovery, but that doesn't necessarily automatically stay the entire proceedings? So was there any discussion, why not just stay the whole civil asset forfeiture proceeding? Because if a claimant's kind of forfeiting things anyway, and a claimant has an obligation to request discovery from the state because it's not a criminal case where the prosecution has a duty to disclose exculpatory evidence, and the claimant isn't asking for discovery, then okay, you've stayed discovery, but do we need to distinguish, it stays the whole proceeding, or is the stay of discovery enough? I don't know if there was discussion or not about that.
Representative Osmond.
Thank you, Mr. Chairman. I think that there was discussion. I don't want to put words in people's mouths, but I think that the general idea was, what do we do with the property during that time period? How do we store it? What's going on? And and being able to link it back up. There were just some logistic aspects to not to holding that for that period of time without any rectification on the property itself.
Representative Mon.
I think another discussion point that we had was, first of all, the stay only goes into effect if a claim has been made, and as we've seen, the vast majority of the time, claims aren't made in a timely manner. So it's only if I'm saying, okay, I want to contest this, and then not being forced to give a deposition that might be in violation of your Fifth Amendment rights. So for the most part, this won't stay the entire proceedings. Most of the time, people aren't making claims, especially if they have been charged, because they don't want to go say, yes, that was mine. And so I understand your concerns, Senator Warren, but I don't think it's going to affect that many cases.
Additional discussion on this topic. Representative Lewis.
Maybe I misunderstood, but I assume that if you don't have discovery, the case is stayed effectively. No? Am I mistaken about that?
Yes, if you're not having discovery, the case would be effectively stayed, but the case would only be started if you've made a claim. And there's a time window to do that.
I see.
And as we had testimony today, the vast majority of folks don't make a claim. And so it would only affect a fairly small number of cases. So.
Okay. Thank you.
Additional discussion or questions? Is there objection by the committee to having this added to our recommendation? All right, seeing none, we'll have that added to our recommendation. Let me get back up here to where I was at. And what I'm doing, as I mentioned, is kind of running through all of the committee recommendations. And I believe that there are two more that we haven't discussed. The next recommendation is fee shifting. It says the committee agrees to one final concept in 2380, which is fee shifting. The committee recommends a new section establishing that the seizing agency can be ordered to pay a prevailing claimant's attorney fees. And I believe that there are some pretty specific requirements in which this occurs. Let's see, the committee's proposed fee shifting provision now puts the possibility in play that the seizing agency as well. Seizing agencies will need to take, let's see. You know where that's at in the actual legislation? Or
Yes.
proposed language, excuse me.
Yeah, Mr. Chairman, it's in section 8, which starts on page 37 of the report, but the big changes start on page 39 of the report.
Let's take a look at that language. Let's see, so it was simply at, let's see, it says, nothing in this subsection shall affect whether a claimant is entitled to payment of attorney fees, litigation costs, and interest pursuant to subsection F. And then it says the court may, take shall out of there, may order the claimant who fails to establish, a substantial portion of the claimant's interest is exempt. But the added language is to, in any proceeding in which the court finds a claimant has prevailed by ordering the return of at least half of the aggregate value of the claimant's interest in the property or currency in which the claimant asserted an interest, the court shall order the seizing agency to pay reasonable attorney fees, post-judgment, so forth and so on. So discussion about that. Representative Lewis.
I do object to this. I think it's going to substantially diminish the ability of law enforcement to seize properly seize property that should be seized. I agree with one of the conferees that suggested there should be a provision that says if the court finds that the plaintiff, the government, was acting in bad faith, that then there should be fee splitting. But short of that, I don't think we should be fee splitting.
Okay. Additional discussion? Committee. Representative Mon.
So, again, I'm not sure this will actually change much because it's there as a fail-safe to stop claiming agencies from running roughshod over the claimants. The fact is, it's just a check because, first of all, the court would have to find that 50% of the claimant's property needs to be returned and that the claimant substantially prevailed. It's a pause for the agency to think about whether they really want to go ahead and file this forfeiture and to decide whether it's worth the risk of maybe having to pay attorney fees to the claimant. So it's just an extra check and balance, and I know it wasn't a unanimous decision in the advisory committee, but it does cause a little pause if you're the seizing agency to say, okay, do I really have the evidence here before I go forward? And so I think it's a good provision.
Okay. Further discussion, committee. Well, since we had an Senator Warren, do you have some? Since we have an objection to this one, I want to go ahead and we'll take just a voice vote. All those in favor of adding the fee shifting provision to our recommendation, say aye.
Aye.
Opposed, no?
No.
All right, the ayes appear to have it. The ayes do have it. We'll get that one added as well. The last one in the recommendation committee, or in the recommendation from the subcommittee, was one that we've talked about pretty extensively, and it appears that the committee recommends but left blank. And so let's have a discussion about this piece of making certain property ineligible for forfeiture, or what is being referred to as a minimum. I would like to know committee's thoughts on this particular item. Making certain property ineligible for forfeiture or setting the minimum. It seems like the recommendation, again, not unanimous from the committee, was that there should be a minimum set, but they weren't going to tell us what that minimum was. Discussion committee on this topic. Representative Lewis.
So I'd make 2 points. I object to it for 2 reasons. One is I think that the agencies involved are going to be self-policing here. If they're going to get, $200 from a forfeiture, they're not likely to expend the resources to do that. And number two, as one of the conferees said, the criminals are going to know what the threshold is, and they're going to structure their criminal activity to avoid seizure.
Representative Carr.
Thank you, Mr. Chair. To my colleague in the House's point, if in fact that is true, and the criminals would then be certain that they would only have amounts, for instance, of cash that were below the threshold, then by that same justification, any amount that you found above that threshold, that would be someone who had no idea what the law was, and therefore they weren't trying to do what needed to be done to be under the threshold. Follow me?
Senator Warren, or Wilburn, excuse me.
Yeah, thank you, Mr. Chairman. Obviously, this is a guessing game. We know where we're at. Maybe we could leave it the way it is and let the committee, when they meet, if you're to take this bill up, and maybe have some little bit more empirical evidence or empirical data to support a number. Otherwise, we're just guessing.
And I certainly, again, I'm going to leave it up to the will of the committee on whether we move this one forward or not. I wanted to bring it up because it was a recommendation of the subcommittee. And so I hear what you're saying. Certainly don't have any objection to that idea either. But if there is objection, Senator, we'll just continue to discuss it here. Senator Haley.
Well, I have no objection to Senator Wilburn, the Vice Chair of the Senate Judiciary Committee, on where I sit either. However, during the special committee, the discussion for a threshold did go around because you look at the minimus rule. How much will someone be able to recover? As we know, there are very small cases or small dollar amounts, currency especially, where potentially innocent parties won't bother to fight it because they can't afford counsel, and for various reasons won't. So, and that those are a large percentage. I don't know, we've heard $3,000 or less. I'm not going to throw out those figures because that's what we're discussing. And so I've always wanted to share that. So when this topic is discussed in committee, our colleagues have a framework of understanding of what I hope we're trying to mitigate, and that is the small fish or the consequences that come of those particular matters. And what is that dollar figure? We've had the privilege here of good testimony for what those averages are and what they range from. But just so we'll have that discussion was why I had hoped that the task force would have made a recommendation, which it opted not to, and certainly now here we are. But what the will of this committee is fine, but I know it's going to come up again, and it may bog down what could be a streamlined discussion for everything else we've agreed to.
Understood. I do think that, we did hear that median number was 3,000. And it's important to understand the median number means half were below that and half were above that in terms of the dollar amount of seizures. The data does exist out there. I was able to pull some of it in its raw form and just not be able to manipulate the data quickly enough to see some of the forfeiture numbers. But I remember one was as low as $86. There were a number of them under the $500 mark, which that only resonates because it was mentioned by Sheriff Easter, and that is their own threshold in that county. And that doesn't, like he mentioned, doesn't mean that that's good for all counties. But I think it was good to know that there is some self-policing as far as that number goes. But there was, I won't say it was the majority, but there was a decent percentage that were below, I think there were 20 or so last year that were below $100. We don't, like I said, we don't necessarily have to. We can move forward with a recommendation, leaving those blank, and then request research to provide and kind of break that data out for us in our committees, assuming the recommendation moves forward, assuming a bill is introduced, and assuming a bill actually has a hearing. There's a lot of assumptions in there. But with that in mind, what is the will of the committee? Senator Warren?
Thank you, Mr. Chair. Just a clarification, House Bill 2380 is still active in committee. It wasn't because it's still active this term for a hearing in the House.
Very true.
So, okay. Thank you.
Well, and I do want to, it actually already had a hearing in House Judiciary Committee. So, and then it was blessed by being moved to appropriations. And
right. So it's still alive and could have another hearing or just be worked. Yep. Thank you.
Representative Mon.
You know, this threshold, I understand why it was an issue, mainly because, you know, you've got lots of folks who have seizures. If you seize $1,000 from me, yeah, that's going to hurt me, but it's probably not. I'm still going to pay my rent. If you seize $1,000 from other people, they may not be able to pay the rent. So that was the idea, but frankly, I don't think it's really going to be effective because the idea was, well, if it costs X amount to challenge one of these in court, most people are just going to go, well, it's going to cost more than the amount they seize, so I'm going to leave it alone. I do dispute the Institute of Justice's estimate that it would cost an average of $3 or $3,000 to hire an attorney. I think it's way above that. And so whatever this threshold is, if we're going to give effect to the intent of this threshold idea, the threshold would have to be so high, and I know law enforcement would not support that, and it would probably hurt their law enforcement abilities. So this, in theory, I was supportive of this, except that I don't think it's workable. I think things like fee shifting and maybe the raising of the burden of proof will do much more towards making civil asset forfeiture more fair than doing something like this, because you're not hiring an attorney to go to court for $3,000. It's just not going to happen.
Well, then let me ask the question, is there, as it relates to this topic, a recommendation from this committee, or do we not want to have a recommendation on this particular item? Senator Warren.
Thank you, Mr. Chair. Just wanted to follow up on the representative's comment that, you know, if you're not going to hire an attorney for a $3,000 seizure, it kind of begs the question, then the process is the punishment. The process of having to be involved in the process is difficult. So as we're trying to balance, you know, law enforcement tools and law enforcement needs and constitutional rights and fairness, and it just kind of begs the question, it seems the process is the punishment if people are just going to wave their hands in and give up on the smaller amount of the claims because it's too expensive to go fight for your private property. Thank you, Mr. Chair.
Mm-hmm. Further discussion on this topic? Do we have a recommendation from a committee member as it relates to this topic? Senator Warren, or Wilburn.
As you know, thank you, Mr. Chairman. As you know, I'm pretty bold. I recommend this as a no-go.
Okay. We got a first and a second. All right, well, now we have a third. So does anybody object to not recommending this item, and do we want to bring it for a vote, or do we just want to let this one go? Well, how about we'll just bring it to a vote. All in favor of not making a recommendation on this item, say aye. Aye. Opposed, no? No. Okay, the ayes appear to have it. So we will not have a recommendation on a minimum threshold or making certain property ineligible for forfeiture. All right, committee, I have done a fair amount of talking. I would like to hear other recommendations from members of this committee. Representative Osman.
Thank you, Mr. Chairman. So I sat on the committee for the Kansas Judicial Council's Special Committee on Civil Asset Forfeiture with a number of people on this committee here, as well as quite a number of people in the audience here today. First of all, I want to echo the previous comments that the Honorable Judge Sexton did a fantastic job, what we've described as herding cats. There were quite a number of opinions across the spectrum, and he did an admirable job mediating all of that. I also want to thank Nancy Strauss, who's the executive director of the KGC, for synthesizing all of it, but also putting together a committee that had a wide spectrum of opinions, and it could have very easily been one that you had just one side of the argument, but we actually got quite a number of it, and it was great sitting with members of law enforcement, hearing their side and coming to compromises on really significant and complex issues. Things that we've discussed tonight, as well as like the fee shifting, prohibiting pre-forfeiture waivers on rights of property. There's a lot that, frankly, if we were to just rubber stamp the committee's recommendations, that would be a significant change in Kansas law on civil asset forfeiture. And I would be one of the first to say, let's go ahead and that I would support something like that. And it would also, honestly, it would also be easy as well. We had law enforcement there, and I don't think that we'd have as significant objections were we to go ahead and do that. But I don't think that we necessarily need to take the easy route. And as I take off my compromise committee hat and put on my legislator hat, there are quite a number of other things that we could be doing that we couldn't get agreement in the committee, but we as legislators certainly could do. And I would be remiss if I didn't explore those. Things like where funds go and it going to the state general fund. And yeah, there's a public perception of policing for profit, and we can, deal with that, but it's beyond that. That's money that's coming from a person. It's property that is coming from a person, and they're not line items on a budgetary spreadsheet. And if we wanted to discuss that these are taking funds from law enforcement, that is taking budget from the law enforcement, we can discuss that at a later point in time. We can address any budgetary concerns, but that's wholly separate from what we're discussing here today. And I think that it should go to the state general fund. Frankly, I even think that on a separate topic, we could be discussing criminal asset forfeiture as opposed to just civil asset forfeiture, criminal conviction for seizures, which would also include a right to an attorney. There are budgetary issues and there are rights issues, and I look to 1963's Gideon v. Wainwright, where the Supreme Court came down with a fundamental right to an attorney in a criminal case. And in that particular case, there wasn't the question of where do we get the attorneys? Who pays for it? Those are problems that can be solved at a later point in time. Just like here, that is a problem that we can deal with at a later point in time, but it's wholly separate from the constitutional violations that might be occurring. And so we should be addressing that part. The standard of proof where, on the one hand, we try to deal with criminal beyond a reasonable doubt. That rightly may have gone nowhere, but there's clear and convincing evidence as a standard of proof that I believe 14 states have applied already and is continuing to increase. And I think that is something that we can address here as well today. One last thing, prohibiting federal adoptions of seizures. That was something that was addressed in the committee. It didn't get the votes to pass, but having federal adoptions of a seizure means that you do an end run around the seizure at the state level. And I think that we need to address that if we're going to be addressing civil asset forfeiture here in the state, so that we can merge the two together and deal with it holistically. So all that being said, that there's a lot more than just the committee. The committee's report is fantastic. What we did was fantastic. I believe we can do more.
Well, if you're ready to make recommendations and have the discussion, that's why we're here. The subcommittee report was a starting point of things that consensus was found on, and that's why I wanted to start there with those items. If they found consensus, I'm glad that on most of those items we found consensus as well, but that is by no means the limitation. Each member of this committee can make a recommendation, can defend their recommendation, and we can put it up for unanimous consent or a vote. So if you have some of those items that you would like to make a recommendation on for further discussion, then let's move forward with that.
All right, well, let's start, I would say, with the standard of proof. I think that the standard of proof should be at clear and convincing evidence.
Very good. Committee, discussion on Representative Osmond's recommendation to recommend to the legislature that we move to a clear and convincing evidence instead of a preponderance of evidence. Representative Mon.
As some will know, my preferred burden of proof is beyond a reasonable doubt, but I don't think there's going to be any sufficient appetite to accept that. So I support Representative Osmond's recommendation for increasing the burden of proof. I do think we need to identify what that means, and because there are burdens of proof that shift. Once there's I think that the recommendation would be that the state will need to prove by clear and convincing evidence that the property is either fruits or instrumentalities of a crime, and then it shifts to the claimant to prove that they may be an innocent claimant. But I do not support the increase in the burden of proof on the claimant, just the burden of proof on the state to show that the property was, in fact, fruits or instrumentalities of crime. I also, this issue for me, I know folks will disagree with me and they'll say, no, this is just an in-rem proceeding, it's just about the property. But there is necessarily a accusation that a crime was committed, and then we're going to take somebody's property from them, and without necessarily proving that the crime was actually committed beyond a reasonable doubt. And it just doesn't sit well with me. I think my libertarian tendencies kind of get in the way of my conservative tendencies sometimes. And this is one of those instances where I say, look, we should at least prove that a crime was committed beyond just probable cause or preponderance of the evidence, which is, 50% plus a little tiny bit. I think we should at least go further than that before we take people's property. My position on this stuff is that property is liberty. If I've taken my time and my effort and my energy to earn things to get and then buy a property or and then you take that from me, you may as well have taken the time and energy and life force that I put into acquiring that property. So for me, property is liberty, and when we just take it away so lightly, it doesn't sit well with me.
Representative Carr.
Thank you, Mr. Chair. I would like to echo the sentiments of my colleague from Wichita, and I would also like to ask, and possibly I need some clarification, because this is somewhat confusing to me with respect to, again, how we could take someone's property and in essence, find someone guilty based on just the fact that they might be, without it being beyond reasonable doubt. So I'm looking for the separation between the reasonable doubt and whatever the next highest, what are we calling that? Yeah, clear and convincing. What is, I mean, if it's clear and convincing, then clearly there's no reasonable doubt in my mind. If it's that clear, otherwise it's not clear at all. So what are the defining factors? What's that defining point? Because I would hate for there to be clear and convincing evidence that I did not commit a crime, and then someone say, yeah, but yeah, you still got to go to jail, buddy, because it's not beyond a reasonable doubt.
And I think it's important to understand we're not talking about an individual. We're talking about the burden of proof for the asset, for the civil asset.
And I understand that, Mr. Chair. However, again, I will have to side with my colleague from my city that that is my liberty. That it may be property to you, but for me and my hard work, that's a part of my life that someone is arbitrarily taken away because, yeah, it might have been involved.
I totally understand. I just wanted to be clear on the difference between the civil and the criminal side. Do you want to take a shot at the differences between the preponderance of evidence and clear and convincing?
Sure. I'll try. It's been a while since I've been in the prosecutorial realm, but preponderance of the evidence, I would say as just 50 point. If you were to put a percentage on it, 50.1% of the evidence supports one way versus the other. So it's just like tipping the scale just slightly to one side. Clear and convincing is a substantial preponderance of the evidence. It is a substantial amount. Again, if you were to put a percentage, you probably say 70 to 80%, likely on one side versus the other. And then beyond a reasonable doubt is the criminal side. And I mean, 95 to 99% likely. I mean, somebody else can weigh in, but I would say that's generally what we're looking at as far as standards go.
So when we're counting a percentage, is that percentage of people who testified, percentage of the scale? So who's got the scale? Can I borrow the scale?
The judge has the scales.
So the judge has the scale. And does anyone else have access to the scale?
There's no jury.
Make me understand.
Yeah, there's no jury in the civil side. The criminal side, there's jury. There's no jury in the civil side. So it is ultimately the judge who is either elected or appointed that is called to make that decision, whether it's a preponderance of evidence or it's 51%, or we jump up to that 70 to 80%, or that 95+%. In a civil case, that is in the civil asset forfeiture world, that is the judge's decision to make.
Thank you.
If I might.
Sorry, trying to get power before my computer dies. Sometimes it is, except for when you're trying to balance out the committee. Yeah. I'm going to encroach on, could you pick that up for me? I'm going to encroach on Senator Warren's space here and shift off over here. Thank you. I think my Mac is even telling me it's getting tired. Okay, so we have the recommendation. Representative Lewis.
I just point out that the consequence of civil asset forfeiture on the person is not nearly as drastic as the consequence of a criminal conviction. A criminal conviction could, in some instances, require prison time. You're going to have a conviction on your record if your assets are seized. As far as I know, that's not something that's going to burden you going forward in terms of your record. And I'd also point out that preponderance of the evidence is the standard used in virtually all civil proceedings. The only exception I'm aware of is, at least in the federal civil proceedings, you have to prove fraud by clear and convincing evidence. But I haven't been convinced that sort of the presumptive normal civil burden of proof shouldn't pertain. I don't know why this should be an exception to the rule.
Representative Mon.
Clear and convincing is also used when removing a child from the home. But I understand what Representative Lewis is saying about, well, generally all civil cases are preponderance of the evidence. But in this case, in these type of cases, where there is an accusation that somebody committed a crime, I think that makes a difference between simply saying, hey, you breached the contract and now I'm going to sue you. There is a difference because the state is accusing, and I understand what the opposition says. They say, no, it's just the property. But there has to be an accusation that somebody committed a crime in order for us to get there. So I think it does make a difference, and this should be a higher burden of proof than simply, hey, you breached the contract, so I'm going to sue you for some money. So, and in my opinion, but I understand where you're coming from.
So Representative Osmond, just to clarify, because there was some changes, and I want to make sure that you're okay with that. So what Representative Mon mentioned was that clear and convincing applied to the state, but preponderance of evidence still applied to the claimant if they're trying to claim it. Is that your intention, or did you want to move both pieces of that to clear and convincing?
So I'm sorry, just to clarify. So no, I think that what I'm looking at is that the state has that burden of clear and convincing evidence. So that's certainly the recommendation. What was the other part of it that we're looking at? I'm sorry.
If the individual claiming they own the assets argues that it shouldn't be seized, then they only have to have the burden of proof at preponderance of evidence still. Right, am I understanding that correctly? Representative Mon can explain it way better.
Sort of. The first step is the state has to bear their burden of proof that this property was fruits or instrumentalities of the crime. If they meet that, the claimant that can then try to prove innocent possession, right, and say, well, yeah, maybe it was fruits and instrumentalities, but my dumb kid took the car and went to go sell drugs in it, and I didn't know anything about it, and it's my car, and I didn't approve of that. And so that they have a burden of proof at that point as well to show that that they are an innocent claimant. That's the part I wanted to make a differentiation between the state proving or the claiming agency proving that this was fruits and instrumentalities of the crime at the higher level, and then the claimant gets the lower level to prove that they were an innocent claimant.
Thank you very much for that clarification. Yes, I agree that this level of burden of proof should be for the state level, not for any ancillary defenses that come on the claimant's part.
Okay. Thank you. I just wanted to clarify and make sure we're on the same page with that. Further discussion on this topic, committee? All right, is there any objection to Representative Osmond's recommendation?
I object.
Okay, then let's go ahead. If there's no further discussion, we'll go ahead and put it to a vote, just so we're clear on that then. On Representative Osmond's recommendation, all in favor say aye. No, hold on. Sure. The motion is that we move to a clear and convincing burden of proof when it comes to the state that is attempting to seize the asset. That increases the standard above a preponderance of evidence to clear and convincing, but only for the state. It stays the same for somebody claiming the immunity side on the back end, which is a preponderance of evidence, but it just increases that burden of proof for the state. Yep, absolutely. Let me repeat that. So all in favor of the Osmond recommendation say aye. Opposed, no?
No.
The ayes have it. We will add that recommendation. Additional recommendations, committee. It's still early. It's only 5:12. Are there additional recommendations that we would like to bring forward or discuss at this time? Going once?
I mean,
Good.
I know that hours like that.
We were only given one day. They didn't say it was an 8-hour day. So we'll be here as long as we need to hash out this conversation.
Thank you. Let's talk about the last part, which is federal adoption of seizures. Now, I don't want to stop the federal government from getting involved, but I want to, I don't know quite how to phrase it, but I want to make sure that the federal government, should they be called in on a state level seizure, have still the same requirements and burdens that a state level seizing agency would have, or a county level seizing agency would have. Everything that's applicable within the recommendations that we're making would be applicable for any federal seizures as well, so that you're not getting around a seizure at by shifting it over to the federal level.
I understand your intent. I'm just not sure we can tell the federal government what to do if they take over that seizure. I mean, please, somebody correct me if I'm wrong. You guys went to law school. Senator Warren.
Thank you, Mr. Chair. Correct me if I'm wrong, but I think other states have something in place that puts thresholds of some sort on whether there can be federal adoption of this, or there's some examples in other states I think we heard about, if I'm remembering earlier testimony, that there is a process, a procedure to put in place to address the issue brought up by Representative Osman.
Yeah, I believe CSG might have talked about one of those options. So if we can roll back. If you go ahead, Senator Warren.
Correct me if I'm wrong. I think there's some language in House Bill 2380 on page 14 that talks about that. Do I have that right?
Yes, thank you, Mr. Chairman. So House Bill 2380 would have prohibited federal adoption, and let me find what page number in that bill. So it would have been on page 8 of House Bill 2380. And the new language there would have said that no law enforcement agency shall request federal adoption of a seizure pursuant to this act. So that would have been a clear ban on, are you looking at 2380? On page 8 of 2380.
Is that section 4 of 2380?
Yes, it is, yeah.
And looking through CSG's report, I do see Ohio barred the transfer of seized property valued at under $100,000 to the federal government. I believe one of the other states had it at $50,000. So there was a threshold put on there for transfer from state to federal. Again, I don't know what your intentions are. It's your recommendation. So we will leave that up to your recommendation and further discussion, Representative Osman.
Yeah, I mean, so as I look, I introduced a piece of legislation, one of the previous terms, it's HB 2640, and in it was listed the language itself says a law enforcement agency shall not, and one of them includes transfer property that was seized or forfeited under state law to a federal agency. So that's how it was written in there, and I would be happy to support that as a recommendation.
Well, I think that's different than what we were talking about, though, because you're talking about transferring something that has already been through the seizure process in state, is the way that I understood what you said. And what we have been at least discussing is the transfer of the actual civil asset forfeiture process from a state agency to the federal agency?
It can be one or either. I mean, I understand there might be a differentiation, but in terms of either the property itself being that has been seized, or calling in a federal agency to assist with the seizure as an end run around any current state laws. So to help, say the Kansas Highway Patrol were to call in a federal agency in order to help with that seizure, and then they would not be bound by current Kansas state law. So I'm looking at a way that if we can, federal agencies are then bound by Kansas state law, if that is even a possibility. But alternatively, that the property itself can't then be moved over to a federal state agency in order to again move past Kansas law.
Senator Wilburn.
Thank you again, Mr. Chairman. I sure don't intend to be a wet blanket. I like your thought process, but I do believe that this could be recommended in committee as a item to discuss in the regular hearing. In other words, along with the limits and other things. This debate here is very worthy of debate, but federal involvement could be a section that we'd like to discuss further.
And I would, at least the way that I'm understanding, the way that we're kind of putting this together is we either make a recommendation or we don't. So we're either going to recommend this topic and word it in a way that it is a recommendation that X happens, or recommend that it is further discussed. And I will again leave that up to the maker of the recommendation to clarify what that recommendation would look like, or, a counter proposal if he's in agreement. So I guess the question is the committee going to make the recommendation that there are no transfers, or make the recommendation that this topic is discussed further in committee if a bill is introduced?
Thank you. For the purposes of time, and I realize that there's a lot of complex issues that can be involved both in this and other proposals, I would accept that as an alternate proposal, that we make a recommendation to at least have that as a discussionary item within the committee.
Fair enough. Representative Resman.
Thank you, Mr. Chairman. I just have a question. So on page 8, where that in the law enforcement agency shall request federal adoption. So that would prevent, if it's multi-jurisdictional or multi-state, will that prevent Kansas from being involved in that?
Well, I'm not sure how 2380 is. As it relates to this recommendation, the recommendation that we're discussing right now is simply that if a bill is introduced, we would recommend it. Do you want to chime in on 2380 specifically and answer his question, Natalie?
Mr. Chairman, with respect to the language in House Bill 2380, the only thing that's prohibited is for the local law enforcement office to request federal adoption. So and this is my understanding, certainly some of the conferees could correct me if I'm wrong, but it wouldn't prohibit like interstate cooperation in those investigations or the federal task forces. They just can't formally request. They would have to handle the forfeiture themselves. They wouldn't be able to request that the federal government take over the forfeiture proceedings.
I understand what you're saying. So the recommendation on the table really is what Senator Rick Warburn recommended. Did we blow something up, or? Senator Wilburn recommended that would recommend that the committee discuss this topic if and when legislation is introduced. Is there any objection to that recommendation? All right, there is not. The recommendation that has been put forth is that if and when a bill is introduced, that the committee consider or have a discussion around the transfer of state to federal. So there's no recommendation that they do anything. It's a recommendation that they just consider it. Just a discussion. Senator Warren.
Thank you, Mr. Chair. Point of clarification, there is a bill that has been introduced that addresses this, and it's House Bill 2380, and it's still alive.
You're right. Fair enough.
How we want to talk about that?
Nope, you're absolutely right, and I appreciate that clarification because I forget that we have a biennium and things continue. But certainly a new bill could be introduced, but assuming that there is a discussion, we recommend that they discuss it. I don't know. What do you got? What was your wording, Senator Wilburn? Microphone, please. Natalie, do you want to help us?
Thank you, Mr. Chairman. I don't think it's necessary to get into the intricacies of how you want it to be done, whether you want, House Bill 2380 to continue to be worked or a new bill to be introduced. I mean, if it is your intention to actually make a recommendation that a bill be introduced, that would be a different discussion. But I think for purposes of a recommendation, you can just say that whatever standing committee is looking into this issue, that they have a discussion about federal adoption and federal transfer of
There we go. I like it. Thank you. Is there objection to that wording? Sometimes you just need the reviser to sort it all out for you, and that's, well, yeah, right. We would be in deep trouble without our research and our revisers. Okay, there's no objection to that one being introduced, committee. Additional topics of recommendation, and while I realize the hour is late, the reality is this is a topic that has been going on year after year after year, and if there's one thing I've learned, it's that if we don't take the adequate time to make recommendations, then when we get to committee and we have hearings, it's a lot more challenging to work on these issues sometimes. So let's continue to charge forward. If there are additional recommendations, I don't want anybody not to have that discussion here, because that is the sole intent of our work, just in the name of time. Of course, if there is not further recommendations, then that's fine as well. But I just want everybody to understand why we were called here today, and I don't want to cut that short. Senator Warren.
Thank you, Mr. Chair. There were a couple of other items that were contained within House Bill 2380, and we also heard conferee testimony on, one of them was a right to a jury trial, one of them was a right to counsel, one of them was where does the forfeited assets, do they go to SGF? Do they go to the city council if it's the police that do the forfeiting or the seizing, I guess? Is it the county commissioners if it's the sheriff? So that there's an elected body that is accountable to others, to their constituents, and they can, reappropriate it right back, but just maybe would help on that funding issue. We heard the appearance of impropriety, policing for profit, and maybe it would help with that. So I didn't know if those items were things the committee wanted for further discussion by the standing committees that might consider this or not, but just didn't want to forget those topics that were brought up today.
I understand completely. Do you have a recommendation as it relates to those topics?
Oh, I can think about one, but I don't have one at this minute, but just wanted to open it up for discussion.
I understand. Are there further discussion or further recommendations for this committee to make? Representative Bond.
So to address Senator Warren's point, as a catch-all recommendation, we could simply recommend that any standing committee considering this issue address or review the advisory committee's report and consider the advisory committee's report in their discussions. I don't know how that works, but
well, and my assumption would be that certainly they would. The committee's committee chairman, whoever, well, we know where that will fall, Vice Chairman Mon, would be able to ensure that occurs if this bill is brought back up or a new bill is introduced. Yes, Senator Warren.
Maybe the recommendation is that a standing committee discuss the issue of a right to a jury trial, a right to counsel, or where the assets that are forfeited, whether they're, I don't know what the right word is, sent to SGF, City Council, County Commission, what's the verb I'm looking for? Whether they're, because there was a proposal in 2380 about it, which is why I think it might still be relevant for discussion if this is brought up again in a standing committee. Transferred, yes.
Yeah,
Is
or
that the?
directed, I think is
Directed.
maybe what the statutory, House Bill 2380 just sent all the proceeds and assets to the state general fund. So that was a pretty simple in terms of statutory language. So I think what you would want them to discuss is like where those proceeds should be directed after they're forfeited.
Yes, where they're directed. So if that's the right verb we're
So
looking for.
is it fair to say the committee makes no recommendation, but it encourages consideration on the right to a jury trial, right to counsel, and the direction of the proceeds, or the direction of the assets seized?
Of the assets forfeited.
Assets forfeited.
Right. I think that captures it, but.
I mean, that way, we're not specifically, we're recognizing it, but we're not making a recommendation as a body. We're just encouraging the committee to consider it.
Right, I wouldn't want a standing committee when they say, oh, well, the interim committee looked at it and they're, stood mute on these issues that might need some further discussion when we're not making recommendations today. Thank you.
So does that, did that catch your three items? The committee makes no recommendation, but encourages consideration on right to a jury trial, right to counsel, and direction of assets forfeited.
I think so. I think that does. Yes, thank you.
Absolutely, just trying to get that wording right. Is there any objection to that language being added to our report? All right, seeing no objection, are there any other items that need brought before the committee? All right, seeing none, I will thank everyone in the committee. I know the hour is long and many of us have a long drive home, but I am certainly grateful for everybody that took the time to be here, everybody that took the time to testify, our research, our IT, our revisers, our law enforcement men and women. Grateful for all of them and all that they do. Senator Warren?
Can I add a quick thank you, ditto to that, and want to also thank the senators who were present here today, along with the representatives, but Senator Wilborn, Senator Bowers, and Senator Haley and I, the four of us constitute almost half of the Senate Judiciary Committee. So I'm glad that we were here to personally participate in the discussion, and as the standing committee that might be working on this issue, we'll have good input to make. So thank you, Mr. Chair, for a well-run day. We appreciate it.
Thank you. And with that, we will be adjourned. Safe travels home, everyone.